Māori tapu te Māori te whiwhia te Māori no whea te Māori no runga no rangi no nukatu. Tēnei te Māori ka whakapiki, tēnei te Māori ka whakakake. Te Māori o ngā riki, te Māori o ngā tipua, te Māori e rangi ka whakaheia ki runga ki enei taura, enei tauira, enei rua nuku, enei rua hine ki aputa ki te whaiau ki te ao mārama. A tēnā e rangi whakamaua ki a tīnā, tīnā hui e, nā iki e.
Tēnā koe te pāpai te whakatūwhero tō tātou nohoanga i te ata nei, ki a koutou katoa, nau mai, hoki mai ki te rōpu whakamaniti te riti o Waitangi. Good morning and welcome back to this urgent inquiry. Just before we hear from the first witness, are there any preliminary matters that we need to address?
No, sir. I'll shortly send around a list of order for cross-examination of Ms Marsh, which we're just finalising, but aside from that, we're smooth sailing today by all accounts.
Thank you, Mr. Lau. Mr. Siliano.
Tēnā koe te kaiwhakawa o te rā, tēnā koutou, te rōpū whakamano o te tiriti o Waitangi. Nei rā te mihi nunui ki ngā kai kereme, me ngā tāngata whenua o tēnei rohe. Ai ki oku hoa, ngā roia, tēnā rā tātou. Sir, as you rightly note, we have a further witness this morning, and the witness to call is for Rangitane Tūmaira Trust, one of the interested parties in this proceeding. I call Mr Crisp. Sir, Mr Crisp's evidence is document A21. And just while you locate that, I just note as well, sir, obviously you did not hear from me yesterday in opening remarks. There were joint submissions filed on behalf of the Rangitane Tūmaira Trust and other interested parties, and those are at 3.3005 on the record of inquiry. So just taking those as read and noting that they're there. Tēnā koe, Mr Crisp. You have your proof of evidence in front of you, and before we start, I'd just like you to confirm that that is true and correct to the best of your knowledge and belief.
Yes.
That is your proof of evidence dated 7 August. Tēnā koe. And I understand you'd like to take your evidence as read, but just have some opening remarks, if that's all right. Tēnā koe.
Thank you. Tēnā koutou te rōpū whakamana i te tiriti o Waitangi. O tira tēnā koutou katoa e hui mai nei i tēnei rā tāpau. Tēnā koe. Thought it would be proper to introduce myself to the tribunal. My name is Stephen Mark Crisp. I am commonly known as Tipene Crisp. I have been a whāngai of Rangitane o Wairarapa since 1986. With reference to Sir Poe, I hold a Bachelor of Arts with honours in Māori Studies and History and a Master of Arts in Linguistics from Victoria University. I am also a certified and practising interpreter and translator of Te Reo Māori. I have been involved in researching the tribal history of Rangitane o Wairarapa since 1986. I have previously given evidence on behalf of Rangitane o Wairarapa in regard to our claims before the Waitangi Tribunal dating back as far as 2003, and for the Rangitane Tūmaira Trust in regard to our Takutai Moana application in the High Court. I was formerly a trustee of the Rangitane Settlement Negotiations Trust and a negotiator for Rangitane in relation to our historical Treaty of Waitangi claims with the Crown. I was a former trustee of the Trust at the time of its establishment. I provide evidence on behalf of the Trust for Rangitane. Tēnā koutou.
Tēnā koe, Mr Crispin. Sorry, sir, just sitting down, given my proximity to Mr Crisp, I will leave you to answer any questions from my friends. Tēnā koe.
Tēnā koe, Mr Crisp. My name's Tim Stevens, I'm counsel for the Crown. I just have a couple of questions. In your evidence, you address, obviously, the hearing in which you've been involved in relation to the east coast of the Wairarapa, and you describe how if the proposed amendments are put into effect as they're currently described, there will be a situation where one part of the coast has been customary marine title will be determined under one test, and another part of the coast is under a different test, and you address the what you see as the perversity of that, if I can put it that way. Do you have a sense of whether there will be ultimately different outcomes according to the two tests, or is that something that's too hard to say?
Tēnā koe, thank you for your question. It is, if I just sort of locate myself, so yes indeed, the Wairarapa 1A hearing was from Whareama South to Turakirai, involved a number of rangitane hapu, of which we supported together with our Ngāti Kahungunu whanaunga. That's been completed, as you're aware. The Judge Gwyn has issued her decision. So that process is in train. From Whareama North to Poroporo, we've recently completed the hearings, and it would be subject to the pānui that was produced by the Crown in the last month or so. There are a number of rangitane hapu who fall into both categories. So Ngāti Hamua, I recognise George Matthews from Te Heka o Papauma, Ngāi Tūmapuhi-a-Rangi have interests in both the southern end of our region and in the northern end of our region. And our concern, as I've stated, is that there would be a different set of criteria applied to the decision-making process through the High Court if this was to proceed. It's really difficult to predict what a judge will decide. And I don't want to make any assumptions, but we are deeply concerned that if the tests are changed, the criteria are changed halfway through the proceedings, that a different result will come forth that will result in quite an imbalance in terms of what, the result for rangitane and our hapu and our neighbours of Ngāti Kahungunu.
Thank you. One other question, and you may have heard me ask this question of people yesterday. You describe also in your evidence the effort that has gone into the hearing, which is yet undetermined, and the prospect of having to essentially rerun that hearing again, potentially. And my question of others, I'd like to ask it of you as well, is are there any measures that you can think of that might ameliorate that or mitigate that to some extent?
Just to help contextualise and locate myself, if I talk about the stress that we see arising from the potential scenario that you've described, before I get to sort of the potential to mitigate that. So I've spoken in my brief of evidence about the personal cost that goes along with it, the sort of the hours and the work of many people engaged in preparing evidence and presenting evidence to the High Court about our takutai moana interests. There's another set of concerns that we have. So harking back to my Waitangi Tribunal experience and treaty settlement negotiations, those processes created significant rub in our inter and intra-iwi and hapu relationships. And we've worked hard to overcome that and to find a way forward. Every time we come to a session like this, it sort of brings up the nawe and the rub and the contention, and it sort of creates the risk to harm inter and intra-iwi relationships. The third element that I was thinking about this morning in preparing for this session was reflecting on the Rangitane Tūmaidā Treaty Settlement, where the Crown told us really clearly it looked forward to developing a new relationship with Rangitane based on mutual trust and respect. It's difficult to see going through this process, the impact of that on our settlement and the promise of the Crown to build that relationship of mutual trust and respect. I'm not sure what could be done to mitigate those risks. So sort of starting at the top of my list, claimant funding is important and was actually the matter that we brought as an urgent inquiry, an urgent tono to the Waitangi Tribunal. So we're still deeply concerned about the provision of claimant funding to let people do the necessary tasks that are required. So that's important. Finding a process that facilitates inter and intra-iwi relationships will be really important. We've worked really hard at that, and I would be really loath to go back and be in a situation where we have to relitigate, quite literally, a bunch of stuff that's deeply personal to us as a community, especially with the history that we've had. So thinking about a way to facilitate better engagement within iwi is another important component. Streamlining the exercise. We've been going at this for a number of years now. Rangitane made its application back in 2017. Our first Treaty of Waitangi claim was made in 1987. So my entire adult life I've been involved with Rangitane doing this sort of thing, and it's time consuming, it's wearying, there's other stuff I'd love to be doing. A facilitated process that helped streamline this would be appreciated. I'm sure there are other things, but sort of that's my initial response.
I've just got two questions that come out of that. One is about the difficulties between the hapu or the different whānau. Is that essentially relates to differences about rohe? Is that the nub of it, or is there more to it than that?
In preparing for the hearings, yes, there's certainly a strong element of we're gathering exercise to demonstrate our interests in particular areas, and that involves trawling over Land Court minute books in particular that were sometimes really heated disputes from 150 years ago and sort of reheating those as it were. So that is a significant element of it, yes.
And then the second part of that question was, is there a Crown role in that second time round? You were talking about a sort of facilitated or streamlined process, I think. I'm just, the reason for the question is it's not necessarily appropriate for the Crown to get involved in resolving those types of differences as such.
I think to respond to that, it is important to look back at our experience over the last 20, 25 years of treaty settlements, which was a Crown process. Dealing with overlapping claims was a Crown process. That created significant tension in our community, and we've worked hard to respond to the fallout and the aftermath of those Crown processes. We are interested in finding a way to, I mean, at one level the answer to your question is this isn't a Crown process. You know, working through inter and intra hapu and iwi relationships is something for us, but the Crown is a party to that conversation. And being an enabling party who sort of can help us facilitate that, not being a disruptive party, would be enormously useful.
Those are all my questions. I want to thank you very much for the thoroughness of your answers. I know you won't accept the premise of the question and that you oppose the amendments in the first place, but I'm very grateful for your evidence. Tēnā koe.
Kia ora, Mr. Crisp. Given the very lengthy involvement that you had and have had for rangitane over the decades, hypotheticals are always a terrible thing in court cases, but I'm going to put one to you. If there had not been a deadline imposed in this legislation initially, would you have, on your understanding of the issues that affected rangitane and the coastline, would you have anticipated pressure for some legal recognition of customary marine title as a matter of urgency by rangitane?
Thank you, sir. Rangitane has always been passionate about our takutai moana, and just, you know, for me personally, having a deadline in 2017 wasn't a bad thing. Just getting our application in. But sort of to your broader point, we've always had an interest in our takutai moana. We were always going to pursue those interests through whatever legal instrument or whatever legal mechanism was available to us. And I note in our deed of settlement, one of the statutory acknowledgements is over the customary marine area from Poroporo to Turakirai. So it's always been important to us. We will always pursue our interests and protect our rights in the takutai moana.
I suppose what I'm really getting at was there any perceived threat to the exercise of your customary rights that you would have needed to react to?
Rangitane has always understood that we've had a strong interest in the takutai moana. We've been active in protecting that, and as particular threats presented themselves, we responded to those things over an extended period of time. Rangitane was always going to continue doing that, and I do take your point about straying into the hypothetical, but sort of we will always protect our interests in the takutai moana.
Tēnā koe tīpene kāre, aku pātai kia koe engari e mihi ana kia koe kua rua te wā. Ka kua te ngākau ki te atu ia koe.
Kia ora, Mr. Crisp. I don't have any questions for you either, but thank you for your evidence and for your time today. Tēnā koe.
Tēnā koe. No questions of re-examination for me. Tēnā koe, Mr. Crisp. Tēnā koe tau.
Tēnā anō e te pai hika mā tēnā tātou. Sir, Ngāti Awa calls Reuben Araroa as its witness in this proceeding. Mr. Araroa's evidence is at document number A4. While the panel is laying their hands to that, me mihi ka tika ki ngā memo o Ngāti Awa e whakarongo mai ana, mā runga livestream, mā runga rorohiko, e tā hirene kei te mohio au, kei te whakarongo koe hoki, tēnei te mihi atu ki a koe, ki aia, and Mr. Araroa has made his way to the stand. No, please take the stand, Mr. Araroa. There is a microphone there if you just press on that button, you'll light up red, ka pai. Mr. Araroa, you confirm your full name is Reuben Te Pere Araroa?
Yes.
And you have affirmed an affidavit in this inquiry dated 7 August 2024?
Yes.
And you confirm the contents are true and correct to the best of your knowledge?
Yes, I do.
Ka pai. So the brief will be taken as read, panel, but Mr. Araroa has some introductory remarks and a mihi that he would like to make. And then Mr. Araroa, if you can remain for questions of my friend for the Crown and the Tribunal if they have any.
Kia ora.
Tēnā koe.
Tēnā tātou. Tuatahi kua tautoko hia I ngā mihi, kua mihia, ki ngā mate o te wā, haere atu rā. Ka hoki mai tātou ki te honga ora, ki te mana whenua o tēnei rohe, te ati awa, Ngāti toa, Ngāti raukaua, tēnei ka mihi ake, kia koutou te whānau e taunei, tēnei ka mihi ake mō te tautoko ana I tēnei kaupapa whakahirihira. Kia koutou e ngā rangatira o te whakamana o te tiriti o Waitangi. Tēnā koutou. E tā pau, pai te tūtaki I a koe anō. Tēnā koe e tā. Ko Ruben Araro toku ingoa, ko au te mana hautu o te rūranga o Ngāti Awa, ko tai mai nei hai kanohi kitia mō taku iwi a Ngāti Awa. Tēnā tātou. I was raised in the 70s in a small rural community in the heart of the rangataiki, which is our ancestral land. The main priority at that stage, according to my karaua, was to learn the English language as best I could. This was reinforced by my father, and the purpose of that was to ensure that I could relate to Pākehā for the purpose of a more prosperous future. I would be educated without any understanding of the reo. I would then join the New Zealand military in a prestigious military academy called Regular Force Cadet Schools. I would then leave the military and seek a career in management in the corporate world. And I'd have to say that that experience has provided many opportunities. However, during that period, I was very naive to the struggles and the battles that my iwi were undertaking. For the last 2 years, I have been serving Ngāti Awa as the Chief Executive. And one of the positive benefits of my upbringing has been the ability to set an agenda with an intent. And that also has set me up to actually identify an agenda that has an intent against our organisation. And the first statement I'd like to say is this. The proposed changes to Section 58 of the Taku Taimoana Act 2011, in my view and in the view of Ngāti Awa, has an agenda with an intent that undermines the relationship between not only Ngāti Awa and the Crown, but all iwi across the motu. I'm quite sure when this act was set in 2011 by the then Prime Minister John Key, I'm quite sure that potentially based on my experience observing him, that he'd be quite perplexed with what is going on today. And if he isn't, then I would maybe suggest that back then that was part of a larger agenda to lead us to where we are here today. I'm here to state on behalf of the iwi again that we do oppose the changes to the legislation. And I'm also here to recognise the mana and authority of my Pākeke that have walked this journey before me and the efforts that they continue to undertake in order for the long-term prosperity of Ngāti Awa. Tēnā tātou.
Tēnā koe, Mr. Araroa. I just have a few questions following your evidence. So I'm right to understand, I think, that Ngāti Awa's application that is still to be heard is in an area that is sandwiched in between and overlaps the Reader and Edwards applications.
That's correct.
And that's scheduled for May next year is the application that Ngāti is bringing.
Yes, that's correct.
And so you have a scenario where Reader was heard in 2021 and judgment is still to be delivered on that.
That's correct.
And then Edwards has been determined and is going through the courts with the Court of Appeal decision being one of the reasons why, or one of the main reasons why we're in this inquiry today, and then your application. But you also participated in the Reader and Edwards applications.
Yes.
And you start off your evidence by saying that when you looked at the Crown engagement pathway, applications wouldn't be progressed until 2040. What was the reason for that? How did you arrive at that time frame?
Yeah, based on working with legal counsel and bringing myself up to speed with the history of our cases that Ngāti Awa have pursued, the information on hand would suggest that 2040 was the time period given other priorities of the Crown at that time.
Right. So that was your assessment based on all of the information that you had available.
Yes, that's
to you.
correct.
Yeah. So you then, Ngāti Awa then participates in Edwards and Reader. I think you essentially described that as a protective step, if I characterise that properly. I had a question about why Ngāti Awa didn't see a need itself to progress its own application at that point. And I ask that because when I read the Court of Appeal case,
Yeah.
it sounds like, in Edwards, it sounds like those two cases, Edwards and Reader, are going forward and they're being pressed by the applicants in those cases. But it was not Ngāti Awa's perspective to press its own application. Do I have that? Do I understand that correctly?
Yeah, I can give you probably the context is probably the best way to answer that question. These are very complex issues that you have to resolve. And the first thing is to observe and listen to what's going on in your local environment. And there are intertribal, what I would call, relationships at risk here, given the context that you've provided that we're in the middle. We don't see ourselves as being sandwiched. We see ourselves as having the mana across the boundary that we assert, right? And so therefore, whether we put an application or not in is something that we must consider in addition to our iwi relationships within the Mātātua waka. And so having conversations outside of the court with our whanaunga, our ancestral whanaunga, for us was a priority. And so therefore, coming forward to today, I would suggest that what you've just described is partially due to that.
You describe in your evidence that the result of this, the complexity, and now the potential for a new test means that there is the potential for different boundaries depending on which test is applied. Do you have a sense, and it may be too hard for you to say, I acknowledge, whether the proposed amendments in your case will make a material difference? Is it possible to have a view on that at this point?
Yeah, again, it's very difficult to be specific around material difference. But we all know, all the people within this room would know clearly, if the rules are changed partway through any game, we've got to go back and rethink what are the consequences. And when it comes to boundaries, again, we are triggering a set of emotional, human emotions, such as anxiety, concern, and fear, that these changes may again interrupt the tribal relationships in our region. So at that level, there is already impact, as I've already written in the evidence. So yeah, we can't be specific until we actually understand what the true nature of the test will be. But inconsistency is never a good thing.
Last question, and this is the one that I've been asking, and I'll say it, so I'll ask it again, and do want to preface it by saying that I know you won't necessarily accept the premise of the question and that you oppose the amendments in the first place, but if they are made, and given the scenario in which Ngāti Awa would find itself in terms of different tests in quite a stark way, are there any measures that could be put in place to mitigate the mitigate the impacts of having to undertake a rehearing in relation to Reader in particular?
Yeah, I'd like to answer that in two parts. The first one is there is nothing that will change the impact on our people if a rehearing is undertaken. The best way to describe that is using an analogy. I'm a surfer. Let's just say there's some great waves at the back and you're paddling through it. You're physically fatigued. You're holding your breath a lot. Just when you think you're at the back, another big set comes through. That's the first thing that's happening here, is we're seeing another massive wave of more legislation coming at us. The second part is we need time to consider it. And my experience over the last 2 years as an iwi chief executive is that time is one of the strategies to reduce the amount of time for us to assess things. And it is overwhelming. And it is resource heavy. And although I acknowledge the funding from Te Arawhiti, that's barely enough to cover the campaign of interacting not only with these policies, but the ones that are coming forward. Our settlement was designed for the prosperity of our people. It wasn't designed to invest into these types of matters. And essentially, coming back to your question, no, I don't think there's anything that can reduce the impact.
Thank you, Mr. Aroa. Those are all my questions. Tēnā koe.
Tēnā koe.
Kia ora, Mr. Aroa.
ora,
Could
sir.
I just ask you to clarify, if you would, the colouring in the plan that follows your paragraph 20, if you would, particularly the grey colour.
Yes.
Yes,
what's the question,
particularly
sir?
the grey colour.
Yes. What would you like clarified, sir?
Could you just clarify what that grey colour area is depicting?
Yeah, certainly. It's our view that the grey colour are the areas that have already been heard. And we're just waiting judgment on that. With the Ohiwa already, the Ohiwa Harbour already having a judgment made on that.
Right. So at your paragraph 25, those 20 weeks of hearing that you've been involved in involves those two sets of Ngā Pōtiki hearings and Edwards hearings and the Court of Appeal.
Yes, that's correct.
Rigorous?
Arduous. Painstaking. I think about the Pākeke within the iwi that have passed since those times, and the amount of effort that they've put in. and the amount of mātauranga that they have delivered to these kaupapa on behalf of the iwi, and the fact that if these are reheard, then, in my view, that is the best way to takahi their mana.
If it was, I appreciate you weren't the CEO at the time, so probably I can't ask you about the effects of the deadline, but if the deadline had not been there, were you aware of threats to your customary exercise of your rights in respect of the takatai moana prior to that deadline being imposed?
Yeah, that's a great question. I was in a commercial corporate career where I learned how we would contribute to the economy of Aotearoa both domestically and internationally. Our resources are at the heart of it. Location is at the heart of it. Water is at the heart of it. Ocean is at the heart of it. So customary marine title, because I believe the next horizon is the moana. And you can already feel that through aquaculture and through these proposed changes. That is the new horizon to be surveyed. My point being is the deadline is irrelevant. What has been continuous is the attack on our resources. And like I said, I would know that because I used to work for companies that would draw millions and millions of water out of rivers and then put that water back in a condition that wasn't as good as we took it. So, yeah, this is important to us.
Tēnā koe te rangatira. Kei te marama o kōrero ki tēnei mema, e takoto pai ana o kōrero. Nō reira kāre aku pātai kia koe, engari e mihi ana.
Tēnā koe e tā.
Tēnā koe, Mr. Araroa. I don't have any questions for you either, but thank you for your evidence. Tēnā koe.
Tēnā koe.
No questions of re-examination, sir, so that concludes the presentation for Te Rūnanga o Ngāti Awa.
Ahoe anō, Ngāti Awa te toki, e tangatanga i te rā, e ngohe ngohe i te wai, a tēnā koutou katoa.
Ki te rere ngā te totorongo, ki te puke ngā te matarongo, weho marongo mai no horangi. Hei titi te pau, whakairo i te pau, mata whai ari ki atu. Takai atu ana e awa te arata, nā mātua i whakahirahira e te kuia nei a mahanga i te rangi ko, awa korongo korongo ko, tamako uru ko kwera, he whawhati te pari hau o te mōna i taua, i te waka o tamate a mimiti ana te tai. He tira, he taua whāno whāno e ko kahukura te manu whakawa i te mate waihoa ke umuri nei. He titi ai a puni hoki te tokatipua, maua tapu kua e ke taua ki moe hau, kia atu tawhiti katoa i te pungare. Hua te ahia, tamate kapua, tangata te arawa i tau tiriti ai e ia te mata o te waia. Wai mihi a hoki ki te manu ka tūtahi ke hiko e wai waira, i te ua o muri wai. Unga te waka, pō waira kaira ruai e.
So, Mr. Lyle, I believe that completes the claimant evidence other than Kahukore Baker,
Yes, sir.
who is going to present tomorrow.
I've spoken to Ms. Baker, and if we do get to the point today where she may be able to be called, if we manage to get through cross-examination of Ms. Marsh, she will be able to make herself available and is rushing back to make that happen. So
Okay.
we'll see where we get to.
Thank you, Mr. Lyle. Mr. Stevens.
Tēnā koe, sir. And thank you. So the tribunal will have our written submissions, and I'm going to speak to them rather than read them all out. I've prepared a simple chronology that contains references to the Crown bundle that was filed last Thursday. That, I believe, has been filed by email, and we have copies for the tribunal and hard copies, so we might just hand those up now. Oh, thanks. Do you mind? So that's...
Thank you.
I'll give you that as well. That's okay. And I'm also providing a short hand-up, which I'll refer to shortly. And the purpose of the chronology I will come to, but that's so I can draw the tribunal's attention to a couple of matters. First of all, I want to say, as the written submissions do, that the Crown acknowledges the significance of the Stage 1 issues for the claimants and interested parties and for the tribunal. The Crown has endeavoured to assist the tribunal and inquiry participants in bringing the inquiry to hearing under compressed timeframes, including through the disclosure of the relevant policy advice and ministerial decision papers, and including the broadening of its disclosure in response to voiced concerns at a judicial conference at which the Crown's disclosure was discussed, to include file notes of ministerial meetings with third parties. And they are, of course, now the cause of trenchant criticism from the claimants. But the Crown has sought to engage with the tribunal and the claimants and provide the disclosure that the inquiry needs in order for it to perform its function. And the Crown is also putting forward a senior Te Arawhiti official, Ms. Marsh, as a witness very shortly to explain the policy development process and that process in relation to the proposed changes to the Act. I did want to say at this point that we heard yesterday in opening submissions that the tribunal will be invited to draw negative inferences from a claimed lack of information voluntarily provided and a suggestion that the paucity of disclosure is striking, particularly with regard to the question of Parliament's original intent in 2011. And with respect, that's not a concern that had been articulated until last week. And in my submission, it's not well founded, and that's the purpose of the hand-up. I don't propose to go through it, but the function of the hand-up is to provide for the tribunal references in the Crown bundle to where the question of Parliament's original intent is addressed by Te Arawhiti officials, and their view and the advice that they gave the Minister on that topic, and then also the Minister's own views of the issue of Parliament's original intent and where the Minister's views might be found, and particular reference obviously to the Cabinet paper, which is the Minister's own voice and perspective that he brings to the Cabinet table. So that's the function of that hand-up, just so the tribunal has references to the documents where these matters are canvassed. The Crown also wants to acknowledge that claimants and interested parties and the tribunal itself, of course, have been working to very compressed timeframes, and the Crown wishes to acknowledge their work in bringing this matter through to an urgent hearing. Turning to context, the tribunal, as well as many, if not all, of the claimants and interested parties will be familiar with the Act and the legislative, historical and social context behind its enactment in 2011, and that's not least of which, of course, because of the tribunal's report, inquiry and report in Stage 2 of the Y2660 inquiry, which the tribunal reported on in October last year. So the Crown assumes some familiarity with the context. I will say that as passed in 2011, the Act was the result of a significant consultation and policy process, and they are discussed in depth, those processes, in the Crown's closing submissions for Stage 2 of Y2660, and I won't repeat those matters here, but there is the reference in the Crown's written opening submissions for this inquiry as to what the Crown said on that occasion. But in short, the Crown considers that the Act reasonably balances Māori and public interests in takutai moana, and reflecting that balance of interests, the Act established an exacting and rigorous test for applicants to obtain recognition of customary marine title. And the rights in Section 62 of the legislation were intended to be tangible, meaningful, and of real effect, and in the Crown's view were calibrated having in mind the exacting nature of the test for CMT. And the exceptions that exist in the legislation to protect the interests of other users were also, in the Crown submission, specifically calibrated having in mind the exacting nature of the test. And so the Crown submission in Stage 2 of Y2660 was that the regime involves a reasonable and treaty-consistent balancing of the customary interests that Māori have in takutai moana with the many other intersecting interests that now exist in that area. And it's important to bear in mind in my submission that submission of the Crown, that the regime involves a reasonable and treaty-consistent balancing of the customary interests, was a submission that was made pre-Edwards, and the majority of the Court of Appeal's interpretation of the Section 58 test. That brings us to Edwards itself, and as we say in the written submissions, the Court of Appeal's decision was the first appellate case to address substantive proceedings under the 2011 Act. And at this point, it's helpful, Sir, to pick up the chronology that I supplied. That does provide, in my submission, important context for this inquiry. And I start there at 4 October 2023, where the tribunal reports on Stage 2 of Y2660. We have the general election on the 14th of October 2023, and then 4 days later, the Court of Appeal delivers its decision in Edwards. A month after the Court of Appeal's decision and the majority's interpretation of Section 58, the Attorney General files an application for leave to appeal the Court of Appeal's decision, and that is to say before the coalition government is announced and before the content of the National and New Zealand First Agreement is known, and therefore the commitment in that agreement regarding the Edwards decision. On the 24th of November, so a few days, about a week after the Attorney General's application for leave to appeal, the coalition government is announced with the New Zealand First Agreement containing the Edwards commitment. And then on the 14th of December 2023, and this is in line with the Supreme Court timetables, the Attorney General files submissions on the leave application. And I do want to take you, Sir, to those leave submissions to understand the Crown's position in the Edwards case. And that's tab 1 of the Crown bundle. So what tab 1 has within it is a briefing document, the Te Arawhiti initial briefing to the Minister for Treaty of Waitangi negotiations on the 21st of December 2023. And an appendix to that briefing, Appendix 2, that's on page 9, is an extract from the Attorney General's leave submissions filed in the Supreme Court. And just speaking briefly to those, not to make the argument as such, but more for the purpose of setting out the Attorney General's view, the Crown's view, in relation to the Edwards judgment. And the extract starts at paragraph 6 of the leave submissions. Section 58 of the Act provides for CMT to be recognised if an applicant group holds the specified area in accordance with Tikanga Lim 1 and has exclusively used and occupied the area from 1840 to the present day without substantial interruption, Lim 2. The majority of the Court of Appeal found it exceptionally difficult to reconcile the text of the second limb with the Act's purposes, and they considered that a literal reading of the second limb would mean that in many cases the threshold for recognition would not be met, and they described such an outcome as one that extinguishes customary interests by a side wind and would be inconsistent with the Treaty of Waitangi, and assurances given in a 2010 consultation document issued by the government. So the majority in Edwards therefore held that an applicant group does not need to demonstrate exclusive use and occupation from 1840 to the present day. The majority considered that such a requirement would be unjust and unprincipled, given that Māori did not have a legal ability to exclude others for most of the relevant period. And instead, an applicant group is only required to have exclusively used and occupied an area as at 1840, prior to the proclamation of British sovereignty. And provided that the group's use and occupation has not ceased or been substantially interrupted post-1840, the second limb may be satisfied. At paragraph 8, the Attorney General submits that the majority erred in law by concluding that Section 58(1) does not require an applicant group to demonstrate exclusivity from 1840 to the present. The Attorney General submits that the second limb clearly and unambiguously requires a group to have exclusively used and occupied from 1840 to the present day. And the Attorney General submits that the majority's interpretation ignores that requirement. On appeal, if leave to appeal were granted, the Attorney General proposes to argue that the majority's interpretation is not an available reading of Section 58(1). The inclusion of a requirement of exclusivity was a deliberate, from 1840 to the present day, was a deliberate choice made by Parliament and part of the government's proposed test for recognising customary title, as set out in the 2010 consultation agreement referred to by the majority. The Attorney General refers to the minority judgment of Justice Miller and submits that Justice Miller correctly concluded that the concept of exclusive use and occupation requires both an externally manifested intention to control the area as against others and the capacity to do so. And it submitted, paragraph 8.4, the effect of the majority's approach to Limb 2, coupled with the court's approach to the burden of proof, is that an applicant group need only establish that its use and occupation has been continuous. There is no requirement for an applicant group to prove exclusive use and occupation from 1840 to the present day, or even as at 1840 prior to the proclamation of British sovereignty, despite the majority identifying this as a component of the test for CMT. And this leaves, in the Attorney General's submission, Limb 2's requirement of exclusive use and occupation from 1840 to the present day with no work to do. I won't read out the rest of the Attorney General's submissions, but in my submission, the Attorney General's the Crown's position as articulated by the Attorney General's submissions on that leave application is important to context to understand the steps taken by the Minister and the Crown following the Edwards judgment. Now, the briefing note, of which this forms an appendix, is, as I say, the initial briefing provided by Te Arawhiti following the formation of the coalition government. And at page 3, at paragraphs 11 and 12, the briefing reads, "The coalition agreement wording and the reasons for the Attorney General seeking leave to appeal the Court of Appeal's judgment appears to be consistent, and you may wish to confirm this in discussion with your coalition colleagues." The briefing goes on to say, "The Attorney General's application to appeal does not limit you as the Minister from making decisions regarding a Section 58 amendment. However, it does add complexity regarding the timing of an amendment in relation to a possible Supreme Court hearing. You may feel that it is better to wait for a Supreme Court judgment, which may resolve the Section 58 issue, or you may consider that a legislative amendment is needed more urgently to clarify this issue, regardless of progress in the courts. We understand that your preference is to progress the amendment and not to wait for a potential Supreme Court judgment." So that supplies the basic context for the steps that then follow, which is the Crown's position is already, prior to the formation of the coalition government, that the majority of the Court of Appeal's interpretation of Section 58 in Edwards is wrong and is not an available reading of the Act. And the Attorney General, the Crown, has therefore sought leave to appeal in Edwards, and the approach that the Crown intends to take in the Supreme Court is that which I've set out in that extract from the Attorney General's submissions. And the question for the Minister that is posed towards the end of December last year is, you may wish to wait for the Supreme Court to clarify the issue, or you may wish to progress legislative amendment now, and identifies that the Minister's preference is to progress legislative amendments and not wait for the Supreme Court outcome. And that sets the basic context. And as I submitted earlier, and just to reinforce the point, the Crown's submission pre-Edwards, the Court of Appeal Edwards, was that the Act reflects a reasonable and treaty-consistent balancing of the interests that are at stake in takutai moana. I know, of course, that the Crown recognises that the Tribunal's report for Stage 2 differs from the Crown's position in important respects, and recommended amendments to the legislation that would reflect the Tribunal's view, but the Crown's submission was and remains that the pre-Court of Appeal Edwards understanding of Section 58 that the Crown now articulates will articulate in the Supreme Court reflects a treaty-consistent balancing of the respective interests. So,
Mr. Stevens, I just have a question of clarification for you on that, because I understand the submission you're making that the proposed amendments are consistent with the position that the Attorney General is taking in the appeal against the Court of Appeal decision. The part that I'm still unclear about, if that was the concern, why do the amendments seek to overturn not only the Court of Appeal, but also the High Court? If that was the concern, wouldn't the amendments seek to overturn the Court of Appeal and to reinstate the test as set by the High Court?
And that does arise, that very question does arise in the course of the policy development that Your Honour will see in the documents and which Ms Marsh speaks to, that originally the approach was that it's merely a question of addressing the Court of Appeal's judgment. And then the Minister himself, when considering and reflecting on the issue, looks at the High Court's interpretation in Edwards and believes, in short, that in order for a durable solution to be arrived at that reflects his view of Parliament's original intent, that the High Court decision also needs to be addressed. And that's the Minister's view, and it comes out in the policy papers. And that's not the advice that he received from officials, but it is nonetheless the view that he ultimately settled on and that he took to Cabinet.
And I'm aware of that as well. If that is the case, can the Crown maintain the position before us that these amendments only arose because of the Court of Appeal decision when it appears that the amendments go further than that?
I suppose the genesis of the coalition commitment is the Court of Appeal's decision and the majority's interpretation there. But when the Minister stood back and reflected on the effect of the Court of Appeal decision and looked at amendments which would produce, in his view, a durable solution for this issue, he also felt it necessary to address aspects of the High Court's interpretation. And that flows out, or I suppose the primary or the genesis of the amendments is the Court of Appeal's decision, but that leads through the policy process and the Minister's reflections to addressing Edwards and the High Court as well, when one is framing the ultimate legislative answer. And what the Crown is advancing in the Supreme Court as to the appropriate approach to interpretation of Section 58 in Edwards is essentially the Crown's position in relation to the proposed amendments. They are essentially consistent if one reviews the submissions that the attorney has put forward to the Supreme Court. And that is as far as I think that I can take the matter, sir.
Just on that issue, but how can there be consistency when the proposal involves fundamental changes to the purpose provisions of the Act? Because that's not even possible in the appeal process in the Supreme Court.
Yes.
So there can't be consistency, can there?
So no, that can't be an outcome in the Supreme Court. I agree with you. What the approach to the purpose provision and the treaty clause, the approach taken in the proposed amendments, the reason for that is that the interpretive approach taken by the Court of Appeal, the majority of the Court of Appeal, is to read down the literal text of Section 58 and say that it's exceptionally difficult to reconcile the literal text with the purpose clause and the treaty clause, and so therefore the majority of the Court of Appeal arrives at a different reading of the literal text. And so in order to address that interpretive approach of any court, how to reconcile apparent inconsistency between the literal text of Section 58 and the treaty clause and the purpose clause of the Act, the amendments lean in specifically to that conflict and endeavour to remove the conflict so that the text of Section 58 is what it says it is. Now, in the Supreme Court, the argument will be that the literal text of Section 58 is the meaning of those words, the natural meaning of those words, are how the test should be applied, and that the broader provisions of the Purpose Clause and the Treaty Clause don't operate to change the literal meaning of Section 58. So that will be the legal argument in the Supreme Court. But to remove that uncertainty and remove the interpretive approach that reads down or changes the meaning of Section 58 by reference to those more general provisions, the legislative amendments address that issue front on. Now, the Supreme Court can't, of course, rewrite the legislation as such, but the argument that will be made to the Supreme Court is that the context of the 2011 legislation and the specific wording in Section 58 means that Section 58 means what it says and should not be interpreted in a way that changes the meaning of those otherwise natural meaning of those words. I hope that's a long answer to your question, sir, but I hope I've answered it.
I understand.
Thank you. So that, in terms of my written submissions, leads me to the purpose of the proposed changes in their process for development, which I've largely canvassed just now. The purpose of the Crown's proposed changes is to clarify the requirements of obtaining CMT following the Edwards decision, which had the effect of lowering the threshold for obtaining CMT. And the key materials for understanding the Crown's position is the minute of Cabinet's initial decisions on 8 July 2024 and the preceding paper that was taken to Cabinet by the Minister. And so I did want to just clarify the documents that we are talking about in this regard and clarify which are the right documents in the Crown bundle, and I'm doing that because in the course of working through the papers, that's a process that I went through. So tab 53 of the Crown bundle
Mr. Stevens, I wonder, could you give us page numbers?
Oh, yes,
Because
of
we
course.
haven't got
Yes,
tabs,
you haven't got
actually.
tabs.
Yeah.
Page 497, sir.
Okay.
So the reason for doing this is that there are several versions of the Cabinet paper in the bundle, and I just want to identify for the Tribunal the correct, well, the best version to look at. This is the post-Ben Keith version, and so that's why I'm taking the Tribunal to this one. This is the final paper that went to Cabinet on for the 8 July meeting, and it removes various redactions previously made, and in particular paragraph 92 is now fully open. And that reads, I'm mindful of the advice of the Attorney General to ministers that good, and this is the Minister's voice, this is the Minister's paper, I'm mindful of the advice of the Attorney General to ministers that good lawmaking processes must be adhered to as much as practicable, such as allowing sufficient time for select committee consideration. Advice from Crown Law, the Ministry of Justice and LDAC supports this. Officials further advise that a non-standard process in the present circumstances dealing with such important property rights as customary title to the common marine and coastal area is likely to be inconsistent with the principles of the Treaty of Waitangi. So the Minister is setting out there the advice that he's received. And then for reasons that he goes on to explain, he nonetheless considers that the amendments that he is putting to Cabinet should be made. So that's the final Cabinet paper that went to Cabinet on the 8th of July, and as I say, that's the best version for the Tribunal to look at because that is the version that has been reviewed by Mr. Keith, and the Crown has followed his recommendations as to removal of redactions. Also, just to note at this point, tab 51,
Page number again.
oh, sorry, page 448. So this is the Cabinet paper that went to the Cabinet Economic Policy Committee, or ECO as you'll see reference to in the papers. So this is the initial final Cabinet paper prepared by the Minister. This is the one that goes to the relevant Cabinet Committee, of which there is a meeting, and then goes to Cabinet on the 1st of July. And Cabinet at that meeting defers consideration of the Section 58 amendments until the 8th of July and invites a revised paper from the Minister. And the revision, so this initially goes to Cabinet. Cabinet asks for a revision dealing with the question of retrospectivity. And so in the final Cabinet paper, if one turns back to 497 and then the recommendations on page 515, yeah. Starting at paragraph the 9th recommendation, agree that either the amended Section 58 test should be applied prospectively from the date that the Amendment Act comes into force with appropriate transitional arrangements for applications currently in process. Or, and there's a further option at 9.2 and at 9.3, and then this is the change, this is the revision, paragraph 9.4. The amended Section 58 test should be applied prospectively, but from the point of announcement of the policy change, requiring rehearing of any live cases that don't have decisions at the time of the announcement, subject to detailed work on transitional arrangements during drafting. So 9.4 is the addition, is the revision from the paper that we just looked at that went to ECO. So as the documents show, provided by the Crown show, prior to the Cabinet decision, the proposed changes to the legislation were developed by the Minister for Treaty of Waitangi negotiations, and it's clear in the Crown submission that he received robust and frank policy advice from officials, and that was over the course of approximately 6 months, which was concerned both with the options to address the policy problem given to them by the Minister and the impacts of the possible options and proposed changes, including how the changes would impact on applicants under the Act and intersect with the Crown's obligations under the principles of te tiriti. And the Crown acknowledges that applicants under the Act were not consulted on about the proposed changes before they were decided by Cabinet, and announced by the Minister on 25 July 2024. Instead, there was a feedback process following the announcement that ran for approximately 3 weeks, and that process concluded on the 15th of July, and there is ongoing work to summarise and present the nature of the submissions received to the Minister. And not only applicants availed themselves of the opportunity to provide feedback, submissions were also received from the New Zealand Law Society and Te Hunga as well, amongst others.
Correction, 15 August was the close date, not 15 July.
Oh, I'm sorry. So I said 15 July was the close date for submissions, and my friend Ms McCoy has pointed out that it's 15 August, not 15 July. So the feedback process began on the 25th of July with the pānui from the Minister and from Te Arawhiti, and then that ran through to 15 August. So in terms of Crown evidence for stage 1, the nature of the proposed changes and the Minister and Cabinet's rationale for them are explained in the documentary record that's been made available to the Tribunal and to claimants and interested parties. And that record shows the understanding that the Minister and Cabinet had of the proposed amendment and the assessment of the risks and issues which the proposed changes raise. And with that, unless you have any further questions, sir, that's the Crown opening, and I propose now to call Ms Marsh.
I'm afraid there are going to be some questions directed to you, Mr Stevens, if I can. Can I just deal with some matters of clarification first, if I can? And it might be appropriate to start at a map at page 447 of the Crown bundle. And that's headed CMT Orders Awarded. And it appears, it's extremely small type, but it appears to say that the Ngā Hapu or Ngāti Porou CMT orders were effective on 1st February 2021. So are we to take it that those would not be impacted by option 9.4 of the final Cabinet paper?
So there is a special arrangement for Ngā Hapu o Ngāti Porou. I will have to go back to the evidence to check that. That is an issue that can be raised with Ms Marsh.
Can you clarify that in the closing submissions?
Yes, of course.
Thank you. The next, whilst we're on that map still, in terms of the Ngā Pōtiki, oh, not Ngā Pōtiki, no, if we look at Wairarapa and the Edwards situations, what do you say is the effect of the 9.4 option in terms of the High Court decisions that were issued in those two situations which are subject to appeal?
So, and this is something that I think the claimants and interested parties have also expressed a lack of that there's there's a lack of clarity about it.
Right. Well, rather than putting you on the spot, make sure that the Crown submissions address that extremely clearly for us, because I'm certainly not clear myself at the moment.
So I'm just making notes of
So
this.
both the Wairarapa and the Edwards situations, which as I understand it are the only two where appeals are extant to the Supreme Court at the moment, and one case in Court of Appeal and the other. What is the Crown's position as to the effect of option 9.4 on those?
Yes, and I will set that out clearly in the closing submissions. I can say now, though, that the basic position is that where a judgment has been delivered in respect of any CMT by the High Court, then the approach taken in Edwards applies, And that obviously is subject to the Supreme Court outcome and whatever the Supreme Court decides. But in essence, there is a path anticipated by the proposed legislation that grandfathers, that's an old word, but preserves High Court judgments that have already been delivered and any processes that follow out of them. And so that...
So in essence, you're saying that regardless of whether this proposed legislation goes through, the Supreme Court and the Court of Appeal in the Wairarapa case have to carry on with the process under the old regime, issue their decisions under the old regime, so the outcomes will be whatever is dictated by that judicial process?
Yes.
Right, with only other ones subsequent being caught by the option 9.4.
Yes, and so so the legislation is prospective insofar as there are High Court judgments delivered,
right,
but not prospective for cases that are yet to be heard or yet to be determined.
So in the Wairarapa situation, that would mean that the judicial process and the appeal process will apply in respect of 1A, but in respect of 1B, where the judgment is reserved at the moment, the legislation, the proposed new legislation would apply, in essence forcing a rehearing of that process.
Yes.
Right. All right.
And as I say, we will make this very, I will explain this in writing in the closing for the Crown, so that is clearly spelt out. So.
Thank you. I just want to be quite clear, one other point of clarification. I just want to be quite clear on the concession that you've recorded, and thank you for doing so, at paragraph 13, I think it is. No, where are we? At paragraph 21, you made an acknowledgement formally that the applicants under the Act were not consulted on the proposed changes before they were decided by Cabinet. I just want to be quite clear that you're not advancing any argument, or are you, that the method of feedback that was utilised met the consultation tests that have been laid down by a range of authorities? Yep.
So, in terms of language, the Crown is careful to... Crown concession is a different thing, which requires... a formal Crown concession requires a process including Cabinet approval. So, I do want to be clear by saying that paragraph 21 doesn't contain a concession, but there is an acknowledgement.
Right.
The Crown does not advance the submission that post-announcement feedback process is a consultation process as contemplated by tribunal jurisprudence on the matter. It is nonetheless a feedback or consultation process, and it's not in vain, and certainly it is intended to consider the submissions that have been made and for the Minister to take them into account.
And you've said that feedback is going to be analysed. Given the haste with which all of this is happening, I would have thought that analysis may have occurred already. Has it? And is there a document summarising?
The analysis process is still underway, and there isn't a document at this point.
Right.
I'll just check one thing, sir.
Thank you.
I was just inquiring about where things were in the process. It's a matter, so it's not finalised and there isn't a document, and I'd need to take further instructions on the ability to provide any document in the future.
Just a few other matters of clarification before I get on to some more substantive points, but top of page 6, I just want you used the wording, the Attorney General, in relation to Edwards, you used the wording, the Attorney General participated in the High Court and Court of Appeal as an interested party. My understanding was that the Crown didn't appeal the High Court decision. Is that correct?
Yes, I think that is correct. Let me just... Yes, that is correct.
Thank you. You've only referred to it in terms, at paragraph 17, in terms of the coalition agreement and quoting the coalition agreement, but you've, in there, it states that the agreement includes a commitment stating the coalition government will reverse measures taken in recent years which have eroded the principle of equal citizenship. The rest of your submission doesn't refer to such a principle. Is it, I just want to be absolutely clear that the Crown is not arguing that the Article 3 equal citizenship issue in some manner is not subject to the tino rangatiratanga guarantee in Article 2.
So that wording is in the coalition agreement. The argument that you've just described is not an argument that the Crown is advancing in this inquiry.
Thank you. I'm probably being pedantic here, Mr. Stevens, bear with me though, but paragraph 13, it may just be an unhappy phrase, I think, that you've used, but I just caught my eye, the exceptions that exist to protect the interests of other users of the Act.
Oh yes, that's...
Just an unhappy phrase.
It is. Users of the Act is an unhappy phrase.
So how would you like to reword that?
The exceptions that exist to protect the interests of others in takutai moana, I think is probably the best way of expressing that.
I think if I've just got a few more matters of substance I wanted to talk to you about. You've put quite an emphasis on, and have used the phraseology, I think, of the original intent being for a rigorous process. I was a practising barrister for about 30-odd years. I never ever was involved in a High Court case that went for longer than about 2 weeks, I think. When you hear witnesses come along today and say that they've been involved in 20 weeks of hearing and they've got 10 more weeks to go, 30 weeks for just one iwi, Ngāti Awa, you couldn't imagine a more rigorous process of litigation, could you?
Those are very long hearings. I agree. And it will reflect, I anticipate, the complexity of the interests at play.
And that was really, most of that, apart from the 10 weeks which they're yet to face, most of that, well, bar 2 weeks in the Court of Appeal, most of it was pre the Court of Appeal decision.
Yes.
So that Māori claimants were undergoing, weren't they, a very rigorous process?
Yes, they were, and I suppose the point that the submission is that process, those processes were unfolding in a world that was prior to the interpretation advanced by the majority of the Court of Appeal. So it is, to accept your point, it has been exacting.
Yeah, all right. At paragraph 12, you referred to the fact that a customary marine title provides an interest in land, and you gave the reference to Section 61A. But the problem is that Section 61B immediately then goes on, doesn't it, to say that those interests are limited to what amounts to a bundle of rights, contained, I think, in Section 62 to about 65. So that the interest in land, in fact, immediately, very next subsection, converts, doesn't it, to a bundle of rights. It's limited.
Yes, I'm just drawing up this section.
Yes. Yeah.
So, Section 62.
Section 61A and then 1B provides the bundle of rights limitation. I'm working off memory, I haven't got it in
Yes,
front
no,
of me.
I'm sorry, this is my ineptitude with the
Yes.
61. Yes, 61, customary, Section 60, subsection 1, customary marine title provides an interest in land, but doesn't include a right to alienate or otherwise dispose of any part of a customary marine title area, and then
B provides only, and the word is only,
yes,
for the exercise of the rights listed in Section 62 and described in Section 66 to 93.
yes.
And we get on to the bundle of rights that you set out in your submissions.
Yes, and so what that section is doing is providing for an interest in land, but as you say, that interest is only the rights listed in Section 62. And I suppose an analogy might be an easement is an interest in land, short of fee simple title, but nonetheless an interest in land. And so interests in land effectively are rights. Property is a bundle of rights in a legal conceptual sense. And so what rights are they? They're the rights in Section 62 and then 66 to 93. So those are interests in land, but they certainly fall short of fee simple title.
Well, they're essentially just permission rights, and the only thing that relates actually to the use of land is actually the ability to access some of the non-crown minerals that might lie on the seabed. Otherwise, they're essentially resource management issues, permission rights for activities or permission rights for conservation or ability to protect waihi tapu.
Waihi tapu is obviously an important feature of that. But
they don't give the ability to use land in any way, because to use, they would have claimants or title holders, if I use that phrase, are going to be in no different position to anybody else, i.e. they are subject to the resource management regime. They have to apply for resource consents.
Yes.
All right. Look, thank you, Mr. Stevens. Those are my questions. Thank you, Judge.
Thank you, Mr. Stevens. I just have some final brief questions, and it's really just following up on what Mr. Crosby raised about the status of the existing awards of customary marine titles. So if I can just ask you to turn back to page 447 of the bundle,
yes,
which shows the map there. And it shows there that there were CMTs awarded for Ngā Hapu o Ngāti Parau. And are you able to clarify for me? I'm afraid it's been some time since I've looked at the Ngāti Parau legislation.
Yes.
Because I'm aware that that is slightly different to the MACA Act. But those awards, was that a result of direct engagement with the Crown or through a High Court judgment?
It's direct engagement from recollection. So I can give you a proper answer. I will include it in the closing submissions, but there is, and you can see in the chronology that there is engagement separately with Ngāti Porou, Ngāti Koata and others who have specific arrangements that required a particular type of engagement from the Crown in relation to these proposed amendments. But
yes,
the best answer is a complete answer, and I'll provide that for you.
Just following on from that, so also under the MACA Act, where there is a recognition agreement with the Crown, it doesn't take effect until it's confirmed in legislation. Is there a similar step required for the Ngāti Porou titles, and has that occurred, or is there a time frame in which that is going to occur?
Excuse me, sir, I'll just get the answer. Yes, so the answer is that there have been direct negotiations. Ultimately, that pathway requires an order in council, and there have been some order in council made in relation to Ngāti Porou, and then there are other there are further negotiations still in train that will also need to be the subject of order in council.
Now, under the MACA Act, the order in council relates to a protected customary right, whereas a CMT requires enacting legislation, but under the Ngāti Porou process, an order in council applies to both?
Yes.
It does, okay. Now, the other awards there all relate to judgments of the High Court, and I'm aware that those judgments have been made. Do you know whether any of those orders have been sealed by the High Court?
I don't know whether they've been sealed.
Would you be able to follow up on that?
Yes, I can.
As well?
I can follow up on that.
It will just be helpful for me in terms of the status of those various awards and how that may wash out in terms of what we are addressing here.
Yes, I'll certainly follow that up, sir. Yes.
Thank you. Well, thank you, Mr. Stevens. We don't have further questions for you, and we've now arrived at the time for the morning break. So we will perhaps adjourn, and then we will reconvene after the break, and we'll hear from Ms. Marsh.
Just before we do break, sir, because I anticipate Ms. Marsh may be some time with questions from my friends and also from the tribunal, I'm going to make an arrangement for her to be able to sit when she gives her evidence, if you're comfortable with that.
Yes, certainly.
Thank you.
Thank you, Council. As noted, we're at the time for the morning break, so we will adjourn and we'll reconvene, I think, at 11 o'clock.
Tēnā koe, sir. Thank you. So the Crown will now call Tui Esme Marsh to give evidence. So what we propose with Ms Marsh is she will give a short mihi and then provide a summary of her evidence that she'll read out. That's been filed with the tribunal. It's so much shorter than her 50 pages, but Ms Marsh hasn't given evidence before, and it would assist the Crown if she could also read her summary, and then she'll, of course, then be available for questions. Kia ora.
Inga mana, inga reo, me ngā tini kāranga rangatanga. Tēnā koutou katoa. E pari ana ngā wai, ngā tai ki hia, e pari ana ngā tai ki tāwhiti nui, ki tāwhiti roa. Ki ngā mate huhu o te motu, koutou kua riro ki te pō, haere. Hoki atu ki te kāinga tūturu mō te tangata, haere, haere, haere hatu rā. Hoki mai ki a tātou, te kānoi ora, e hui nei, mai i tēnei uri o ngā tini hapu o ngā puhi, me te whānau o hene rupe ki te rohe o Ngāti Parau. Tēnā koutou, kāti, tēnā tātou katoa. Aroha mai. Little bit nervous. My name is Tui Esme Marsh. This is a summary of my sworn affidavit dated 19 August 2024. In my affidavit, I explain my role as the Deputy Chief Executive responsible for treaty reconciliation in Taku Taimoana at Te Arawhiti. I am responsible for delivery of the treaty settlement and Taku Taimoana work programs at Te Arawhiti. The purpose of my evidence is to describe the advice Te Arawhiti has provided to the Minister of Treaty of Waitangi Negotiations, Honourable Paul Goldsmith, on the government's policy to give effect to the commitment in the coalition agreement between New Zealand National Party and New Zealand First Party to amend Section 58 of the Marine and Coastal Area Taku Taimoana Act 2011. My evidence addresses the overarching questions in the Tribunal's Statement of Issues and is set out in three parts. First, I provide an explanation of the roles of public service officials in providing advice to ministers and Cabinet who are responsible for decision-making on policy and proposed legislative change under New Zealand's constitutional system. Second, I provide relevant background information to the Crown's proposed amendments to the Act. Third, I explain the policy processes by which officials at Te Arawhiti provided advice to the Minister on options to address the policy problem set by government of clarifying the Court of Appeal's judgment in Re Edwards. I also address the Minister's meetings with seafood industry representatives and the Ngāti Koata Trust Board, both of which I attended with other Te Arawhiti officials. In this summary, I turn straight to the section in my affidavit that discusses the policy work on the proposed amendments to Section 58 of the Act. This is at paragraphs 38 and following of my affidavit. The coalition agreement between National and New Zealand First contained a commitment to amend Section 58 so as to make clear Parliament's original intent in light of the judgment of the Court of Appeal in Re Edwards. The government position is that the courts, in interpreting Section 58, including the Court of Appeal's October 2023 decision in Re Edwards, changed the nature of the test and materially reduced the threshold for the recognition of CMT. The government's concerns about the Court of Appeal's decision in Edwards on CMT align with the basis of the Crown's ongoing appeal to the Supreme Court. The government is looking to legislate to achieve the outcome that the Crown seeks in the Supreme Court and considers that it is better to do so through legislation now. Te Arawhiti is the lead policy advisor on the development of the proposed bill. Cabinet is the decision maker on policy proposals for the bill. It is important to note that the policy proposals are still subject to change during the Cabinet process, and Cabinet has not taken decisions on certain matters relating to the process after the bill is introduced into Parliament. The early stages of the policy development process and the provision of initial advice to the Minister occurred between late December 2023 and the beginning of April 2024. During that period, officials took a review of official records in order to identify appropriate options that would achieve the Parliament's original intent. Noting that it was the Minister's preference to progress the amendment rather than wait for a potential Supreme Court judgment, officials advised at the outset that any amendments to Section 58 would have risks and implications that the Minister would need to consider. The risks included causing further tension in the Māori Crown relationship and the implications for applicant groups who had been awarded CMT determinations and those whose applications were yet to be decided. Officials also advised that as the issue of amendment directly impacted on rights and interests of whānau, hapu, and Māori under the Act, engagement with Māori, particularly applicants, would be crucial to mitigating damage to the Māori Crown relationship. After reviewing official records, in a briefing dated 14 March 2024, officials advised the Minister of Parliament's intent in developing the CMT test. We noted that the Act created a practical regime for the management of the marine and coastal area, taking into account public and Māori interests. Officials advised that this balancing of interests was reflected in the scheme of the Act's operative provisions, its preamble and its purpose provision. The nature of the CMT test was inherently linked to this balancing of rights. In designing the regime, Parliament was aware of the stringency of the test, and this informed which rights would be part of CMT and which would not. Officials advised that the less stringent interpretation of the test arising from Edwards CA might result in CMT being recognised over more of the coastal and marine area than under the previous interpretation. On 19 March 2024, the Minister met with the Deputy Prime Minister and Ministers Seymours, Jones and Portaka to discuss the proposed amendments. Following that meeting, the Minister directed that officials complete the work on Section 58 amendment options to enable legislative amendments to be enacted by the end of 2024. This direction reflected a change in the government's proposed timing for the amending legislation from introduction by the end of the year to enactment by the end of this year. On 11 April 2024, Te Arawhiti provided the Minister with initial options for amending the Act. Officials analysed each option and identified the risks associated with each. We advised that option A, insertion of a declaratory statement to state the purpose of the amendment as overturning aspects of the Edwards CA decision and alter the law as expressed by the Court of Appeal, and option B, insertion of text to define the key concepts of exclusive use and occupation and substantial interruption, consistent with the legislative intent, if progressed together, would have the best prospect of achieving the policy intent and pose the least relationship risk. Officials also identified additional policy issues for the Minister's consideration, which included whether an amendment to Section 58 should be applied retrospectively to applications already determined under Edwards CA. This reference to retrospectivity arose following the Minister raising it with officials shortly before the date of this paper and seeking advice. It was not a matter which officials had previously considered was within the scope of advising the government on how it might meet the coalition government's commitment. Officials had recommended that Section 58 amendments not be applied retrospectively. However, the Minister did not accept that recommendation. The Minister agreed that options A and B together would achieve the objective of the coalition agreement and that Section 58 amendments be applied retrospectively. On 18 April 2024, Te Arawhiti provided the Minister with a first draft of the draft Cabinet paper. The paper set out the Minister's concerns over recognition of large CMT awards. It was his view that it would challenge New Zealanders' expectation that the Act establishes and maintains a durable scheme to ensure the protection of the legitimate interests of all New Zealanders in the marine and coastal area of New Zealand. It also recorded the Minister's view that options A and B, when progressed together, would be most effective in achieving the objective of the coalition agreement, and that Section 58 should be applied retrospectively. On 22 April 2024, I attended a hui with the Minister and other Te Arawhiti officials. At the hui, the Minister expressed concern for the first time that the earlier interpretation by the High Court in Edwards HC and subsequent High Court decisions also went beyond Parliament's original intent. The Minister also indicated his intention to apply the proposed amendments to Section 58 retrospectively, so that CMT awards that had already been granted would be reconsidered under the restored new test. On 27 May 2024, Te Arawhiti provided the Minister with a paper responding to his request for further advice on how the Section 58 test was applied in Edwards HC and whether responding to this and other High Court judgments should be part of the Section 58 proposals, and the risk and appropriateness of applying any changes to Section 58 retrospectively. In the paper, Te Arawhiti officials provided the view that while the High Court decisions prior to Edwards CA focused less on the literal wording of Section 58 and more on Section 58 in the context of the Wider Act than the Crown might have expected, these interpretations and decisions were broadly consistent with the regime set out by Parliament. Accordingly, officials did not consider legislatively setting aside any of the High Court decisions on CMT was necessary to achieve the coalition agreement commitment. Officials also advised the Minister on Parliament's intent around the strictness and nature of the Section 58 test. Officials noted it was the Minister's view of Parliament's intent that the Section 58 test was intended to be a very high threshold to the recognition of CMT, resulting in relatively few and small areas under CMT. However, officials pointed out in the paper that while internal political discussion may have suggested a very stringent test was intended, the body of evidence from the parliamentary record, public statements from legislators at the time, and officials and ministers' statements to the Waitangi Tribunal during the recent Taku Taimoana inquiry indicated that Parliament had a less restrictive intent. Officials also again provided the view that they did not consider there was sufficient justification for retrospective application of any new test. This was based on well-established norms and conventions around retrospectivity and the specific treaty-related context of the Act. In the paper, officials provided an option analysis for amendment to Section 58 and presented the following options. Option A, the existing proposal for a declaratory statement disregarding re-Edwards CA and the definition of key terms in Section 58 to ensure future judgments are more consistent with Parliament's original intent for the nature of the CMT test. Option B, the above, but with the addition of a range of significant changes to the preamble, purpose, and/or Treaty of Waitangi clauses to definitively limit the size and number of customary marine title awards through a higher threshold test. And option C, a broader reform of the Act to make the test and its relationship with the wider Act objective more coherent, as well as considering how to improve existing logistical issues around the cost and process of determining CMT. As to option B, officials advised that these kinds of changes to fundamental aspects of the Act were likely to be seen by Māori as an erosion of the objective and political compromise of the Act that distinguished this Act from the original Foreshore and Seabed Act 2004. It was Te Arawhiti's view that the existing suite of proposals in the first draft Cabinet paper, declaratory statement and defining key terms in Section 58, applied prospectively, was the most appropriate way to fulfil the coalition agreement commitment. That was option A. Ultimately, in conjunction with Cabinet's recent decision not to increase the financial assistance scheme funding for 2024-25, officials noted that wider changes to the regime were likely to be seen as undermining the political compromise central to the Act as an alternative to the Foreshore and Seabed Act 2004. Officials considered that while options B and C might result in a more coherent Act and one consistent with the Minister's aspirations for the regime, the disruption to the takutaimoana process from litigation and dissatisfied applicants could ultimately result in a more costlier and more lengthy outcome. In meeting with officials on the same day, the Minister provided direction on the following options he sought to progress to Cabinet. Option A, specifying sub-options with respect to potential changes to the purpose, treaty provision and preamble, and retrospective application to the Edwards HC and subsequent High Court cases, excluding those that have not been appealed, but seeking Cabinet's views on the issue of retrospectivity. On 5 June, Te Arawhiti provided the Minister with a revised draft Cabinet paper. The paper had been revised to reflect comments made by the Minister at the officials' meeting on 27 May 2024. Revisions included further detail for ministers on rights and interests provided to a group who have been awarded customary marine title, including highlighting that public interest infrastructure is exempted from the resource management permission right of CMT holders. Updating the options to reflect the Minister's preference for option B, the option that includes more extensive overturning of court decisions and amendments to the preamble, purpose, and/or Treaty of Waitangi sections of the Act to allow Section 58 to operate more in line with its literal wording. Expanded discussion on whether the amendment should apply prospectively or retrospectively, and updating proposed timeframes for the passage of amendment legislation, and setting out the consequences of pursuing more fulsome engagement with Māori and other stakeholders and select committee consideration. It was in this paper that the Minister's view that option B should be pursued was reflected. It was his view that changes in option B sought to clearly focus interpretation on the wording of Section 58 by clarifying that the framing elements of the Act did not undermine the literal wording and clear requirements of the CMT test. Option B also involved overturning the High Court's decision in Edwards and subsequent High Court judgments. Overturning these cases would limit their ability to serve as precedents in the future. As to the issue of retrospectivity, the paper recorded the Minister's view that Edwards CA, along with High Court cases that took a similar interpretation, were undermining the policy objective of the legislation. He believed that retrospectivity would bring unduly large awards made on the basis of the Edwards CA interpretation back in line with early awards and his view of Parliament's intention in passing the Act. It was the Minister's view that retrospective application of the Section 58 amendments would ensure all applications, past and future, were decided on the same test. He considered this was important to create a fair and robust approach to recognising customary interests, avoid differential treatment for applications based on when cases were heard and determined by the courts. On 19 June 2024, Te Arawhiti provided the Minister with a final Cabinet paper. In the paper, the Minister noted the risks associated with the broad policy options A to C, but stated that these had been considered alongside the consequences of doing nothing. In recommending option B, he relied on the following. The bundle of rights included with CMT is premised on CMT being awarded only where applications meet the full criteria set out in Section 58. Large and more awards of CMT on the basis of the lower threshold test established in Edwards CA may result in significant portions of coastline falling under CMT. The increased difficulty of getting resource consents across a large portion of the coastline would challenge New Zealanders' expectations that the Act protects the legitimate interests of all New Zealanders in the common marine and coastal area of New Zealand. In discussing whether the amended test should be applied prospectively or retrospectively, the Minister noted that both options A and B have retrospective elements. The Minister presented three options around retrospective application of the restored test for Cabinet's decision. These were: the amended Section 58 test should be applied prospectively with appropriate transitional arrangements for applications currently in process. The amended Section 58 test should be applied retrospectively to decisions relating to CMT made by the Court in the period between and including Edwards HC and the proposed amendment coming into force, requiring these decisions to be reheard under the amended test with the exception of those existing decisions that have not been appealed. The amended Section 58 test, option C, the amended Section 58 test should be applied retrospectively to decisions relating to CMT made by the Court since Edwards CA, thereby preserving the earlier awards so that applicant groups receive the fruits of their litigation. Rec 9.3. The Cabinet paper was then submitted to the Cabinet Economic Policy Committee on 26 June 2024 in a minute dated 1 July 2024 following reference from the Cabinet Economic Policy Commitment, Cabinet deferred consideration of the Cabinet paper until 8 July 2024 and invited the Minister to submit a revised paper for consideration. On 1 July 2024, the Minister met with officials where the Minister proposed an additional retrospectivity option for consideration. In the meeting, the Minister also requested further information regarding the current and upcoming cases that had applied for CMT and the impacts of retrospectivity on those cases. Officials understood that ECO and Cabinet had requested this information and that this is why Cabinet deferred its decisions on 1 July 2024. On 2 July 2024, Te Arawhiti provided the Minister with an aid memoir containing an additional option for retrospectivity. The additional option was generally prospective in that any judgments that had already been issued would stand, but it used the announcement of the policy as the date after which all future judgments would need to be under the restored test rather than the commencement date of the legislation. Officials advised that the consequence of this option was that cases that were in hearings or where judgment was pending at the time of the announcement would need to be reheard, and that there were 5 cases expected to be in this situation. The Minister's Cabinet paper was revised to include an additional option for retrospective application of the restored test. On 8 July, Cabinet made initial decisions regarding the government's intention to introduce to the House legislation to clarify Section 58 of the Act. Cabinet agreed to amend the Act by inserting a declaratory statement that overturns the reasoning of the Court of Appeal and High Court in Edwards and all High Court decisions since the High Court in Edwards, where they relate to the test for CMT. Adding text to Section 58 to define and clarify the terms exclusive use and occupation and substantial interruption. Amending the burden of proof section of the Act, Section 106, to clarify that applicant groups are required to prove exclusive use and occupation from 1840 to the present day, and making changes to the effect of the preamble, purpose and Treaty of Waitangi sections of the Act to make it clearer the relationship between the sections and Section 58 in a way that allows Section 58 to operate more in line with its literal wording. Among other things, Cabinet also agreed that the amended Section 58 test should be applied from the point of announcement of the policy change, noting that this would leave existing customary marine title decisions as at the date of announcement as they were, but require rehearing of any live cases that did not have decisions at the time of announcement, subject to detailed work on transitional arrangements during drafting. Cabinet also decided to undertake consultation with applicants over a 2 to 3 week period. The Minister accordingly acted on that decision and through officials has undertaken a 3-week consultation period between 25 July 2024 and 15 August 2024. Officials will provide advice to the Minister on applicant responses prior to him returning to Cabinet in mid-September. Nearly there. I believe it is clear from the consistent advice from officials to the Minister and the Minister's advice to his colleagues in the Cabinet paper that any changes to Section 58 would be seen negatively by applicants and be likely to damage the Māori Crown relationship. The fact of this inquiry and the very significant number of claimants and interested parties confirms that assessment. I acknowledge the claimants have in their evidence expressed consistent and strong concerns and mamai about the proposed amendments to Section 58 of the Act, the nature and constraints of the consultation process, and the changes to the financial assistance scheme. It is important that claimants have spoken and will speak to their own concerns and mamai, but I do wish to acknowledge that most applicants will be affected by the proposed amendments to Section 58 of the Act, but some more than others. All applicants have experienced the following frustrations and demonstrated huge patience. The Act, which created the framework for legal recognition of CMT and PCR, was enacted 13 years ago. The deadline for lodging applications was April 2007, more than 7 years ago. It has taken a considerable period of time for applications in either pathway to materially progress, and indeed the court pathway has to date proven to be quicker. Even with the previous iteration of the financial assistance scheme, many applicants have incurred significant legal and other costs to prepare their applications. Ka whakamanoa ahau i ngā whakaaro nui ki te hunga tū nohu, e rātou tonu e whakatakotohia ketia ngā taunakitanga ki te uiuinga 2660. For those applicants who, as at 25 July 2024, are awaiting judgments, or whose applications are part heard, or whose Crown engagement pathway applications are most advanced, I acknowledge that you are the most impacted by Cabinet's decisions to propose retrospective legislation. Your evidence about the vulnerability of your tikanga evidence is understood. There are also applicants and cases given priority under Section 125 of the Act because they applied under the Foreshore and Seabed Act 2004, so have been waiting even longer just to have their applications considered by the High Court, let alone determined. Finally, it has been helpful for the Crown to read the evidence of some claimants, even where whānau or hapu have received CMT awards, that the way in which the courts have understandably divided their hearings into stages means that some applicant groups within the same iwi have applied for and received CMT under the current test, while others in that iwi and whanaunga yet to be heard will, if Parliament enacts the proposed amendments, be considered under a more stringent test. Those claimants are telling the Crown that this potential for different outcomes could create internal strains. Any submissions received through the consultation process for the proposed Section 58 amendments received by Te Arawhiti will be summarised for consideration by the Minister before he returns to Cabinet for the alleged paper, as will the claimant's evidence to this tribunal inquiry. Te Arawhiti will brief the Minister on any findings and recommendations the tribunal may make in this inquiry. However, decisions on whether to accept or act on any recommendations can only be made by the Minister, who will advise his Cabinet colleagues.
So thank you, Ms. Marsh. My friends will now have questions for you, so if you could remain there or take a seat when you feel you want to, in order to answer their questions and also any questions from the tribunal. Kia ora.
I just organise myself a little better.
Tēnā koe, Ms. Marsh.
Tēnā koe.
My name is Lyle, and just so that you know who I'm here to represent today, my clients are Te Pukerehi Iwi, who were one of the applicants involved in the Re Edwards Whakatohia applications and will be appearing in the Supreme Court in November. Te Raiahu Whenua Trust and the Panaho Whānau, who are applicants who had their application entirely heard in the Whangarei Harbour. Ngā whānau hapu o Te Aitanga Rahauati, who are a group seeking engagement presently with the Crown. Ngā Te Pirauki Hauraki, who sought to engage under the Foreshore and Seabed Act many years ago, and their engagement application was transferred across into the Marine and Coastal Area Act, and Tiwi o Te Rorua, who are seeking to engage directly with the Crown. I also represent two interested parties, Heta Koko for Te Rohina Marae and Hapu, who are seeking direct engagement, and William Tauaki for Ngāti Tamarangi, who is one of the applicants which has been part heard in the Kapiti Coast. So the questions that I'm asking are on their behalf, but I'm also going to be asking some more general questions on behalf of all claimants as we move through. So my first questions are about you, so forgive me for that. But you've said you've been a public servant since 2000, and you would agree that public servants are required to act in a politically neutral manner?
I would.
Are you a, sorry, forgive me, but do you have a tertiary qualification or a...
I do. I have a Master's in Public Administration.
Ka pai. So you're not a lawyer by training or
No.
a historian by training? Ka pai. I'm interested in your role as Deputy Chief Executive. It's a little opaque for those of us on the outside. Are you able to give us more of an idea about what your role entails specifically at Te Arawhiti?
So, as I described in my affidavit, it is for, I have responsibility for the delivery of the work programs, both treaty settlements and taku taimoana.
And are you personally...
Ultimately, I'm not the decision maker, but that's my role at Te Arawhiti.
And are you personally involved in policy development, that side of things, or are you more focused on management of that process?
In this matter, I was closer to this matter than what may be the norm, given the significance of the kaupapa.
You've said that you're authorised to provide this affidavit for Te Arawhiti, but
I am.
would I be correct to say that the brief of evidence is the result of a team effort? It's not something that you've put together
That
as
would
an
be
individual?
fair.
Are you able to confirm who assisted in drafting it?
In drafting
Your evidence?
the summary,
No, for the affidavit that you've prepared for this inquiry.
our legal team and part of the core team that's been working on the policy changes on the amendments.
I know you've been at Te Arawhiti since January 2022, but as the background that you've set out in your affidavit confirms, Te Arawhiti is well aware of the long history that lies behind the issues that this tribunal is hearing, including 3 Waitangi Tribunal reports, a ministerial review panel report, various court decisions, and so on. So there's a high level of institutional knowledge about the issues at Te Arawhiti. Would that be right?
Yes.
So to put that, I guess another way, the guide rails that should govern Crown conduct in this space have been made clear long ago. Do you agree with that statement?
Could you clarify that, please? What you mean by that?
What I mean by the guide rails So the parameters of acceptable Crown conduct in the space when they deal with things like takutai moana ought to have been made clear long ago and well understood at Te Arawhiti.
I think they have been made clear, and I think that Te Arawhiti has a understanding of that.
So what I'm going to do now is work through the documents in a chronological way, and I think very much skim across the surface of some of them to give us an idea of the steps that have been taken. So at your paragraph 49 of your affidavit, you say the starting point was that there was no detail about parliamentary intent or direct criticisms. So policy direction was sought from the Minister. So this is the very start of the Te Arawhiti coming to grips with the coalition agreement and trying to work out what future actions would be. Are you with me there?
Paragraph 49.
Aye. So was it at this point that Te Arawhiti decided to go out and track down what its view of parliamentary intent was?
At what point, sorry?
The point prior to the 21 December paper being prepared. Perhaps if we... So at 49 you say, it was therefore important for Te Arawhiti to ensure its first briefing that it obtained sufficient policy direction from the Minister. So prior to that first briefing, was there work undertaken at Te Arawhiti to go out and try to work out what that parliamentary intent might mean?
There was. We're required to be familiar with the coalition agreements and to put in place processes to implement those. So we had made ourselves familiar with that, and we had begun to work through what that might look like and to enable us to identify appropriate policy options. And important to that was the original intention.
So the first major document that we have is the 21 December document, and I'm not sure whether you have access to a common bundle.
I've got the full copy.
It might be helpful. I do wonder if it might be brought up on screen as we move through, if that's at all possible. Probably not so necessary for this document, but for some of the later ones it might be helpful.
Oh, I might not the best thing.
Mr. Lyle, when you're referring to that common bundle, could you refer to the page numbers for us?
Absolutely, sir. So I'm going to be starting on page 1. That's it. Seemed a good pace to kick off. So just take some time to get set and perhaps give me a nod when you're all set up.
Kia mihi. Kia ora.
Kia ora. So we were discussing the 21 December document, and I'm now looking at page 2. And the top of page 2, under purpose, we have it recorded that the context, scope, process and timing for amending section 58 of the MACA Act as set out in the National and New Zealand First Coalition Agreement, and then it records the action point from that agreement beginning with amend section 58. The heading to that section of the coalition agreement, to reverse measures taken in recent years which have eroded the principle of equal citizenship, is not mentioned there.
I'm sorry to interrupt, Mr. Lyle. I've just had a request from behind me whether you could move the mic closer because the people behind me are having difficulty hearing you. Thank you very much.
I can probably try to speak up a touch too. So just I've just read through paragraph 1 and noted that that statement which caps all of the action points in the coalition agreement about reversing measures which have eroded the principle of equal citizenship is not mentioned there. Would you agree with me that as a result the advice focuses on original intent, but we don't see advice to the Minister on what Te Arawhiti thinks about equal citizenship or this principle of equal citizenship?
Yes, I would agree that the advice focuses on, or this work focused on, identifying original intent and not on equal citizenship.
And there was no process undertaken by Te Arawhiti in a manner akin to original intent to go out and consult documents and try to work out what was meant by that principle of equal citizenship statement?
Not to my knowledge.
And that, so from this moment, this point in 21 December onwards, that equal citizenship principle is absent from the analysis undertaken by Te Arawhiti. Would you agree with that?
Yes.
Down the page under background, there's a subheading Parliament's intent. And it says we will continue to review the official records such as parliamentary debates and the then government's public statements. What did that process actually entail? How many people were working on it, for instance?
From recall, a core team of 3 or 4. One who had had been around at the time of the Act coming into being.
And did that core group have a terms of reference or a task set out, or were they, I guess on the other hand, just sent out to cast a wide net and report back what they found?
I think it's the latter. I don't recall a formal terms of reference.
And we know from the bottom of this page that the Crown closing submissions and the Y2660 were one of the documents that must have been identified there, and because they're quoted. If we turn the page, we're into a quote by the then Minister Finlayson, which is set out in full. And so this is the top of page 3. I don't really want to make too much of this, but there is some underlining and handwriting. Can you confirm if that's the Minister's handwriting?
It is.
And he's underlined specific sections there, including the tests for customary marine title are strong ones, and noted the intent is clear. As I've said, I don't want to make too much of that, but would you agree with me that that does indicate a fixed position on what intent means from the Minister at this stage?
It indicates, and he communicated that's his view. That was his view at that time.
If we look down to paragraph 9 on the same page, this is under the heading Court of Appeal decision in Re Edwards. It has Te Arawhiti's view that CMT ignores the requirement in section 58 for applicant groups to have exclusively used and occupied a marine area from 1840 to the present day. I think I'm at risk of getting into legal questions if I push too hard on that, but I will ask if Te Arawhiti would accept that that's something on which reasonable people can take differing views. So
Reasonable people can take differing views on several things, lots of things.
And we don't have evidence that Te Arawhiti in this document or other documents gave advice that the approach of the Court of Appeal was one that was available to the court, would be considered orthodox by many people, those sorts of considerations.
Sorry, I don't really understand your statement.
So here we have Te Arawhiti saying very clearly that the Court of Appeal ignores the requirement in Section 58. There's no neutral and balanced advice to counteract that, is it, saying other people may take a different view? Well, are you able to point me to any advice that takes a contrary view?
To that?
Aye.
No.
Then at 11, we have the statement which has been referred to already, the coalition agreement wording and the reasons for the Attorney-General seeking leave to appeal the Court of Appeal's judgment appears to be consistent. That's, well, in seeking to bring those two together, the appeal and the actions sought under the coalition agreement, was it Te Arawhiti's view that in taking its appeal, the Crown was seeking to reverse measures taken in recent years which have eroded the principle of equal citizenship?
Can you repeat that, please?
In taking the appeal, or seeking an appeal in the Supreme Court, there was no mention of this principle of equal citizenship on the Crown's part, was there?
I'm not aware of this. It's a matter that I can't answer.
And would you agree with me that in seeking to show equivalency between the appeal sought in the Supreme Court and what was sought under the coalition agreement, Te Arawhiti was putting its thumb on the scales in favour of those amendments taking place?
I can't answer that question. I personally not been involved. Sorry, we provided no. I wasn't part of any discussions around this matter.
If we move to page 5 of this document, we've got a process and timing section here at 20, noting that engagement will be needed on the policy and legislative process as the issue directly impacts on the rights and interests of Māori. I'm interested in this phrase, engagement with Māori, particularly applicants, will also be crucial to mitigating damage to the Māori Crown relationship. Do you agree with me that the word mitigating would suggest that Te Arawhiti contemplated some damage was unavoidable to that relationship in taking these amendments?
Yes.
If we look down the page there to 26, the top line, this is in reference to the High Court pathway. It says, we anticipate the High Court may encounter difficulties in applying the majority's interpretation of exclusive use and occupation. Do you know what difficulties means in that context?
No, I don't.
And would you agree with me that that's entirely speculative at that point?
I don't have an answer to that.
It also says there that the Attorney-General will continue to participate in High Court hearings to assist the court in its interpretation of the law and provide evidence of third-party interests in the relevant application areas. Again, I think I'm in danger of straying into more legal issues, but rather than just being there to represent those third-party interests, you'd agree that it's important that the Crown appears in the public interest on behalf of all Aotearoans, wouldn't you?
Yes.
And Māori, of course, make up a significant and today vocal group, part of that broader group,
Aira.
don't they? Aye. Now on the 30th of January, so we're moving on from our December document now, the hui was held with the minister, and at that hui we have the table, which just find our page number in the common bundle for that. Table at 27 of the common bundle.
No, because it doesn't bring the full
I do have a
context.
wonder if I could up Yep. This is the witness.
Just go with that.
So my understanding is that this table represents the culmination of the work that Te Arawhiti had been taking place at Te Arawhiti, and then based on the advice received on the last paper, we arrive at basically what's set out in this table as a broad summary. Is that the circumstances as to how this came to be prepared?
So this is a summary. This is us preparing a discussion document for the minister to have a discussion around approach, timing and scope. So the early discussions around that. We needed some decisions, of course, from the minister so that we could provide him with further advice to progress the mahi.
Now on the bottom of this table, as appears in the bundle, there's handwriting once again, and do I assume that's also the minister's handwriting?
It is.
Right. My reading of that handwriting, and correct me if I'm going astray, but for the record, I see this has led to real concerns that most of the coastline will fall into customary ownership and hugely expensive process to determine overlapping claims, plus real concern for expectations of New Zealand to have equal say in, and I can't quite make out the last part, but in what happens might be the... So I'm gonna come back to that in 1 second, but starting on the far left of the table, we have what was Parliament's intent. So you've said that this is a discussion document, but here we have some firmly phrased conclusions about Te Arawhiti's view on parliamentary intent, don't we?
We have brought together what this is a result of the review, noting that the review was still ongoing. So as I said, the purpose of the summary was to outline clearly, the issues and to gain advice from the minister. Oh, I do, sorry. It does not fit without this because this has the questions under it. It shows the purpose of A3.
So I'm being asked about the A3 table that you're discussing with the witness that's in the common bundle.
Right.
And the witness has another document that looks like the A3 table but is not the same.
It includes what is the scope of the review. As I said, the document was to gain a clearer sense of the Minister's direction around timing, approach and scope. And so this document was prepared for that purpose, to discuss with him at officials.
So just to work out where we are.
It speaks to what is the scope. It asks questions and it seeks a decision from the Minister.
And so
The old version.
The questions are missing. Questions are missing from this version.
So I've got the version that has the handwriting on the bottom, which is possibly a different.
yes, so it's just been drawn to my attention that the version that Ms. Marsh is referring to, has in front of her, the original, is at 529 of the common bundle and 530. And so that is what she's referring to. So it's not it is a document that's been supplied. It's not currently the document that you're asking about, but that is the one that she's referring to. And so it may be worth clarifying with the witness, if I may suggest this, what 529 and 530 are and when that was created.
Yes. So I'm referring to the document which was attached to the aid memoir on the 29th of February 2024 at the moment. And for the purposes of my questions, I think we're best to stick with that as we skip across the narrative. But
I'll come back to it in re-examination to clarify if you don't. That's the easiest way to deal with it, probably.
I'm not sure if you quickly can clarify when this document was prepared or circulated, or because it doesn't appear to be the one that was presented to the Minister at the hui that we're discussing, does it?
My understanding is that, I know the one that you're discussing, a version of that was attached to the letters that were to go to the Prime Minister and other ministers. This is the version that we discussed with the Minister at the meeting on the 20th of January, seeking his direction, hence why the questions are included on the A3.
I think for the purposes of my questions, it's not going to make too much difference which version we look at, because I'm interested in the
Well, it does. It does, because one is before we had the Minister's direction.
Okay, well, let's focus in on the copy that's attached to the 29 February aid memoir, which is the one that you have in front of you. So you've said that this is a discussion paper for the purposes of the hui, and I've put to you that the statements around parliamentary intent seem to be fairly conclusive statements rather than something that's up for discussion. Do you agree with me on that?
They are a reflection at that stage of our review.
The next bubble or list to the right in the centre of this diagram, what is the problem we are trying to solve? And there we go straight to saying that the Court of Appeal did not interpret Section 58 consistent with Parliament's original intent. There's some specific factors listed, and then it says the Court reached this interpretation by focusing on the Act's purpose and treaty provision rather than the literal text of Section 58. Would you accept my proposition that Te Arawhiti can't adequately address the problem that they are trying to solve if they don't also take this concept of equality or principle of equal citizenship into account? So this misstates the problem that the Minister is trying to solve?
What I can say about that box is that was a response to our question to the Minister to confirm that this is the problem and the objective that the government intends to address.
And do we have the question that was put to the Minister and his response in the discovery documents that were provided?
Sorry?
You've said that you put a question to the Minister about the problem that you were trying to solve and his response.
In the A3 when we were seeking direction at the 20
So it was
January
in the
meeting. It's on the A3.
So this is where the Minister asks for more when we're looking at the factors that the Court of Appeal, Te Arawhiti says, got wrong.
No, not from recall. We're still very early. The Minister, we are still working with the Minister on scope, process, timing, approach.
Right. So just
Noting that he has coalition partners that are party to this agreement, and he is wanting to canvass them on that approach and the scope and the process, given it is a coalition agreement.
So just to re-put the question for clarity, here we have the table that I've handed up in A3. We've got the what is the problem we're trying to solve section. And we have a line drawn down to a bubble where the Minister's asking for more in that section. So he's asking you to bolster the case against the Court of Appeal in effect. Would you agree with that?
Yes. No, sorry, would you answer that again? What I agree with is that's the Minister's comments. That's the direction that he's giving us.
And the direction is to bolster the case against the Court of Appeal.
It's to add, this has led to a real probability that most of the coast will fall into, sorry, I can't read some of the comment that is made there. He's asking us to add that.
And does this give Te Arawhiti any concern about neutrality when you're being asked to specifically focus on what the court got wrong?
The Minister's politician, we're public servants, and we hold to political neutrality.
And I think before we move on from this document, just to note that I think this is the first articulation of the proposed options which may be available, including the declaratory statement and definition of terms. So is that something that Te Arawhiti worked through, presumably with your legal team, and landed on prior to this hui taking place?
Yes.
And did you seek outside advice prior to that point?
Is that a question about legal advice?
Yeah.
Well, ka pai. No, I'll accept that then. Just noting the objection. You'll forgive me, but on documents that we have these options arriving almost from a vacuum. But I think I'll leave it to my learned friends to dig into the detail on that one as we skip across the top of the issues. As we go through, I'm going to note the dates that the various High Court applications started and ended within the chronology that you've set out. So after the hui that was held with the Minister, where you took feedback on this paper, but before the next document, which is 29 of February, We had the Whangarei Harbour hearing beginning on the 12th of February and running to the 7th of May. So there we have applicants heading off to court in good faith while these changes were being prepared in the absence of the applicants. So we can agree on that, can't we?
Sorry, can you ask that question again?
We can agree that applicants are heading off to court, investing their time and resources while these decisions are being taken in the background in the absence of the applicants.
Are the decisions that have been made around the work we are discussing, process, scope? There are no firm decisions around the changes.
Now, the next paper I'd like to take you to is the 14th of March briefing, which is Common Bundle 28. If we turn to page 32 of that document.
Paragraph number, please.
Paragraph 18. So there we're talking about the impact of the Court of Appeal's decision in Edwards. And it says, because each application is considered on a case-by-case basis, we can't know what the implication will be in any particular case. So you'd agree it's not a certainty that the Court of Appeal decision would have changed the approach to subsequent applications.
I agree that because each application is considered on a case-by-case basis, we can't know what the implication will be of any particular case.
And at 19 it says, there is a concern that the potential implications of recognition of customary marine title over a larger amount of the marine and coastal area than previously anticipated will have an impact on New Zealanders' expectation of having an equal say over the management and use of the coastline as originally intended by the Act. Shouldn't that read the Minister's concern is?
Could read the Minister's concern.
And it strikes me that otherwise this is giving, I guess, broader applicability to a concern that's been expressed by the Minister, possibly creating a problem that then needs to be gone out and solved by phrasing it in this way. Would you agree with that?
No, what I agree, no I don't. What I agree with is that we're doing work to meet the coalition agreement. And we're providing the best possible information and advice that we can along the way.
I think some of the next sections are probably best left to legal submission in this document, but if we do turn to 34 of the Common Bundle, there's a section on process and timing. So just trying to nail down what happened when. There it says introduce the amendment bill by the end of 2024. Is that the first time that that expectation had been confirmed with Te Arawhiti?
At that time, back to the A3 where we were having discussion. Sorry, can you point me to the exact?
It's on page 34.
Can I have a paragraph, please?
Paragraph 29 has 3 bullet points.
Sorry.
And the third bullet point says, well, based on relatively straightforward technical amendments, the intention was to introduce the amendment bill by the end of 2024.
And your question is, sorry?
So was that the first time that date or time frame was set down in a document, to your knowledge?
In a document.
And I think we can both agree that the amendments as they stand aren't straightforward and non-technical, are they?
No, they are not.
No. We'll circle back around to that. I think we'll move to the 11th of April paper, which is page 56 of the Common Bundle. If we can turn to page 61, please.
Paragraph, please.
So this is paragraph 25. So again, we're trying to nail down what happened when, and to me this is the first time that the 4 options have been set out in detail in the papers. Is that your understanding? 11 April?
That's my understanding.
If we turn to page 63.
Sorry, my pages differ from yours, so it'd be
So
helpful
paragraph
for paragraph.
35. Now we've discussed, I think these have come up in evidence and discussion already, the 3 paragraphs 35 to 37. But I did want to note the statements, for instance, at 36, amendments to the legislation are likely to attract criticism, possibly of a magnitude. This is all very passive language, wouldn't you say?
It's not as direct
And,
as possibly could be.
and do you agree with me that that understates the possible effect as a result?
I think that consistently throughout the process, the policy development process, and it can be seen in several documents, that Te Arawhiti raised the risk of implementing the amendments and the impact on the applicants, not only the applicants, but wider Māori. And I think that the documents show that we did that consistently.
Well, we say that, but then at 37, the consideration is that options A and B pose the least redacted relationship risk. Wouldn't an option to do nothing be the one that poses the least relationship risk, and shouldn't that have been maintained throughout the advice given?
I'll take you back to the coalition agreement and Te Arawhiti's role to put in place processes to implement that.
And that wouldn't stop Te Arawhiti from including in advice, even a standard clause that reminds the Minister that the steps that you are recommending are likely to be fraught and likely to breach Te Tiriti o Waitangi and best practice would, and so on and so on.
I think that we have consistently done that through raising in a number of places throughout the process. You will see those that raised as risks and the implications of implementing the amendments.
And it's not raised here, however, is it? Sorry, it is being, there's a transcript being prepared, so we need an oral answer to the questions.
What's how you read that?
So
Yeah.
it's not
I
raised
read,
here.
we, as I said to you, we consistently provided the Minister with advice around the risks and implications of implementing the amendments.
Now below this on the same page, 63, under other issues, there's the issue raised of whether an amendment should be applied retrospectively to applications already determined under the Rear Edwards Court of Appeal decision. Now the next page where it goes on to discuss that is redacted entirely, so we don't know what was actually said there. But I did want to nail down that that appears to be the first time that retrospectivity and that framework was raised in the documents. So we're at 11 April when that came up. Is that your understanding?
That is my understanding.
And probably belaboring the point, but if we turn to page 66 briefly, and I'm at paragraph 57, there's a section, engagement with Māori. Now there it records that previous advice conveyed that good faith engagement with Māori on the government's proposals is necessary to meet Treaty of Waitangi obligations, and a fulsome and meaningful engagement process is important. And if we turn the page to 67, paragraph 59, it begins, at a maximum the above time frame could allow for 2 to 3 weeks targeted engagement. Those two things can't be reconciled, can they? 2 to 3 weeks can't be a fulsome engagement period, can it?
No, and we are in yet the earlier paragraph highlighting the importance of a fulsome and meaningful process with the Minister.
There's no recommendation here that more time be provided.
We are now working within confirmation, I think it was, of enactment by the end of the year. We are looking for consultation opportunities within that compressed timeframe.
I wonder if we could bring up CB 398, please. CB 398, yes, thank you. And if you could scroll down a little. So this is an email from Nicole Butler. Could you confirm who she is?
Pardon?
Could you confirm who Nicole Butler is for the...
Nicole Butler is the principal advisor in the Takutai Moana.
And Tim Fields?
He's a project manager.
And you'll see this is an email sent Wednesday the 31st of July of this year. It's at the top of the page. Oh, sorry, apologies. This is an email sent the 23rd of April of this year, but then forwarded on once again. So this email references a hui that was held the day before with the minister, where, as you've noted, he first expressed his concern that they weren't going far enough by only addressing the Court of Appeal judgment. What I did want to raise is, it's noted here that the Minister noted there were high stakes and we need to take the time necessary to ensure that it's robust and defensible, not a rush job that falls over. Do you see that there?
Yes.
So the issue I want to raise with you is that it appears to the claimants that time is being taken to set up this new regime in a way that won't be able to be unpicked, to the detriment of claimants who then have very limited time to respond to it. So I guess that's inaptly put. Do you agree with me that the Crown there is using the fact that applicants have no detail of the amendments at the time to create enduring changes that can't be undone?
I don't quite understand your question.
So the Crown is prepared to take the time necessary to make changes, ensure the changes are enduring. That's what that sentence says, in effect, isn't it?
I think, well, my take on that sentence is the 2 bullet points raised by the Minister need careful consideration, given their implications.
And what implications are those in your view?
Well, anything around the High Court judgments would surely warrant careful consideration and the overturning of those.
And do you see the flip side there, that there's an injustice in not also allowing applicants to have that same period for consideration?
I could see how you could read that.
Now, on the 10th of May, the LDAC advice was received. Are you familiar with the letter that was received from that group?
Sorry, I'm not familiar with the contents of it. Like the detailed content, I cannot recall that.
Well, we might bring it up just so we can orientate ourselves. So it's at page 49 of the Common Bundle. And the parts that are unredacted, and I'm looking at paragraphs 8 and 10 in particular, I think, would you agree broadly with me that LDAC considered that parliamentary intent was not a helpful articulation of a policy objective?
Sorry, are you reading paragraph 8?
At paragraph 8, I'm summarising in effect so that we can move forward with a shared understanding of what LDAC said.
This is LDAC's advice, so I'd assume that's what they think.
No. And they've said at 10 that legislating in this way doesn't restore Parliament's intent, it changes the law as it currently exists. So I'm gonna come back to that, and that's the purpose of taking you there, to make sure that we've seen it. But in the meantime, we have the Kapiti Coast hearing beginning on the 13th of May, which is shortly after that LDAC advice was received, and shortly before the 21 May hui with the seafood industry representatives. who were participants in that hearing. I think for my purposes, I'm going to leave the detail of the seafood industry representatives hui, the Ngāti Kuata hui, to my learned friends to cover off in detail, so I'm just mentioning the fact of them. There was a third hui that took place. The minister wasn't there, but you personally met with Te Rorua iwi on the 24th of May. Do you recall
With yourself?
that? Aye.
I do.
And have you read the evidence that Alex Nathan has prepared for this inquiry, which is document A1?
No, I've read the summary.
He says that Te Arawhiti could tell the group nothing about the amendments beyond the fact that advice had been prepared on changing the definitions of exclusivity and substantial interruption. Does that accord with your recall of the hui?
Alex is, and respectfully, that's his take. Sharing information on proposals other than what is contained in the coalition agreement. So whatever Alex, sorry, and respectfully, his take is his take.
Sorry, you were saying sharing information beyond what's in the coalition agreement?
That things where decisions have not been made by the minister and we don't have sanction to communicate those. Sorry, maybe you clarify your question and then I'll be able to answer.
Sorry, Mr. Lyle, would it be
better.
possible to bring up the evidence, just so it's clear to Ms. Marsh
Sure, if we
what she's being asked to comment on?
could please bring up document A1.
Okay.
I'm looking at paragraph 12. So if you could give me a nod once you've had time to review that. So I was really just wanting to get at the fact that while Te Rorua, as you've rightly said, may have been inappropriate to reveal further information that wasn't subject to ministerial decision, that's exactly what was revealed at that hui with the seafood industry representatives only days before, wasn't it?
The rest of the paragraph is my recall. I do not recall Te Arawhiti could tell us nothing beyond the fact that they had prepared advice on changing the definitions of exclusivity and substantial interruption. No further information was put forward.
So that's what he said, and the Crown hasn't sought to challenge that evidence through cross-examination. So
his take.
Your Honour, I know we're at the break, so I'll do some triage of questions over the break and we'll come back.
Thank you, Mr. Lyle. Just before we adjourn for lunch, I also would just like some clarification on the updated cross-examination order that has been provided, because I see that not only has the order been updated, so too have the time estimates, and it seems that they have been increased rather significantly. Are you able to provide me with some assistance on that?
I think, Your Honour, where there has been an increase, it's been reflected in a decrease in those that aren't seeking to question, which are listed at the bottom of the
Do you have the updated estimate order in front of you?
I can bring it up, sir. I do now, sir.
We have the first tranche of questions with individual estimates. So by my calculation, that's a total of 305 minutes. The second tranche, I'm just a little bit unclear. Is it being proposed that those in the second tranche are not asking questions because there is now being further time taken in the first tranche?
That's the plan, sir. Yes, they've indicated that either they'll pass questions directly to those that are taking more time, or they won't seek to, or they anticipate their questions will have been asked and answered. So
I see. So it's not being proposed that there will be questions for both the first tranche and the second tranche for those time estimates. Okay. That does still increase the time estimates somewhat, but not as much. So hopefully we can simply manage that and see how we go.
I'm a humble messenger, sir. So.
Okay. Well, yes, we'll just keep track of that and see how things go. But thank you, Ms. Marsh, for the evidence that you have presented so far.
Mr. Stevens and Ms. Marsh, just over the luncheon break, just to save time when I get to ask questions, could you have a look at the Legislation Design and Advisory Committee paper at page 50 of the Common Bundle, and at paragraph 11 there's a reference to paragraph 28 of the draft Cabinet paper, and I just want to be absolutely clear with the page reference number on the Common Bundle, which is that draft Cabinet paper that's referred to.
Thank you. I'll do that. I do just want to clarify the Tribunal's expectations about Ms. Marsh and the extent to which she can talk to anybody about her evidence. I know she's under cross-examination, and in a court scenario, she would not be permitted to speak to anybody about her evidence now. So I wanted to clarify the Tribunal's expectations in that regard, and including discussing with her that question.
Well, generally, Mr. Stevens, the same approach applies. Given that Mr. Crosby is asking you to specifically raise that with the witness, I don't have an issue with that. I think if there were additional matters that you wanted to discuss with Ms. Marsh while she's under the cone of cross-examination, then I'd need some further clarity about what you're wanting to raise with her.
Yes, and there is nothing that I wish to raise.
Okay.
I just wanted to make that clear
Yes.
for everybody's benefit.
Thank you. Thank you, Mr. Stevens. Okay. Well, thank you again, and we will adjourn for lunch and we'll reconvene at 1:30.
There you go.
Kia ora, sir. My learned friend, Mr. Irwin, with your leave, would like to address the panel before I start again, if that's possible.
Kāti e te kaiwhakawā e te rōpu whakamani te tiriti tēnā rau atu, koe te kaiwhakawā o tira koutou o te poari. Now, pardon the interruption, Your Honour. Earlier today I filed a memorandum or application seeking leave to appear on behalf of the Ngāti Koata Trust. And it's for that reason that I stand here today, just to seek Your Honour's leave to appear as an interested party. The Ngāti Koata Trust became aware very late yesterday through the media that a meeting it's held with the Minister has become a part of the documents and the evidence of this proceeding, and for that reason it wishes to join as an interested party. Your Honour, I don't see this would have any change to the timetable for this hearing, far from it. The chances are my capacity here will be that of a watching brief. But we'd like to take stock of the situation. We're still coming up to speed with this proceeding. May be the case that we'd have a few questions for Ms. Marsh tomorrow. But if that were the case, those questions would be brief.
Thank you, Mr. Irwin. I am happy to grant Ngāti Koata interested party status. What I can't confirm at this stage is whether there will be time available to question Ms. Marsh. We do have a compressed timetable that we're working to at the moment, and of course I'm aware from your memorandum that your clients have only recently learnt of this issue, but we need to make sure that we can complete what we have on the program already. So I'm happy to grant interested party status. At this stage it will be for a watching brief, and we will monitor how we go for time and whether you do in fact have questions for Ms. Marsh.
Ka pai. Thank you, Your Honour. Obliged.
Mr. Lau.
Kia ora, sir. Kia ora, Ms. Marsh. I'd like to turn to the briefing paper that's at page 128 of the Common Bundle dated the 27th of May. And I'm going to start at page 135 of the Common Bundle, at paragraph 29 of that document.
Thank you.
Now there's a heading, does the High Court's judgment in Re Edwards also need to be set aside? And here we're coming back to the LDAC advice from 10th of May. And at 29 it says that their advice was that the legislative proposals need to have a clearly defined and discernible policy objective, and that this should be distinct from the notion of restoring Parliament's intent. And then at 30 we have a statement of what Te Arawhiti sees the policy objective as being. It says to ensure that the threshold for the award of CMT is consistent with what was intended by Parliament at the same time. Isn't that just another way of saying restoring parliamentary intent for all intents and purposes?
It's what we understood from our discussions with the Minister.
Would you agree with me that the policy objective as stated there is inconsistent with the advice provided by LDAC?
The advice provided by LDAC is the advice provided by LDAC.
And I'm asking you whether you agree with me that the policy objective as outlined there is inconsistent with that advice.
That's your take on that advice?
And what's Te Arawhiti's take on that?
On what, sorry?
On whether the policy objective set out at 30 is inconsistent with the advice provided by LDAC.
Again, I'm going to go back to, it says, from our discussions with you, the Minister, the policy objective in this case is to ensure that the threshold for the award of CMT is consistent with what was intended by Parliament at the time. So we're talking about the Minister's
We are.
understanding?
Kapai, it might be as far as we can take that. But if we can turn the page to 136, please, of the Common Bundle. This is the page that has paragraphs 33 and 34 on it. And at paragraph 34, it's referring to Crown Law's attached amendments advice, but we don't have that advice. It says the above evidence indicates that legislators' intent was not to set up a particularly high barrier to the recognition of CMT, instead providing a common law influence test that would be applied by the High Court and ministerial decision makers. We note this was a marked step from the foreshore and seabed 2004 test, which required applicants to have ownership of abutting coastal land to be awarded territorial customary rights, a very high threshold. So at this point, as at 27 May, we have both Crown Law and Te Arawhiti's advice aligning that Parliament did not intend to set a particularly high barrier to customary marine title. Do you agree with that?
No, I think the words that we use are less restricted intent.
If we turn the page to 138 of the Common Bundle, at paragraph 47, there's 3 broad policy options listed there. I'll just point to option B as being a combination of A with the addition of a range of significant changes to the preamble, purpose and or Treaty of Waitangi clauses to definitively limit the size and number of customary marine title awards through a higher threshold test. That would be contrary to the advice of Te Arawhiti at that point in time if that step was taken, wouldn't it?
We present all options for the Minister to consider.
And when you say...
Again, I go back to the policy development process. We seek direction, we provide advice, we seek further direction, we provide advice.
You say you present all options, but again, we don't have evidence that an option was presented to the Minister to implement the Waitangi Tribunal recommendations, engage in the type of longer conversation with Māori that's been recommended in reports since the Foreshore and Seabed Act report of this Waitangi Tribunal, and so on. That option hasn't been presented in the papers that we have, has it?
Not directly, but I bring you back to the context of a number of comments that are included in various papers outlining risks, implications, and considerations.
Now, if we move to page 140 of the Common Bundle, paragraph 60 of the document, we're at Te Arawhiti's view. Now, we aren't in this part of the inquiry addressing the funding changes, but here at 60 it does mention in conjunction with Cabinet's recent decision not to increase the financial assistance scheme, wider changes are likely to be seen as undermining the political compromise central to the Act. Te Arawhiti recognises, doesn't it, that for applicants the funding issues and the amendments are intertwined and unable to be separated?
Te Arawhiti does acknowledge, and I have acknowledged, the importance of funding assistance and the changes to those.
And at 63, we've got Te Arawhiti grappling with some of the issues that arise through seeking to impose retrospectivity. It's at the bottom of the page that we've just been discussing. There it says, Te Arawhiti does not consider that there's any reasonable justification for overturning or retesting awarded CMT. That says awarded CMT, and I've not seen any advice at that point that applicants that have been part heard or awaiting appeals specifically. Had Te Arawhiti turned its mind to that by this point, 27 May?
So it's a long process, but would be the first mention that I've seen that refers to. Sorry, I can't answer that like
definitively.
Yeah.
Okay, now this document that we've been discussing on the front page, 128, says discussed at officials on 27th of May. And on page 172 of the Common Bundle, there's an aid memoir dated the 5th of June, which makes reference to that hui. And that paragraph 5 confirms that the Minister provided direction to progress to Cabinet, and that included implementation of the option B that we've discussed, and retrospective application to the Edwards High Court and subsequent High Court cases that have not been appealed, but seeking Cabinet's view, and you've taken us through that. I guess the takeaway from that document is that at 5 June, so relatively late in the piece, is when those retrospective options are really starting to firm up. Would you agree with that?
Yes, I would. Beginning to firm up.
The 12 June aid memoir, page 222 of the Common Bundle, is in response to questions that the Minister raised following his hui with first the seafood industry representatives and then Ngāti Koata. And I'm at page 224, paragraph 7b, or A and B, which were two queries following that Ngāti Koata hui, but query 4, can applicants apply for wahitapu protection rights as part of their CMT award? Was Te Arawhiti surprised that the Minister would be asking a question about basic rights that can be awarded under the Act at this late stage of the planning for amendment?
No, I think, in the bigger scheme of things, he was still coming to terms. He's got multiple portfolios, and this is not an easy subject to understand, to be fair to him. I mean, yeah, I've just got to pretty good grasp on it now, and I've been 2-3 years, and so when he asks questions or he's unsure, he will ask for advice so that he does understand clearly. And yes, the question was, wāhi tapu was discussed at the seafood industry. So I think it's only right that he gets, good advice on what the rights are around that, the protection rights are around that.
And customary marine title is one of the cornerstones of recognition of Te Tiriti o Waitangi through the Act. Would you agree with that?
I don't disagree with that.
And wāhi tapu protection rights are a bolt-on of that, but provide the strongest rights under the Act. So they're a very important part of protections available to Māori, aren't they?
Wāhi tapu?
Wāhi tapu protection rights.
Absolutely.
Right. Would you agree with me that no, I'll move on. So that happened on the 12th of June. We then have the Aotea hearing beginning on the 17th of June, moving into the 5th of July. So this is the third hearing that's taken place while the process that we've been discussing was on foot. And on the 19th of June, we have the aid memoir and final cabinet paper. I'm at page 230 of the Common Bundle, which is the first page of that document, at paragraph 8. Are you with me there?
Yeah.
Kapai.
Sorry.
So this is after the Te Arawhiti's undertaken departmental consultation with the Ministry of Justice and others, and the Ministry of Justice advice is reflected from at paragraph 8. And if we turn the page to 231, we see key points raised by the Ministry include at C, the likely impact on the proposals on social cohesion, including the full range of current policy proposals impacting Māori rights and interests, redacted, and then at F, raising the negative impact of option A on the rule of law alongside the risks currently noted for option B. Do you think that the feedback there from the Ministry of Justice is objectively more critical than that advice provided by Te Arawhiti about these changes?
It's the Ministry of Justice's advice, and I understand a statement was incorporated in the cabinet paper.
And at paragraph 11, further down the page of 231, we have the Parliamentary Council Office, PCO, and it was that office that suggested that section 106, the burden of proof section, be amended at this point. Is that correct? Yes,
That is
my
what the
question
paragraph
is
says.
Right. So, to your knowledge, it wasn't in the mix until this point. It was.
To my knowledge.
Could we please bring up the Common Bundle at page 401?
That's the one. Sorry, I thought I had my whole group. Sorry.
So this is an email from Fern Hyatt, dated the 26th of June. Are you able to tell us who Fern Hyatt is in this context?
In this context, private secretary to the minister. She's a director with Te Arawhiti in treaty settlements in her substantive role.
And you were one of the recipients of this email when it was sent. So this is sent 26th of June, and there's a heading, therefore by 12 p.m. tomorrow, can I please have some talking points? And the second bullet point is clearer information about the impact on the live cases. So that would mean those that have been part heard or still awaiting judgments, to your knowledge. Is that right?
Sorry, I want to get the words right.
No, do take your time.
I seem to have lost my paper.
There's one with the judgments in it.
One with the judgments on it. Oh, it's in front of me. So your question, sorry, again?
So down the page, below the 12 p.m. tomorrow in bold, the second bullet point, some talking points have been requested. Clear information about the impact on the live cases, and I've asked whether, to your knowledge, that would mean those applicants that have been part heard or have been heard and are still awaiting a judgment. That's
if
what's
they are
referred to
still
there.
in hearings or pending a decision when the Act is deemed to come into force.
And then in brackets, so this is 26th June, he, meaning the minister, still doesn't fully understand the table provided and what transitional means. And again, I've got to ask, did that ring some alarm bells at Te Arawhiti that this late in the process, amendments which would have prejudicial impacts on live applications, the minister didn't understand the full effect that these amendments might have on those applicants?
What it indicated to us is that he required more information and that he wanted to be crystal clear.
If we could please turn to page 424, and we've been there before today. This is I think the Ben Keith approved cabinet paper might be the shorthand for it. And if you could please scroll down so that we can see paragraph 80 and the sub-paragraphs of that. And really we're going here because this sets out the 4 options for retrospectivity at this time, so we'll know what's being referred to in the papers to come. I think the one to focus in on for the purpose of the next one would be recommendation 9.3, retrospective application to all CMT decisions since Re Edwards in the Court of Appeal, as well as the rehearing of all live cases that have been progressed to substantive hearings, and then 9.4, which have been taken through. If we could then turn to 494 of the Common Bundle, please. And what I've asked to be brought up are the talking points developed for the 1st of July hui. we could scroll down a touch. So if you could stop there, please. So the Minister in these talking points is seeking the view of Cabinet on the level of retrospectivity. There we have the third option. So this is going to be at a place in time before the 9.4 has been fully formed or sprung from the Minister's mind. But he's recommending the third option at this point, at the 1st of July hui. So that's to set up, I guess, the next paper that I'd like to look at. But if you could confirm that does reflect what you've read there.
These are the talking points that we provided.
Now if we could please turn the page to 495. This page discusses transitional arrangements. And if we could go to the top of the page, 495, please. So here we discuss the impact on live cases. While the precise transitional arrangements will be decided on a case-by-case basis, the proposal here set out, and I don't know whether I need to read it out, but is it your view that the proposal here would have allowed applications like those in the Whangarei Harbour who are awaiting a decision to proceed under the law as it currently stands?
Sorry, I can't answer that one.
The bullet point, which is the third main bullet point down, says these arrangements assure that cases are decided on the basis of the test that applicants will work.
Sorry, yeah, that's the...
So this is page 495 under impact on live cases.
Sorry for the interruption.
Right, so the third main bullet point down, just above next steps in comms, these arrangements ensure that cases are decided on the basis of the test that applicants were working to at the time of preparing and giving their evidence. That would suggest that as at 1 July, the Minister's position was applications like those in the Whangarei Harbour would have been allowed to have their decision issued and customary marine title confirmed on the basis of the current law, wouldn't it?
Again, these are the talking points that we provided that reflect where we were at that stage with the Minister.
And so, I guess...
Remember, we're preparing to draft a cabinet paper on his behalf, in his voice, with his views.
I think the point that I wanted to stress is we're now at 1 July, so we're weeks out from an announcement, and we still haven't landed a position, have we, on how those with live applications will be. Well, they will be prejudiced, but to what extent they'll be prejudiced would probably be the way to put it.
It's, the policy, well, you know, the policy process is an iterative process. Changes can be made at every step of the process, right up to the decision-making point.
Now, there's an aide-memoire dated the 2nd of July at page 248 of the Common Bundle. And the purpose of this is to provide further information regarding the current and upcoming cases and impacts on the retrospectivity options on those cases.
Apologies,
Ka pai. And at paragraph 2 and 3, we're discussing the proposed additional option that became the fourth option that we saw in the Cabinet paper earlier, and indeed the one that was adopted. At 3, it says, the consequence of this is that cases that are in hearings or pending judgment at the time of the announcement would need to be reheard. There are 5 cases expected to be in this situation. Where it uses cases there, it's actually talking about hearings in their entirety, isn't it?
Yes.
And in the different hearing fixtures, there's multiple applicants involved, so it's not just a case of one applicant group who would be affected. There's many working parts here.
Yes.
Right. Would you agree that putting it in this way, 5 cases, somewhat understates the effect that these changes are going to have on all of the applicants who have been progressing in the High Court, including those that we've mentioned as we've gone through our cross-examination today?
That's your read. That was not our intention. It never has been.
Now it says we've assumed that the cases that are scheduled to start hearings after the announcement date would not continue on their existing timeframes, as any judgment would be overturned in the case reheard when the Amendment Act comes into force. So there's a limited point in those applicants continuing until after commencement. I think you'd agree with me that that assumption has been found incorrect. Applicants are seeking to continue their hearings.
And that's exactly what it is, an assumption.
Could we please bring up page 519 of the Common Bundle? We're getting very near the decision point of Cabinet here. So what should come up are the talking points for the Cabinet hui on the 8th of July. And if we scroll down one page, please. I'm looking at paragraph 19. First of all, there's track changes in this document. Is this a work in progress, or is this in the form that it landed in? Are you aware?
I'm not aware.
At 19, we have the Minister recommending option 9.1, but fast-tracking the amendment legislation to reduce the number of judgments being made before the amendment comes into force, noting there are no other CMT hearings scheduled for 2024. And then at 22, we have the Bill's priority category on the 2024 legislative program being changed from Category 5 to Category 2 must be passed by the end of 2024. Are you aware of what considerations or criteria are required for the different categories that are assigned in Cabinet to accord these bills priority?
No, but we can provide you with that information later.
I don't know if our timeframes will allow for that, but ka pai, it's something I can cover in submissions. So we have the decision taken by Cabinet on the 8th of July, and I'm not going to take you to the document because I think that's properly a matter for legal submissions. But if we could turn to page 257 of the Common Bundle, please.
Mr. Lyle, just as we do, I see we have hit the 90-minute mark. Are you able to give an indication of how much longer you have?
I think my guesstimation's been quite spot on, actually, Your Honour. I'm just winding things up. So.
Thank you.
Uh, 257. Then we have, if we could scroll down slightly, it's a line starting on 18 July. Yeah, so, on 18 July, we expect to provide you with this report, seeking your agreement to the approach on disclosing the Cabinet papers regarding Section 58 and the announcement date. So that refers to the goings-on in this inquiry and the application for disclosure of documents, doesn't it? And it says, we understand your decisions on this paper will influence the timing of the announcement. What I really wanted to ask if you could confirm was whether the timing of the announcement hinged on that request for production of documents in this inquiry, or whether there was some other basis for setting 25 July as the date at which retrospectivity would be applied.
Yeah, I'm unable to give you a definitive on that. I have to put a bit of context. I got quite sick that very night and ended up in ICU. So I'll need to, it's a little bit murky around this area for me. So it's been upfront with you.
So you can't tell me today why
No.
25 July was...
No.
The decision was taken by Cabinet on the 8th of July, and there were some weeks until the 25th of July. Why the delay? Why weren't applicants informed? So if Cabinet took the decision on the 8th of July, and then it wasn't communicated to applicants until the 25th of July, why the delay? Why not let applicants know as soon as possible?
There are things that need to be put in place between the announcement, formal things that need to be signed off to be ready for the announcement.
I have two very quick matters to deal with. First concerns the unfortunate Hobson's Pledge advertisement on the front page of the Herald. And I accept that my learned friend has since pointed us to a response from Te Arawhiti to that. What I wanted to ask was, in looking at that Hobson's Pledge advertisement, does Te Arawhiti agree that that advertisement was misleading?
We provided the statement that we provided accurately describes what we think. I don't wish to discuss that ad personally myself. So my answer is our release was our response to the ad.
And does Te Arawhiti agree that advertisements like that are likely to fuel racism?
Our release was our response to the ad.
I'm just not sure, sir, what issue this goes to.
It's also inviting a rather speculative answer, isn't it, Mr. Lyle?
Difficult to grapple with this issue in the absence of evidence from the Crown, however, but nevertheless that was the final question on that line. And I have one final matter. The amendments that are proposed, we've seen they've been developed entirely by Te Arawhiti and ministers until at least the 25th of July. does Te Arawhiti accept that there's another perspective here where not only the identification of problems, but the identification of solutions and priorities should come from Māori, the whānau, hapu and iwi out there?
I think I'll point you back to the numerous occasions where we highlighted the importance of meaningful and fulsome engagement with Māori, right back from the initial advice, right through, and I think it's acknowledged in the risks
So I think
of the cabinet paper.
I think I'm wanting to push you a little on that to say that this could go beyond engagement, right, to the identification of problems with the Act and then how they could be solved.
And I point you
allowing
back
space
to
for
we were
that.
dealing with a coalition agreement. Our job was to put in place processes to implement that.
So it's Te Arawhiti's view that the coalition agreement is what's prevented this approach from allowing for that sort of engagement.
That's your take on that, not mine, not Te Arawhiti's.
Well, why, in Te Arawhiti's view, has this approach allowed for Te Ao Māori, whānau, hapu, iwi, to identify problems, come up with solutions and engage in a meaningful way?
Not the process as it rolled out in the way in which you describe.
Those are my questions, sir.
Thank you, Mr. Lahal. Ms. Cole.
Kia ora.
Closer? Oh, needed it on.
Tēnā koe, Jackie.
Kia ora. I am here on behalf of 3 applicant groups. We don't need to go into the detail of all of that. Our questions are very general in relation to the evidence that you've provided. Excuse me, and I'm wanting to start really. Something funny is happening on my computer. We will just get rid of that. I'll go to the top of that. I want to start by being very clear that the criticisms that our clients and we as council have in relation to the Crown's acts and omissions and that have led to this inquiry are not aimed at you personally.
I understand.
I want to start off with the summary of the brief of evidence that you read earlier today. Can you tell us when was that drafted? Was it drafted last night?
Yes.
Yes. And who drafted it? The lawyers?
They did.
Yeah. It struck me as being very conspicuous as you were reading it and we were listening to it, that it focused a great deal on addressing the issue of what was Parliament's original intent when enacting the MACA Act, much more so than what your actual brief of evidence did. And my question is, was that done in response to Council's openings yesterday?
I think around the original intent, I think it represents the amount of time proportionate to the entire process that we did spend genuinely reviewing and trying to identify or form our view of the original intent and the importance of that in identifying appropriate options to meet that intent.
Okay. I'm going to come back to that in terms of the evidential trail of where advice is given on original intent a little bit later. But I hear what you've just said there, that you were focusing on, there was a lot of time, I think is what you're saying, spent by the team in looking into what was Parliament's original intent.
Proportionate to the length of the process.
Right. Another thing that struck me in your summary as you were reading it today is that there seemed to be quite an emphasis on what the minister's views were, or the minister's beliefs, as distinct from the advice that Te Arawhiti and possibly others in the process were actually giving to him. Are you seeking to distinguish between those two things, the minister's views and beliefs and Te Arawhiti's advice? And do they align?
We're tasked with free and frank advice. The ministers receive that, consider it, they make the decision on whether to take that or not.
Yeah,
it does not stop us from continuing to provide that free and frank advice.
Yeah, and I absolutely appreciate that, and that's the role of public servants, of course. But what I'm asking you about is the evidence that you've actually presented to the tribunal, and particularly in relation to the summary that you read today, is there does seem to be a distinction sought to be drawn between the advice that was given by Te Arawhiti and the views of the minister. And what my point is that it would appear that those two things diverge quite markedly, particularly when we get to the end product. Is that fair?
On a number of issues, that is fair.
Thank you. Just to be absolutely clear, this is an inquiry into the acts and omissions of the Crown, not into what Te Arawhiti did. So it's not an inquiry into Te Arawhiti. And you understand that?
I understand that.
Yeah. Am I correct in listening to some of the answers that you've given to Mr. Lyle's questions that you are strongly of the view that Te Arawhiti officials did give the minister fulsome and frank advice?
Yes.
Yes? Is that including advice about the likely risk of treaty breaches that would be committed should he proceed with the path that he was adopting?
Can
Say it
you
again.
clarify that?
So
please?
the advice that Te Arawhiti were giving to the minister, you maintain was free and frank and fulsome? Yes? Yep. Again, just repeating what Mr. Lyle said earlier, because this has been transcribed, we have to get verbal responses. And one of the things that Te Arawhiti officials were giving him advice about, this is the question, was one of the things that you were giving him advice about was the likely risk of treaty breaches in the event that he continued with the amendment proposal that he was bent on pursuing. Yes? Advice was being given about treaty breaches that would be committed.
Advice? Yes.
Thank you. In the various advices to the minister that we've received through the disclosure process, mention is made of very limited consultation with Māori being inconsistent, so that very limited consultation with Māori being inconsistent with Te Tiriti. We've all seen that. So you gave advice, if you don't engage, it's crucial, that kind of language. The aid memoir of the 5th of June, which is attached to one of the draft cabinet papers, you don't need to go there, but for the record it is Common Bundle, page 187. It says that the consultation proposed by the minister would, quote, likely be inconsistent with the principles of Te Tiriti. So advice was definitely given to the minister about likely breaches of Te Tiriti in relation to consultation.
Yes.
Yes. When the minister pressed on with his proposed amendments, did Te Arawhiti do anything further to reinforce its advice about treaty breach?
Sorry, without, did we?
If you can't remember.
Yeah, I can't remember.
Yeah. Because my next question, of course, was going to be, where in the document do we find that, documentation do we find that advice? And then the next question that follows from that, of course, is it all in the redacted information that we actually can't see? So really...
And I can't divulge that to you.
No, you can't. But nor can the tribunal be aware as to whether or not the minister was even receiving that advice. Can you see the point?
What I can say is he was very clear on the legal constitutional relationship risks.
And notwithstanding that, he chose to go down the path that he has, made the recommendations that he did to Cabinet on the 8th of July, and we now have the situation that we have in terms of what the amendments proposed are going to be.
He acknowledges that in his cabinet paper, that he notes the risks.
Right.
He's considered them, but the risk of doing nothing outweighs that.
In his view?
In his view, in his paper.
In his paper, okay. Is it fair to say, sorry, I'll go back one step. Am I correct in understanding that the Minister justifies his decisions as to where he landed in terms of a outcome? He justifies his decisions on the basis of what was agreed between National and New Zealand First in their coalition agreement?
Sorry, can you explain?
You have said to us, in answer to Mr Lyle's questions on a number of occasions, it was because we had the coalition agreement. We were going down this path because, my language, going down this path, because there was the coalition agreement. These things happened because there was the coalition agreement. Right? I'm not misquoting you there.
We proceeded with work on the options at the direction of the Minister.
Yeah.
The Minister signalled that the coalition agreement was a priority.
Right, okay. And in terms of, Te Arawhiti have given him advice, as presumably have other agencies, given him advice about the risks of going down the path that he's chosen to go down. He's chosen to go down that path anyway, and Cabinet have endorsed that. That's now a decision of the Crown, yes? And that is all because the Crown is more committed to the agreements within the coalition agreement than it is to Te Tiriti. Isn't that correct?
I can answer that, yeah. What I can answer is around the process, the considerations. I don't know what it is you're wanting me to answer.
Do you agree? Well, you've told us a number of times that the coalition agreement was key. Yes? Yeah. He was told that doing these things would breach Te Tiriti, and he proceeded anyway. Isn't it fair to take from that he elevates the obligations of the coalition government as contained in the coalition agreement above the Crown's obligations under Te Tiriti?
That's something you'd have to ask the Minister.
Well, okay, I will then ask you this. Has the Minister authorised you giving evidence in this inquiry? You don't know?
I don't know.
To what extent is he aware that you're giving evidence in this inquiry on behalf of the Crown?
He's aware.
To what extent are you briefing him? Or Te Arawhiti briefing him? So when I say you, I mean Te Arawhiti.
I'm not aware up till I've been out of the office for the last couple of days here. Until then, Did he read your... Do you know whether he was provided with a copy of your brief of evidence? I don't.
When you attend meetings with ministers, is it your practice to take your own notes?
Not me personally. Yes, I take rough notes, but there are note takers, but the practice is for actions to be sent back from the Minister's office.
Okay, so they effectively take the note?
They're not minutes or...
No.
Yeah.
I've seen plenty of them in my time, don't worry. Did you refer to any of those sort of notes when you were preparing your evidence for the purposes of this inquiry?
To the notes from...
Meetings. Because in your evidence there are a number of references to meetings that you attended.
Yes, there's so many meetings. I refer to the briefings. Yeah, because
Right, so-
generally I sign out the briefings that go.
Okay. So
They come through me in a QA process.
Yep. So for the purpose of preparing your brief of evidence here, I'm going to assume from that the lawyers prepared your brief of evidence on the basis of that kind of high, if I might describe it as high-level information, the briefing papers, the aides memoir and file notes that have been provided through the disclosure process, but they haven't delved down any further in that. And I'm not being critical when I say that, I'm just, okay. So when you went and checked the brief of evidence before you signed off on it, did you compare that to notes or any other personal records that you'd taken of this process over the 6-month period or so?
No, like I said, I QA the papers that come through.
Yep.
And obviously I can't remember every date, but I read the brief of evidence with that lens on it.
Okay.
Having walked alongside except for when I got sick. I walked alongside the team during that process over the 6 months.
And you said earlier on, team of 3 or 4 people, is that right?
No, there's a core team, including our legal, including our policy. I think that would make up maybe 6 to 8. So it's a cross-te arawhiti effort, not just takutai moana,
And
our
so-
legal and policy.
And this is in terms of the development of the policy.
Yes.
That's what you're describing there.
Yeah.
In terms of when it got to the kind of crunch end, where cabinet papers were being finalised, so June, July-ish, is that when you brought in externals like the Professor Mark Hickford's and the Crown Law Office?
We still held the pen on the paper
Right.
internally.
Okay.
Theirs was, I suppose, additional assurance, legal assurance for the minister.
Okay, so just to be clear, and again, I'm not being critical when I say this, but aside from the disclosure that we've received for the purposes of this inquiry, you would accept that there would be a significant amount of further additional documentary material that goes to the policy decision that has been made to make the amendments to the MACA Act.
I would expect that we provided.
Are you not familiar with the disclosure that's been provided?
I got, you mean all the documents?
Yeah.
Yes, I am.
Okay, so that, I'm
Diligently
assuming that's
read
the
them.
bundle that you've got in front of you. Would you agree that the actual volume of documentary material that has gone into the policy development and advices, etc., to Minister and Cabinet would be significantly more than that bundle you've got sitting in front of you?
If you included, I suppose, people's notes, I don't know what else would be included in there. The key papers that I'm aware of that I signed out are in there.
Yeah, now the key papers.
Yeah.
Okay.
I even brought to correction that this was the A3. So the key papers that I know about are in here, the decision-making
The
documents.
decision-making papers. Yeah, no, thank you. Okay, can I go to your actual brief of evidence? I want to start working through that paragraph 14 of your brief of evidence. And this is not in relation to ministers having being the ultimate decision makers, but and actually it's at 15.2. Officials provide advice on policy issues. The process, especially on complex tasks or subjects, is typically iterative with officials' advice to ministers for decisions informing further advice and decisions. Isn't it a usual indication that I'll go back one step. You've been a public servant for 20 years. You know the process very well. Isn't it the usual indication that a minister either doesn't like or doesn't agree with a piece of advice that officials have sent up to him or her when they send that briefing paper back unsigned?
I don't have knowledge of why the minister sent it back unsigned. What I do know, what I can confirm is that it is a regular occurrence with the minister. I don't take that to be one way or the other.
Have you, in your dealings with other ministers over your 20 years experience, seen that practice? Of ministers sending things back unsigned if they agree with them?
My experience as a Deputy Chief Executive only spans to 2022.
Yeah, okay. So you can't speak to it. Righto. Oh, you won't be able to answer the next question then about the good old days when ministers used to respect the advice of their officials. Paragraph 15.7 of your brief of evidence. You note that Cabinet is the central decision-making body. We accept that. Do you accept that Cabinet, as a body, as well as all the individual members of Cabinet, all the ministers, are subject to and bound to respect and uphold the principles of te tiriti?
Are they bound to?
Yeah. Let me go back a step. Who is the Crown?
I asked myself that too. Sorry.
Well, you're a Deputy Chief Executive of a government department. Who is the Crown?
So sorry, what's the point? of this.
Oh,
I can't give you,
throughout your evidence-
definitions of things are not my forte.
Do you not know who the Crown is?
I can't give you a definitive answer.
It's not a legal question, Mr. Stevens. Okay, so if I were to tell you that have you ever heard of the three parts of government? The judiciary, which is the courts,
Yes,
and the executive?
I have.
Okay, so do you know what the executive is?
Yes, I do.
And what's that?
I'm sorry, I don't know where you're going to with
Okay,
this.
so that's the cabinet, right?
I've already said to you that, yeah, I can't give you a full
Okay,
answer on
well,
that.
will you take it from me that that's the cabinet
Okay,
and that's the Crown? Okay, so throughout your evidence, when you differentiate between the government, I'm talking about your evidence here,
Yeah.
you differentiate between the government and the Crown, it's really important that we all have a clear understanding as to who we're talking about. Don't you agree with that?
yes,
Okay,
I do.
so when I'm talking about the Crown, I'm talking about the executive. So Mr. Stevens doesn't have any issue with it? I'm not misleading the witness? I just want to make sure there's no objections here.
Mr. Stevens certainly hasn't objected so far.
That's okay. I don't want him to say anything at the end of my submission because it's a really important point that you actually, as the Crown's sole witness in this inquiry, it's really important that we have this clear.
Yes,
Okay? Please don't think I'm trying to insult you, but as a Deputy Chief Executive, I thought you probably would have
I
known
accept that you're doing your job.
Okay. So let me go back to my question. Now that we're clear as to what Cabinet is and therefore the Crown, do you accept that Cabinet as a body and all of the individual members who make up the Cabinet are subject to and bound to respect and uphold the principles of te tiriti?
I choose not to comment on that.
Okay. Do you think there should be somebody who is actually a decision maker on this policy fronting the tribunal? Do you think it's fair that it's you sitting in that chair?
I oversaw the process. I signed out and QA'd the papers. I therefore take responsibility for that process.
The process that Te Arawhiti engaged in.
Yes, I
Yep.
do.
And there's obviously a distinction between Te Arawhiti and the Crown. Because Te Arawhiti's just a government body, right? A department. It's not the Crown. So my question, I suppose, I'm sorry, I feel like I'm pulling teeth. You're not the Crown. So you're the person
My
who...
relations at home would have you say different. I can tell you that now.
And I totally take my hat off to you, the fact that you can even do your job. So there we go. Paragraph 23. Hopefully this is a bit of an easier one. Paragraph 23, third line down. The paragraph reads, alongside the Ministry of Justice and other agencies, particularly Crown Law, Te Arawhiti had a role supporting the public service to understand its treaty, te tiriti, obligations within the current constitutional settings. Can you tell us what you mean by within the current constitutional settings? Sorry, looking at paragraph 23, page 26.
And that's that parliamentary government of the day, parliamentary sovereign, Parliament is sovereign.
Parliament is sovereign. Can I just ask, really bluntly, is that kind of language that we might find in your brief of evidence come from the lawyers who drafted this in the first instance?
Sorry?
Is that kind of language within the current constitutional settings, is it something you've inputted, or is that something that the lawyers have put into your brief of evidence and you've agreed with it?
I didn't write this
No.
paragraph.
No, I didn't think so.
I would assume it's derived from information about the agency.
Yeah. Okay. Paragraph 24, the second sentence of that paragraph, you say that Te Arawhiti's advisory role is to ensure that the Minister has a clear understanding of Māori rights and interests in policy processes. Yep. Are you personally satisfied that the ministers of Te Arawhiti's, that the ministers who received Te Arawhiti's advice, and I say ministers meaning plural, Prime Minister Seymour, Jones, Potaka, Goldsmith, quote, have a clear understanding of Māori rights and interests in this policy process?
What I am clear on is that we provided them consistently around the impact on Māori rights and interests in the process.
How do you know, or do you know, whether they even read your advice?
Well, I know that Minister Goldsmith did. I can't speak for the other ministers.
Okay. At paragraph 36, this is referring to the Attorney General's appeal to the Supreme Court. And halfway through the paragraph, it says a fundamental reason for the Crown's appeal, the Attorney General's appeal, is that none of the parties' submissions in the Court of Appeal contended for the approach taken by the majority to the interpretation of Section 58. Can you see that? So paragraph 36, and it's the second half of the paragraph.
Okay.
Yeah, so you're saying that a fundamental reason for the appeal is that the judges did something that none of the parties were contending for. Is that what you're saying in that paragraph? Or subparagraph, second part of the paragraph?
This is about the Attorney General's appeal?
So the Attorney General is the party to the litigation?
Yeah.
So it's his or her appeal?
Yeah.
Yeah, and he or she, in this instance he, applied for leave to appeal. That got granted, and that appeal is going to be heard in November.
Yes.
Yeah. And you're saying that a fundamental reason for the Attorney General, so the Crown's appeal to the Supreme Court, is that none of the parties' submissions to the court below sought what the majority of the court actually came out with. You're not familiar with it,
yeah,
are you?
I can't.
Is this another one of those paragraphs that you didn't have anything to do with?
That would be a misrepresentation to say I'm not aware of these issues.
Okay, well then...
But not to the detail that you ask.
And I'm not wanting to ask detail, I'm simply
Yeah.
wanting to ask you, so what? So what if the majority of the Court of Appeal came out with an outcome that none of the parties had actually been submitting on? Why is that a fundamental reason for the appeal?
I don't have opinion on that.
Okay. The document, which is the table that you've got in front of you, TA 003-4444. So the table that you've got that you were talking to Mr. Lyle about, that you've got your hand on, yes, that's right. It's at... I'm looking to Mr. Lyle for the common bundle number for it. I think we need the second version. Well, actually, I want to clarify the versions because I was totally confused in the discussion with Mr. Lyle, so possibly the tribunal was too. You know how there's a copy that's just one page and it's got the handwriting of the minister on it?
That's...
This one.
Yep, that's page 27.
Page 27, thank you, Mr. Stevens.
Is that the one attached to the letter?
Yes. So just to be clear, I'm not going to ask you about the particulars of the document, but just to be clear, were you saying before that that is not the document that was attached to the aid memoir? The document that was attached to the aid memoir was the double-sided one? That you've got
No, I'm saying that there's mention of a meeting on the 20th of January.
Yeah.
And this is the discussion A3 that was used at that meeting.
So it wasn't...
To gain the minister's direction.
Okay. But that page that's got the handwriting on it is just one side of that double-sided document that the minister's presumably scribbled some notes on, done something with, and it's ended up in discovery.
It appears so.
Thank you. Okay, so I had written a note, because perhaps I'd misunderstood, that this document had been attached to an aid memoir of the 29th of February, which had draft letters from Goldsmith to the PM, Deputy Prime Minister Potaka and Seymour. Is that wrong?
Ms Cole, just before we move on,
Sorry.
I may just need some help with that, because when I look at the version on 530,
Yes.
it seems that that's slightly different to the version on page 27. There seems to be decisions sought from the Minister on the latter version, not on the earlier version. So it seems that they may actually be different documents.
That they are different documents.
Are you talking about the red at the bottom?
On the page 530 version, yes.
So that's why I wanted to clarify where this document actually came from. Oh, does it turn itself off? Sorry, Alan.
It's the next iteration.
There is a simple answer to this, which
Yes.
I'll venture.
Great.
So the document at page 27, the document that is at page 27 follows a series of draft letters that are supplied with the aid memoir. And paragraph 4, the attached letters appendix 1 are addressed to, and then over the page B, attach the A3 that summarises Parliament's intent, the working problem definition and so on. And then that is the document at 27, so that is the A3 that will be attached to the letters. And then, and it's best to clarify this with the witness, but the document at 529, 530 is the document that Ms Marsh is referring to when she says that there was a document discussed at the hui of 30 January. And she has the original copy in her hand, which is what she keeps waving, and the document that's been disclosed is one that has been redacted on certain grounds, so it should be the document at 529.30 and 530. That is the one that the tribunal has and claimants have that we ought to discuss. I hope that solves that problem.
That is extremely helpful, although it does then raise the question of why is the handwriting of the Minister on the one that was appended to the letters that were sent out in late February, early March?
They were draft letters and they weren't sent.
Okay, that's helpful. If you had the meeting with him on the 29th of January, correct me if I'm wrong.
20 January.
January, when you took along the document you've got in your hand right now.
Yeah.
And it had decision sought from Minister at the bottom in that red line. That was obviously taken off the version that was then going to be appended to the letters that didn't end up getting sent. Is that right?
Yeah, because we remember he was consulting with his colleagues, coalition colleagues, around his approach, his proposal for approach, timing, scope.
Okay. Two last things on this document. Firstly, when the Minister wrote more on the handwritten notes one, you said to Mr Lyle earlier on that that was because the Minister wanted you to add more into, to add to effectively the box that is headed up, what is the problem we are trying to solve. He wanted you to add in the words that he'd put at the bottom of the page. Is that right?
That's what that indicates.
Okay. This is not my second question, but I did want to clarify. The version of this document that we've got with the handwriting, the last words run into the numbering. I wondered whether you have a copy in your bundle that can tell us what it actually says. And maybe you can get back to us. Yep. It looks like, what happens or what, I don't know.
We can provide a version that it does not obscure the Minister's handwriting.
That would be terrific. Okay. And my second question was simply going to be the version of the second page that was taken to the 29 January meeting, which is the page that is exactly, as far as I'm aware, exactly the same as this one except for the red at the bottom. Are there any other amendments to the content of the boxes between the two documents?
I haven't done a reconciliation.
Well, let's not spend time doing that now. Perhaps if there are changes, it can be pointed out to us, but
Just to add to the confusion, you've been referring to a meeting on the 29th. The aid memoir is actually dated 29th of January, but the aid memoir is actually dated 29th February.
yeah, that's right.
So the draft letters appear to have been drafted for no earlier than 29th February.
The meeting, my recall of the meeting to discuss the decision-making A3 was 20 January.
When you come back to clarify the point Ms. Cole's making about this document, can you just have that timeline perfected if you can?
29th. 30th of January is what I'm being told.
sorry,
Is
30th.
the meeting, yep. At page 15 of the Common Bundle.
Sorry, 30 January.
That's right.
Yeah,
And then
new
Mr
glasses.
Crosby's right in terms of the second document is the one that's attached to the aid memoir of, I think, the 21st of February. 29th February. We'll get there eventually. In any event, you tell us that the letters and so this document were actually never used again. Is that right?
That,
Either version.
yeah, this one was for the gaining direction.
Yep.
What you see in the draft letters, that did not go. And the minister's comment, what did go to the ministers is the 14 March.
That's right. So, in our opening submissions, we made quite a big deal of the fact that this particular document appeared to be the most substantive document we could find that recorded Te Arawhiti's view as to what the intent behind the test in Section 58 originally was. And there's 5 bullet points. And somebody yesterday helpfully pointed out that there's a 6th bullet point in another memo later on. But my question is, where is the documentary body of evidence to support the assertion that what is recorded in this document as being Parliament's original intent? So where is the body of material that tells us how you got to these decisions as to what Parliament's original intent was?
So you're asking for the record of the review and what was reviewed?
The second part. What was reviewed? Because there doesn't seem to be any information. You've told us that there was a very thorough review, but where is it?
And provided a few sources of that Hansard.
Yeah, I think all we've seen
all
is
those things.
I think all we've seen is references to Hansard, Chris Finlayson's press release, and one other thing that slipped my mind.
Yeah,
But
there's
that's
a
all.
number of sources that are stated in the evidence provided.
Okay. Are you familiar with the fact that in the Edwards Court of Appeal, Mr. Hodder, King's Counsel, acting for the Landowners Association, Coalition, took the Court of Appeal judges very carefully, and I'm told laboriously, through all of the materials which were available as statutory interpretation aids for the court to determine Parliament's original intent? Are you aware of that?
No.
Will you take my word for it that he did that?
Yes, I will.
The Court of Appeal justices made a decision, 2 different decisions, but decisions, after hearing all of their evidence, and we surely must respect the learnedness of Court of Appeal judges, right? So in determining what Parliament's original intent was, which is what they've done in their decision in the Court of Appeal, does Te Arawhiti think that the Court of Appeal judges just got it wrong?
I respect the opinion of the Court of Appeal judges.
I would too. Okay, paragraph 43. Again, sorry, I must need to quickly check. I retract that, can jump this piece. Paragraph 44, you make the point, and you said this also in your summary today as well, that it's at the top of page 11 of your brief of evidence. You make the point that Cabinet has not taken decisions on certain matters relating to the process after the bill is introduced into Parliament. Can you tell us, do you know when will those decisions be taken?
I can't confirm.
So there are
right now.
processes still to come in this bigger amendment of the Act issue that haven't been made and possibly won't be made until after introduction. Is that what your evidence is?
I can't confirm that any decisions have been made,
Okay.
other than what you know now.
Yeah. I know that other council are going to get on the consultation bandwagon, so I'm going to ask just a couple of questions on consultation. You are very clear in your evidence. I would respectfully say that you consider that Te Arawhiti's advice was fulsome and frank and direct, I suppose, in terms of what consultation was required. Is that fair? You've described it in your evidence, or indeed in the documentation. For example, Common Bundle document under tab 3, which doesn't help. Te Arawhiti reiterates its previous advice that engagement with Māori and applicants would be crucial to minimising damage to the Crown-Māori relationship. My question is, again, you don't need to go to it, because my question is simply, what would you say crucial engagement consists of or looks like in this situation?
One that allows for meaningful input.
From Māori?
From Māori.
Okay. Has that happened?
No.
Okay. Is there a reason why in the paper to the Minister it is described as, engagement is described as being crucial, but then there is not another paragraph to explain what crucial means? Was the Minister just supposed to know what crucial engagement meant or looked like?
No, it's not just the words in the various documents. You know, those discussions too are held at meetings to ensure, work the Minister through, that he understands.
So are you telling us that...
I mean, about the same time the anniversary had rolled around, and
the
he was
anniversary
aware, foreshore seabed, he had, you know, we had discussions. He understood. He understands.
Okay. So you're telling us...
is important to Māori.
So, okay. So you're telling us that what the crucial engagement should look like was actually orally discussed with the Minister. So he knew what it was about.
I'm saying that the Minister, we made clear through our briefings and in our discussions that this matter was an extremely important matter to Māori, and the importance of consultation.
Okay. But the Minister chose not to take that advice?
We offered, he received, he considered, and he made his decision.
And he chose not to take the advice, didn't he?
In this instance.
In this instance, yeah. Okay, paragraph 52. There is a reference down the very bottom of the paragraph. It's on page 12 of your brief of evidence. This is going all the way back to the December meeting. The second half of the paragraph refers to the government's objective in developing the new legislation, and this is from your brief of evidence, which was to establish a regime that balanced the interests of all New Zealanders in the marine and coastal area. When you say all New Zealanders, are you including Māori in that group?
Yes.
Can you explain then how Māori rights and interests are being balanced by these proposed amendments?
That's not for me to answer.
Well, you have given the Minister advice that this legislation is to establish a regime that balances the interests of all New Zealanders. You've confirmed that all New Zealanders includes Māori. You must know what you meant when you said balancing the interests of all New Zealanders, which include Māori. How does it balance Māori interests?
We've covered several areas where you've pointed out to where our advice to the Minister has differed from his views and the advice and the decision that he has taken.
Okay, yeah, no, I appreciate that, but can I just clarify then from that advice was specifically given to the Minister as to how the impact of this amendment would not balance Māori interests, and he chose not to take that advice?
As stated before, he received and considered
That's
and
not
made
what
his
I'm,
decision.
But that's not what I'm asking you. Was the advice given in the first place?
Given for, sorry, clarification.
As to how Māori interests would be balanced through this amendment, these amendments?
Again, I'll go back to we raised the risks, the implications, the importance of consultation. You've highlighted where we have difference in the advice that we provided and the decision that the Minister made and his views and those of Te Arawhiti.
Okay. Can I get you to jump to paragraph 70 of your brief of evidence, which is in the top of page 18. So paragraph 70 starts on the bottom of page 17, runs over. And I will start at the top of paragraph 70. Officials advise that the less stringent interpretation of the test arising from Edwards Court of Appeal might result in CMT being recognised over more of the coastal marine area than under the previous interpretation. You see that?
Yes.
Can you tell us what you mean when you said the previous interpretation? And that wording, by the way, has come straight out of one of your briefings. You'll see it in the it's referred to in the footnote. So what did you mean by the previous interpretation?
What was understood to be the original intent of the legislation.
So when you say previous interpretation, you mean the interpretation by parliamentarians, not an interpretation by the courts? Or are you not sure? Another one of those paragraphs that the lawyers wrote, maybe?
No.
Well, it has been pointed out that it's been taken from a briefing, so perhaps and there's a footnote to the briefing, so perhaps we could go to the briefing.
With the context in it.
And you signed off on the briefings, as we already know?
I did.
That's what I said. You signed off on the briefings? So this is the 14 March briefing.
Which number in the case?
I'm just getting it for you. It's 28.
Oh, gosh. Apologies. 14 March.
That's the first page of the briefing paper. We need to pop down to paragraph 18 by the looks of your footnote. It's under a heading, the impact of the Edwards decision.
Yes.
Yeah. See that it is taken, so your words in your brief of evidence are taken directly from that. We can't know what the implication will be in any particular case. Our expectation is that the less stringent interpretation of the test arising from Edwards may result in CMT being recognised over more of the coastal marine area than under the previous interpretation. So all I'm trying to explore is what was meant by previous interpretation. I think what you've told us so far is that you're talking about an interpretation that Minister Goldsmith submits is what Parliament originally intended, but that does not align with the advice that Te Arawhiti gave him.
I don't think that's what I'm saying. I think this aligns with the
So Te Arawhiti gave
and
him
I might
advice.
be wrong. This is our assessment.
Okay. Te Arawhiti, you explored this earlier with Mr. Lyle. Te Arawhiti gave the Minister advice at one point that this more restrictive test was, Te Arawhiti did not consider that the more restrictive test was necessary to achieve the objects as originally intended.
We did.
But this is absolutely going beyond that, isn't it? By significantly reducing the amount of coastal and marine area that title can be recognised over under these proposed amendments, that is a significantly more strict test, isn't it? The Te Arawhiti advice even says that, doesn't it?
I do still need clarification. Sorry.
Okay.
It's been a long day.
It has been a long day, and I apologise for that. What time is it? 3:10. I think I've got 10 minutes left. Oh my gosh. It's in the same paragraph, actually, paragraph 70. There's also a reference to previously anticipated. It was so carrying on from previous interpretation. It was noted that there was a concern. This is in your briefing paper. It was noted that there was a concern that the potential implications of recognition of CMT over a larger amount of the marine and coastal area than previously anticipated would have an impact on New Zealanders' expectations, etc. So my question was going to be, what are you referring to when you say previously anticipated?
As I said, our assessment
of the historical documents.
Our assessment was that, so the reflections we have of the original intent and our assessment lead us to that statement.
But then that begs the same question that I was asking 10 or 20 minutes ago, is your assessment of what?
Of the records that we reviewed.
Okay. And we don't, to your knowledge, we haven't got any of that evidence in the materials discovered in this inquiry, do we?
I have not cited any.
Yep, thank you. With all of the research, and actually I'll just have to make sure that you're even aware of this, were you actually involved in reviewing that material from previously, you personally, or did you only get sort of briefings from the team who did the review?
It would briefings from the team.
Okay, so you probably won't be able to answer this, but I will ask it. Is it likely that when passing the 2011 Act, parliamentarians at that time were perhaps ignorant of the level of connection that Māori have to their takutai moana?
I can't answer that. Yeah. I wasn't there at that time.
No.
Or have
but
any
that's why.
knowledge.
Sorry, that's why I asked you whether or not you'd undertaken the review of the documents. So, yeah.
Ms. Cole, we have reached the time for the afternoon break.
I think I saw it was 3:10 on the timetable that I looked at earlier.
That was for yesterday. It's 3 o'clock today. So perhaps this might be an opportune time to break. And are you able to provide an indication of how much longer you have?
Perhaps I could give you an indication when we get back from the break after I talk with my colleagues.
Yes, I was going to suggest that. We are, by my calculations, running slightly behind, about 15 minutes or so. So I'm going to also, over the break, just recalculate, at least in terms of the time estimates that we have, how much longer we've got to go and what that is going to do for the timetable. But if Council are able to confer and come up with solutions, that will be great as well.
I just confirm, sir, that in the timetable for tomorrow, we do still have Ms Marsh for questioning from both Claimant Council and from the Tribunal, most importantly, through until about 12 o'clock-ish or something like that?
Yes, at the... At the moment, it's scheduled to go until 11:15, and
11:55 according to the copy I've just been handed. Cup of tea, 10:30
yes,
till 11?
yes, sorry, 11:55, that's right. And then Ms Baker is due to give evidence. I may also assist Mr Stevens. I'm aware that the amount of questions that you have had for claimant witnesses have been often a lot shorter than the 35 minutes allocated, so perhaps if we are able to get an updated estimate from you as well, that would just assist us to manage the remaining timetable.
Of Ms.
Ms Baker.
Ms.
Yes.
Baker. Oh, yes, of course. It will be about the same amount of time that I've been taking, but I can give you an updated estimate.
Okay. Well, thank you, Council. I might also reduce the afternoon break slightly so that we can try and make up a little bit of time. So we will adjourn and we'll reconvene at 3:20.
What time do we finish?
Kia ora, sir. Just to say we've had discussions amongst council and I think the timetable is well in hand to finish at the time that we anticipated tomorrow, so we should be right on track for the times estimated for claimant council originally. Others have dropped out or given their time to Ms Cole and others to proceed, so I'd like to put your mind at rest on that issue.
Well, can you just assist then, Mr Lyle? So has there been a further update to the proposed allocation of time for questioning to the one that I've received today?
There's been an informal one, and I can make it formal while Ms Cole questions if you'd.
Okay, that's fine. We'll just keep going as we are. As long as council are coordinating between themselves, then I'm not going to get till tomorrow, and we have 5 minutes left with Ms Marsh. So I just want to ensure that we also have the time to ask the questions that we have, of course, as well as Mr Stevens in re-examination. Thank you.
Thank you. All right. Can we pick up, please, at paragraph 78 of your brief of evidence, which is on page 20. And here you're talking about the briefing paper of the 11th of April. And you say at paragraph 78, on the 11th of April, Te Arawhiti provided the Minister with a paper that sought his agreement to proposed options to restore the original intended exacting nature of the test for CMT. I'd like to explore with you, please, what you mean by exacting nature.
That my understanding is that it met all elements of the test, both limbs.
One of the big things that the Crown doesn't like about the Court of Appeal's decision, as I understand it, is essentially that the Crown thinks that in order to satisfy both limbs, there needed to be exclusive use and occupation continuously from 1840 through to the present day. Do you agree with that?
That's the literal read of that.
Well, that's interesting, because I would invite you or anyone else to show me where the word continuous appears in section 58.
It does not.
It doesn't. So the literal wording does not say continuous from 1840 through to the present day, does it?
Sorry, can you pose that again?
So the literal wording of section 58,
Yes.
as I understand, I'll just backtrack a little bit, as I understand your answer to my question as to what does exacting nature mean, your answer was it refers to the literal wording of section 58.
No, that my answer was that it met both limbs of the test.
Okay. And then I asked you about whether or not the Crown's view is that in order to meet both limbs, there needs to be a continuity of exclusive use and occupation from 1840 through to the present day. Isn't that right?
I think to your conversation on the Crown earlier, I think that that is an interpretation of the Crown.
Well, except your evidence is that the exacting nature comes from an application of both limbs of the test on a literal wording. Am I misunderstanding what you're saying?
No, possibly I'm not understanding what you're asking.
Well, let's go back a step then. In your brief of in your brief of evidence, and indeed in the briefing paper of the 11th of April, Te Arawhiti provided the Minister with a paper that sought his agreement to proposed options to restore the originally intended exacting nature of the test. This is 78 of your brief of evidence. And my question was, what do you mean by exacting nature?
And my response was that it meets both limbs of the test.
Right, and then I put to you the Crown's appeal to the Supreme Court, among other things, is premised on the proposition that then the Court of Appeal got it wrong because there needs to be a continuity of exclusive use and occupation from 1840 through to the present day. And you agreed with that?
From 1840 to the present day.
Yeah, so unbroken.
That is what the Act says.
Well, that's, and then I put to you, where in section 58 does it say that? Where does it say, where is the use of the word continuous?
I never included the word of continuous. I said from the present, from 1840 to the present day.
So do you accept that the Crown's position is that the Court of Appeal have got it wrong, and that's why they're wanting to make these amendments to the Act? And they got it wrong to the extent that on a literal wording of section 58, there needs to have been continuous, unbroken connection by the applicant party to the Rohi Moana CMCA from 1840 through to the present day.
I accept that the Crown's interpretation, from my understanding, is that the interpretation of the Court of Appeal went beyond what was originally intended by the Act.
I just need to go back a little bit. Paragraph 72, back on a page back. Paragraph 72, you're talking about, this is the 14th of the 14th of March briefing. This is the common bundle at page 31. It's paragraph 21 of the briefing. The second half of your paragraph 72 in your brief of evidence says, and again it's taken straight from the briefing paper, the rights available for CMT holders went beyond these avenues for involvement, and it was clear that Parliament intended for this additional set of rights to be available to a more limited number of groups with strong customary connections to the marine and coastal area. Wanting to pick up on those three words, strong customary connections. What do you mean by that? What do you mean by strong customary connections?
With regards to the Act, it would be use and occupation from 1840 to present day without substantial interruption, exclusive use. There are unrecognised at home. There are existing customary rights. This is about having those legally recognised. It does not take away the customary rights that exist. It does not, for mine anyway, ignore the inherent connection that people like we have heard in the court during these proceedings have with their takutai moana. And I'm reminded of that.
Tēnā koe. Having regard to your response just now, you would agree, I think, that determining strong customary connections, as that appears in your briefing paper and your evidence, is a matter of tikanga?
Traditionally, I think, yes, it's a matter of tikanga.
And when you and your team did your review of the historical materials to look at what Parliament's original intent, did you find documentation that explained why it was that in the MACA Act, Section 58 is extrinsically attached to tikanga in other parts of the Act. So, for example, the preamble and the purpose.
I haven't cited that, but we could provide that for you if it exists.
Yeah, okay, so the first part of the question, I suppose, is was it looked for? Second part would be was it found? Third part would be was it taken into account in the advice that was provided to the minister?
I can't answer that.
Yeah. Oh, paragraph 86. This is where you're talking about the first draft of the Cabinet paper on the 18th of April. And at the top of page 23 of your brief of evidence, you note that the aid memoir was returned to Te Arawhiti unsigned, but the minister discussed the contents of it with officials on the 22nd of April. You went to that meeting on the 22nd of April? That was a question as opposed to a statement.
Yeah. Can't 100% confirm, but more than likely I was at that meeting. I've been at the majority of the meetings.
Okay, so given that in your evidence you note that it came back unsigned, but then it was discussed at the meeting, can you give us an indication of what was discussed with the officials by the minister on at that meeting, or is that too hard?
Sorry, can you point me to the...
So we're looking at the top of, bottom of page 22, top of page 23. So you're talking about the aid memoir of the 18th of April. You get the AEM back from the minister unsigned, but 4 days later you go and have a meeting with him. And you say the minister discussed the contents of it with officials on the 22nd of April.
Okay. We're talking about this.
Oh.
No.
So is the information redacted?
No, I'm just confused about what paragraph.
Yeah, sorry. I'll just take a moment. And your question is?
Can you tell us what the essence of the discussion was that you had with the minister? I asked the question because your brief of evidence doesn't talk about it, doesn't tell us.
So this was unsigned. Where are we at in the process? Previous filing or review. Sorry, I can't recall exactly what was provided or what was discussed at that meeting.
Do you, seeing as this was the first draft of the CAB paper, do you have a recollection that you went along to the meeting with the minister and basically he said, I don't like it, go away, try again? Or was it not like that?
No, it would be around clarifying matters that arise that he's not clear on, or as you've seen as the policy developed, thinking around matters like retrospectivity and other matters.
So maybe at the, no, we're speculating, so there's no point.
Yeah, I can't confirm what
No,
was.
fair enough. As you said, you go to a lot of meetings. And that's why I also asked about whether or not you keep notes of your meetings. Paragraph 88, just want to ask you about timetabling. So fourth line down in paragraph 88, if you've got to that, paragraph 88 of your brief.
Yeah.
And it says, after discussions with the minister, so since the minister's agreement, officials advised that the paper was timetabled to be lodged with Cabinet Office on the 16th of May, etc. After discussions with the Minister, he questioned whether the timetables suggested were ambitious enough. Do you have an understanding at that point, when he asked you about whether it was ambitious enough, do you have an understanding as to the reason for his desire for haste? Did you have an
I may be wrong by now, but we are at the point where we're talking about enactment before the end of the year. And as you have experience of, meeting those timelines has some trade-offs.
Yeah. Understand that. I guess what that raises in itself is what then was the reason for even wanting to get it pushed through before the end of the year? Did you? It's not. Sorry, I'm not even really asking you what were the reasons, but did Te Arawhiti have a sense as to why this had suddenly been elevated up from Category 5 to Category 2?
The direction came, I think we've mentioned earlier, the direction came after the ministers' meetings with other ministers.
Okay, and that was despite the fact that Te Arawhiti had been giving fulsome advice about risk?
Yes.
Yep. And again, they just wanted to push on anyway?
Yes, I think the reasons for that are described in the Cabinet paper.
Can I ask you, did you or anyone from Te Arawhiti ever question the Minister about the rush?
Yes.
Can you tell us what he said?
Practical point of view, we explained several times.
But did he give you an explanation as to why there was this rush?
The Minister is of a mind to do things at pace.
Despite advice?
I think there's times where you've seen and noted where he sought clarification. So it's not full steam ahead without.
So do you think that advice was given by Te Arawhiti against rushing the process?
Yes.
And the Minister chose...
We offered up, as we always do, options in terms of the timelines for the process.
Okay. And he chose, notwithstanding that advice, to continue on?
To continue on. As I said, there are trade-offs. So one of them, I think, was 1 week's consultation with other ministerial colleagues.
Yeah. And one of them was breaching Te Tiriti, wasn't it? A trade-off by rushing this through.
No, I can't answer that.
Paragraph 91, again, this is a question about language. This is taken from I'm looking at the footnote of your memorandum, the 18 April paper. The paper set out the Minister's concerns that recognition of CMT over a larger amount of the marine and coastal area than previously anticipated would challenge New Zealanders' expectations. And you know what the question's going to be. Can you tell us how you determined what New Zealanders' expectations about the Act were?
Those are the Minister's concerns.
So he's fed that to Te Arawhiti and you have incorporated that into the paper?
Into the draft Cabinet paper, which we pen on his behalf.
Yes. So I presume that your answer would be the same in relation to the language of what are the quote, legitimate interests of all New Zealanders? That's the matter that came from the Minister?
Sorry, which paragraph are you?
See, it's the same paragraph. So would challenge New Zealanders' expectations that the Act establishes and maintains a durable scheme to ensure the protection of the legitimate interests of all New Zealanders. And so my question, of course, was going to be, how did you determine what the legitimate interests of all New Zealanders?
The paragraph reflects the Minister's concerns.
Okay. Did Te Arawhiti ever give advice to the Minister challenging his understandings or beliefs as to what New Zealanders' expectations are?
What we provided him with advice on was how the amendments would be viewed by those affected by them.
So do I take that as a no? We didn't give advice to the Minister as to what New Zealanders' expectations in relation to the marine and coastal area legislation are?
No, we did not.
Okay. And likewise, Te Arawhiti did not give advice to the Minister as to what New Zealanders' legitimate interests in the marine and coastal area are?
Not to my knowledge.
Thank you. Te Arawhiti were very clear, I'm looking at paragraph 102 of your brief of evidence here, were very clear in the draft cabinet paper mentioning that one of the risks of amending section 58 was that it was likely to attract criticism, and I quote, possibly akin to the controversy associated with the enactment of the 2004 Act. You see that at paragraph 102 of your brief? So you gave the Minister advice that that was a likely risk?
We did.
You agree that it remains a likely risk?
That's up to Māori, but yes, it's a likely risk.
And you're here representing the Crown. Is the Crown, by charging ahead with these amendments, wanting to cause that level of controversy?
I can answer that.
Can you answer what the Crown's response will be if there is a similar level of controversy?
No, I can't.
Has Te Arawhiti, given you are Te Arawhiti, given any consideration to, I mean, when I say that, I mean, given what Te Arawhiti is a government department to do, has Te Arawhiti given any consideration as to what the Crown's response should be if there is that level of controversy or reaction?
Not within my area of responsibility that I can.
Have you ever discussed it with Lil?
Sorry?
What happens if we get, hey Lil, what happens if we get the same kind of marches as we did in 2004? What are we going to do about that?
I've taken the proceedings to be about Crown's advice in the process, not my discussions with Lil.
Okay, paragraph 106. You're talking about the 27 May briefing paper. And officials, halfway down the paragraph, officials pointed out in the paper that while internal political discussion may have suggested a very stringent test was intended, the body of evidence from the parliamentary record, public statements from legislators at the time, and officials and ministers' statements to the Waitangi Tribunal during the recent Takutai Moana inquiry indicated that Parliament had a less restrictive intent. So that was the advice that was given on the 27th of May. Is that right? So yes. First point arising out of that is the body of evidence. So it's apparent from this that the body of evidence that was looked at by your team to determine Parliament's original intent was the parliamentary record, which would be Hansard, I presume, public statements from legislators at the time, which is presumably the 2011, I'm looking at Mr Lyle, press release from Minister Finlayson, and officials and ministers' statements to the recent 2660 Takutai Moana inquiry. Is that it?
That's what we state.
Right, so that's the body of evidence that was looked at.
That's the body that we state here. Okay. There may have been other documents, but I can't confirm that.
can I ask why it took until the 27th of May for that advice regarding that body of evidence suggesting that a less restrictive intent was intended to be given to the Minister? So my question is, why did it take until the 27th of May for that advice to be given to the Minister?
I think, well, my take on it is that the closer we get to the cabinet paper, the more important it becomes that we reinforce the messages given the importance of the kaupapa.
Reinforce the messages, what do you mean by that?
For example, around retrospectivity, being clear on our view, consultation consistently, and again, we are getting to the business end here. And as I said, we spent a fair bit of the time clarifying the Minister's understanding and forming our own.
I put it to you that the Minister's understanding was more important to Te Arawhiti than whatever Parliament's original intent was back in 2011, wasn't it?
That's your opinion?
No, well, I put it to you that that is the case. Do you agree or disagree?
We have the words there. However, officials pointed out in the paper that while internal political discussion may have suggested a very stringent test was intended, the body of evidence from parliamentary record, public statements from legislators at the time, and officials and ministers' statements to the Waitangi Tribunal during the recent Taku Time 1 inquiry indicated that Parliament had a less restrictive intent.
That's what you told the Minister?
Yes.
And you've told us that the reason that it took until the 27th of May for that advice to be given was because you were basically getting to the pointy end where CAB papers were going to be finalised?
Again, I point you to that, that taken out of context. There are discussions prior to this, so it's not something that's a once-off one statement.
I think it's the first time you mention it in your evidence, so...
That may well be.
So this is the 27th of May. As you're aware, the Minister and Minister Jones had a meeting with representatives of the seafood industry the week earlier on the 21st of May. And you went to that meeting?
I did.
Had you given this advice about the body of evidence indicating that Parliament had a less restrictive intent than what the Minister was intending to push through with these amendments before he went to the meeting with the seafood industry reps?
No, what we provided to the Minister was a briefing that I understand is included in the documents. The purpose of the meeting was to discuss, the seafood industry requested a meeting with the Minister. The purpose of the meeting was to discuss their concerns about the public consultation process and the Crown engagement pathway, and also the financial cost of engaging in the process in both pathways. So we provided the Minister with a briefing for that purpose and that discussion.
And the meeting file note records that basically that matter that you thought you were going to a meeting to talk about, the express purpose of the meeting was barely discussed, quote unquote. Is that right?
The file note as it's noted, was confirmed by me.
Right. So you go to a meeting with the Minister, having prepared him with some information for the purposes of him talking about what the engagement would look like for seafood industry people, parties to MACA litigation, Crown engagement, not litigation. And you get blindsided by this discussion about amendments to Section 58. Is that a fair representation?
The discussion at the meeting did not reflect our understanding of the purpose of the meeting.
Okay. And so clearly, my question from a couple of minutes ago was the Minister advised of your advice that the body of evidence indicated that Parliament had a less restrictive intent than what he was pushing for, had not been given to him prior to this meeting with the seafood industry reps.
Any comments attributed to the Minister are his.
No, I'm asking about whether or not Te Arawhiti had given advice to him prior to that meeting with the SIRS.
We provided a briefing for the purpose of the meeting.
Which did not touch on that issue.
No, because the purpose of the meeting was to discuss public consultation.
Okay. Is it fair to say, given the matters that were ultimately discussed in that meeting with the seafood industry reps on the 21st of May, that Ministers Goldsmith and Jones were working on the basis of incomplete advice on the issue of Section 58 at the time of the meeting?
Can you explain
So
the
when
question?
they go to the meeting with the SIRS, with the seafood industry reps on the 21st of May, you've given them a briefing or paper of some kind that provides them with information for the purpose of talking about engagement or involvement of seafood industry parties in Crown engagement pathway applications. Yeah?
Correct.
You have not given them a briefing paper that addresses the key point that is in the coalition agreement about the need for amending the Marine and Coastal Area Act, namely Parliament's original intent.
Because that was not the purpose of the meeting.
Yes, that's right. It was not the purpose of the meeting. And my point to you is that you didn't give them any advice about Parliament's original intent, which is now contained in your 27 May briefing, because you hadn't thought that they'd need it on the 21st of May.
We provided a briefing for the purposes of that meeting.
I understand that, and I
But
don't take
there
any
are
issue with that.
previous briefings, which we've talked through today, that talk to the intent, particularly with Minister Goldsmith, but also noting that the 14 May briefing went to a number of ministers. I think I need to check whether Minister Jones was included in that.
I don't take any issue with the fact that there had been previous briefings. This is specifically about the matter that was specifically contained in the 27 May meeting about the conclusion from the review of the body of evidence that indicated that Parliament had a less restrictive intent.
Again, we provided a briefing for the purpose of the meeting.
Very briefly in relation to the letter from the Legislative Design Advisory Committee, and I know that Mr Lyle tried to explore this earlier. That letter is dated the 10th of May, and it's at... Sorry.
Page 49.
Thank you, Mr Stevens. Page 49. Okay. I don't need you to necessarily go to the letter. It is obvious from the document that the letter was sent directly to Te Arawhiti. It was sent to Matthew Andrews and to Tessa Buchanan. Yeah. And Tessa Buchanan is a senior official within Te Arawhiti.
Was.
Been there for 1,000 years. When that information was received by Te Arawhiti from the Legislative Design Advisory Committee, was the advice from LDAC provided to the Minister, to your knowledge?
To my knowledge, yes.
Would that have happened before the hui with the seafood industry representatives 11 days later on the 21st of May?
I can't recall.
can you recall whether Te Arawhiti has taken any of the content of the LDAC letter, and fairness to us, we don't have a lot of it because a lot of it's redacted, but has Te Arawhiti taken anything from that LDAC letter to influence the drafting or preparation of information provided to the Minister?
Under legal.
Do you want me to ask the question again?
So the question is whether the LDAC letter has gone to the Minister?
Yes, or the content of it has been used in any way to inform any of the advice that Te Arawhiti have given to the Minister.
So there's, as we know, there's two aspects to the letter. One is privileged.
Yep.
And then
I'm not
there's an
asking you
open
to
section.
disclose the privileged information.
Yep.
All I'm asking is whether or not the information that is contained in the LDAC letter, be it privileged or not, has that been used by Te Arawhiti to inform the advice it's given to the Minister?
Yeah, we should answer that question
All
to the extent we can.
Advice that we receive is considered. The Minister was informed of this.
Was informed of the LDAC advice?
Yes,
Okay.
to my knowledge.
Okay. There was communications information prepared by Te Arawhiti in anticipation of the release of the proposed amendments.
Sorry.
So Te Arawhiti prepared some, well, for example, the press release that went out, or the pānui, I should say, that went out. Te Arawhiti prepared those. Was any of the information, to your recollection, that was provided by, or information and advice, that was provided by the Legislative Design Advisory Committee used to influence the drafting of that communications information?
Not to my knowledge.
Okay. Paragraph 107, you talk about the specific treaty-related context of the Act. So page 107, this is on page 28 of your brief of evidence. The paragraph starts, officials also again provided the view that they did not consider there was sufficient justification for retrospective application of any new test. This was based on well-established norms and conventions around retrospectivity and the specific treaty-related context of the Act. Putting aside issues of retrospectivity, which other council will ask you about, what did you mean by the specific treaty-related context of the Act?
I'd be hazarding a guess, not a guess, but around the treaty provision, around that it's a kaupapa that has significant impact on Māori rights and interests.
Okay. So officials gave advice about that, and those are key matters that the proposed amendments that we now know about are going to address. Is that right?
Proposed amendments.
Proposed amendments, yeah. So again, I'll retract that. Paragraph 108 over the page, that's a replica again of your briefing paper of the 27th of May, paragraph 42. Excuse me. You see the last line of paragraph 108, and it's again, this is paragraph really talking about risk. Excuse me. So officials provided options analysis. We know that, your options that you set out. And it's interesting to note that this one paragraph is a single sentence. It's very difficult to break up. In the paper, officials provided an options analysis for amendments. Sorry, it's two sentences. Officials noted that notwithstanding Parliament's intent and the coalition commitment, so notwithstanding Parliament's intent, original presumably, and the coalition commitment, ministers could make decisions to advance policy changes to bring a more demanding test that would reduce the number and size of CMT, or else otherwise adjust the marine and coastal area regime to change the balance of interests between Māori customary interests and the wider interests identified in the preamble and purpose provisions, although this carried additional risk. My question is, what additional risk had been identified, and why is it not set out in the paper? So not so much in your evidence, but in the paper. So I guess two questions. Can you tell us what the additional risks were that officials were referring to, and where was the information provided to the minister of those additional risks?
Paper is... Sorry, I need the question again. Sorry.
That's okay.
Got a bit distracted.
No, that's right. So you've read the paragraph. So you're talking about the fact that you gave advice, here's our options, and one of the options is that you can make the test more demanding. And then you follow it through with saying, though this carried additional risk. Which is clearly right.
Yes.
Yep.
It clearly is right. I'm just struggling to recall the risks, and I'm looking to 27 May paper and whether it's contained in there.
So this is at paragraph 42 of that paper, 27th of May.
It's page 138 of the Common Bundle.
Thank you.
And your question is, what are the additional risks?
Yes, and were they communicated to the minister? Because they're certainly not in this paper.
Not in the redacted parts. I'd have to confirm that.
Okay.
Not that the risk would have been communicated, but what was communicated.
Because my next question was going to be, given that it's not in the paper, did the minister ever ask for elucidation as to what those additional risks might be? Did he ever ask for any more information about, well, what am I getting myself in for here?
I think he might have used a phrase like that, actually. I'm not being flippant either.
They're only human.
You know, that's our job, to provide the best information we can for decision making.
Okay, so you think that? Sorry, so you think that perhaps there was further advice given about what those additional risks might be, perhaps orally?
Yeah, I think, and throughout the process, some of those risks.
Okay, and
apply.
Ultimately, the minister has chosen to proceed, notwithstanding that advice.
As I said in the cabinet paper, he makes clear that he considered the risks, and the risk of doing nothing outweighed that.
Well, what was that risk of doing nothing? That Māori would have their customary rights and interests recognised under the existing legislation? That was a risk?
I think he outlines in the paper the thinking behind that.
I think you've mentioned 2 or 3 times now that the minister considered the risk of doing nothing outweighed all of the risks that Te Arawhiti highlighted to him in advice over this period of time. Is that right?
Not all of the risks that, as I said, there are changes at each step, and not all our advice is received and considered, but not all our advice is accepted.
Can you point to a single piece of Te Arawhiti advice on these amendments which this minister has actually accepted?
It would be a degree.
Well, give me an example of a degree of something.
where we have talked about items like retrospectivity.
But he's gone ahead with that anyway, to the most extreme.
To a degree. It's a proposal to a degree.
I don't understand that answer.
Well, your question to me was give a example of where the minister has taken our advice.
And you've used retrospectivity as
and yet we have highlighted the areas where we have different views. One of those being, not wholly different views. Original intent, the minister's understanding, the understanding that we've communicated in the paper. The retrospectivity item.
Well, has he taken any advice? Has he actually adopted any advice?
On those two items, his view has differed.
Yes, it's differed. So my question is, has the minister actually adopted any of the advice that Te Arawhiti have given him in relation to, for example, the retrospectivity issue?
He has received and considered that advice and made his decision.
So my question is, has he adopted any of the Te Arawhiti advice?
He has received and considered.
No, I'm asking you, has he adopted any of the advice? It is a simple question.
We have talked about the difference in our views.
I'm going to take that as a no, unless you can point to an example where the minister has actually adopted advice from Te Arawhiti.
I think, as I pointed out, there are some areas that we had different views on.
You've got lots of areas where you've got different views on.
There are different views on.
I totally accept that.
And so, again, he received and he considered that advice and he made his decision.
Yes, and he chose not to adopt the advice from Te Arawhiti. Isn't that right?
On certain matters.
On consultation?
On certain matters.
Well, tell me one. Tell me one where he's adopted your advice.
There is more in the cabinet paper than those matters.
Okay, I'm getting close, I hope. I want to just quickly ask you about the New Zealand Herald front page advertisement. I totally understand the Crown's position is that has got nothing to do with us because it's an private organisation, they can do whatever they want, and the New Zealand Herald can take money for doing whatever they want to put on their front page, whatever they choose. My question is, what was the reaction of Crown officials to that publication?
What, as individuals?
Well, you're Crown officials. When you walk into that office, you no longer become Tui Marsh, you become a Crown official. You bring Tui Marsh with you, but you become a Crown official. So what was the reaction of Crown officials to that advertisement on the front page of the Herald?
We have released our
No, that's not what I asked. What was the reaction
The Crown officials are individuals. What are you asking?
What was the, did you have hui within Te Arawhiti to talk about whether or not there should be a response to that advertisement?
We provided a response.
Did you have meetings within Te Arawhiti to talk about whether or not the Crown should provide a response publicly to that advertisement on the front page of the paper?
No, we had a meeting to discuss that we were going to provide a response, and that we did.
Okay, so you did have a meeting.
The response that we provided.
And who drafted the response?
The Takutai team alongside our communications person.
Okay. And we received a copy of that response under cover of a Crown memorandum this morning. You're aware of that?
No, I am now.
Okay, well, we received, Zoe was up all night preparing a Crown memorandum, which sent us all a copy of that media release, it's called. I haven't got a copy of it. Came to me while I was en route.
I thought I had a copy.
Has the tribunal been provided with it? Oh, yes, of course, because it's been filed. Actually, does that have an ROI number? Not yet, it'll come. Okay, my question really now becomes, I've canvassed the room and no one that I've spoken to had ever seen that document before. We have had somebody Google it, and you need to go into 3 or 4 different pathways within the Te Arawhiti website to find it. What did Te Arawhiti do to make that media release actually publicly out there?
As I said, we sent it directly to the Herald, News Talk, ZB, RNZ. We put it on our LinkedIn, and the feedback I had from comms yesterday is that actually there's been quite a few hits on that, and it's been shared. So maybe we've got different, and on our website.
Where are you referring to those? I haven't seen any references to those, the document being sent out to those media organisations.
That's the understanding that I got from, confirmed
Your
by our
comms people?
communications. Yeah.
Okay. So it was sent out to those media organisations. Did any of them do anything with it?
I'm unsure. I don't know.
Have you ever seen anything in the general media about that media release yourself?
So I'm just not sure what issue this goes to.
It goes to the issue
Doesn't
of the
make
Crown's...
a good news story. Sorry.
It goes to the point that was made in our opening submissions about the Crown's obligation under Te Tiriti to rectify misinformation and disinformation that causes damage to the treaty Crown-Māori relationship. And
Well, I think your response is clear, though, that the paper that they issued was their response. It seems they did that. They've taken the steps that she has confirmed and haven't done anything more. So I'm not sure if you can get much more by pursuing that further.
Well, all I'm after for the final question is the last one that I did ask, which was, did even she see it in the general media? Because we're talking about a media release that gets emailed out to various media organisations. As you just said, it's not a good news story, so they're not going to publish anything about it. So who's going to see it? What was the effect of putting out that media release? That's my point, sir.
To respond
ineffectively
to that.
But do you accept that it's an ineffective response?
Those are your words.
Well, do you agree that it was an ineffective response?
Those are your words.
I'm asking you a question. Do you agree that it was an ineffective response?
We sent out the media statement to the bodies that I have
identified.
Mm-hmm.
And you feel that...
I'm not sure what else you want me to say.
No, it's not about what I would want you to say. It is what we would expect the Crown to do as a good treaty partner. As Te Arawhiti, wouldn't you have advice about how the Crown should actually take active steps to correct the misinformation that has been put on the front page of the Herald? Maybe you should have taken out an advertisement on the front page of the Herald and printed out that media release.
And as
was that ever thought of?
We provided the media statement.
Yeah. And then let everybody else not find out about it. Okay, I'd like to ask you the same question that Mr. Stevens has asked every one of the claimant witnesses, because you are here for the Crown. If all of these groups who have had hearings but don't yet have judgments or are under appeal have to go to re-hearings, are there any measures the Crown could take to mitigate the hardship on applicants and their witnesses?
Do you mean financial?
Mr. Stevens has asked witnesses if they've got any suggestions. Does the Crown have any suggestions? How to mitigate that hardship?
I think in terms of what we've, the point of, I suppose, around asking that is we are trying to listen. It is not in my opening comments and my closing comments of my opening. We have acknowledged, I have acknowledged on behalf of Te Arawhiti the impact and our regret for that. So I think it is genuine to ask within the constraints of what we can do around what might alleviate that impact.
Can I ask you, why is the Crown putting it on the claimants to come up with ways for the Crown to mitigate the hardship that the Crown's actions are going to impose on them?
As I said, and have acknowledged the impact.
You've acknowledged the impact, and I totally respect you for that. And I do actually, on that point, want to question you. You just said that you made an acknowledgement on behalf of Te Arawhiti. And 2 hours ago, I explained how this is not an inquiry into the actions of Te Arawhiti. This is an inquiry into the acts and omissions of the Crown. You are the sole Crown witness in this inquiry. Is that acknowledgement that you've made in your evidence and then in your opening statement today on behalf of the Crown?
That evidence I provided, and I will go back to it. Sorry, excuse me.
Are you looking at your summary?
I am.
Yeah. Does the summary have an ROI just while she's looking for it? No. I just want to be really clear that please don't think that I am trying to suggest that you, as an individual, are not heartfelt in what you said before. My question, in terms of what's in that summary that you're looking at, my question is whether or not what you said is coming from the Crown.
I am the Crown witness.
So it is coming from the Crown?
I am the Crown witness.
Okay, that's good, thank you.
That's my response.
Right.
I am the Crown
So the
witness.
Crown recognised the mamae, the hurt, the trauma, the loss, and yet it is still continuing on with its proposed amendments that are going to cause all this. Is that right?
As we've discussed earlier, the risks and considerations and advice has been provided and the decision has been made. And it is an initial reminder.
Oh.
They are not final.
Yeah. So that's the premature point that I made in my opening submissions. I'd like to propose a step that the Crown could take to mitigate the hardship. How about the Crown agree, in all of those cases, to file memoranda by consent that the applicants all have unbroken connections to the Takutai Moana, which satisfy any statutory test set out in the legislation as amended, and agree to the court making consent orders on that point. How about the Crown does that?
We note your suggestion.
Yeah, well, will the Crown take that on board? Give it some
Note
real
your
consideration?
suggestion.
Will the Crown take that suggestion on board, or will they completely disregard it?
As I said, we note your suggestion.
Okay, what also about the funding? How about the Crown go back to funding applicant groups in the same way as it funds its own lawyers and not confine counsel acting for applicant groups to legal aid rates?
At this time, we are required by Cabinet to manage the financial assistance scheme within the $12 million appropriation.
Yep.
Cabinet's made it very clear that at least for the upcoming years, there will be no increase.
Yep, I appreciate that.
So
And
we need to manage within that.
And the question that the Crown have been asking of witnesses in this inquiry is what steps or measures the Crown could take to mitigate the hardship on applicants. I'm suggesting to you that a step the Crown could take would be to go back to funding applicant groups in the same way as it funds its own lawyers. And you know what? One option with that is stop paying the lawyers that for the Crown at these rates, put them on legal aid rates too. Is that an option?
I note your suggestion.
Okay, good. Okay, I'd like to just quickly ask you about the Crown chronology. So there was a general election held on the 14th of October. The result was known about a week later, give or take. The Prime Minister-elect announced that he was confident that he'd be able to form a coalition government reasonably quickly. And it took until the 24th of November, so about 6 weeks later, there were coalition discussions going on between those three parties. And on the 24th of November, the coalition agreements, plural, were made publicly known, signed off and made publicly known. In the meantime, so just to get those dates right, 14th of October, 24th of November, the Crown's appeal in Edwards was filed on the 16th of November, 8 days before the coalition agreements were signed. Who was giving instructions to Crown Law Office on behalf of the Crown in order for the Edwards appeal to be filed in that time?
I don't know the answer to that.
Do you know whether there was a caretaker government in office at the time that the appeal was filed?
I cannot recall.
Okay, so if there was an election on the 14th of October and the coalition agreements and therefore the government wasn't formed until after the, signed on the 24th of November and presumably sworn into office a day or two later, the appeal was lodged here. It wasn't the current government that was giving instructions to lodge the appeal, was it?
I can't answer that question.
Do you not know who the Attorney General was at the time that the Court of Appeal decision was appealed by the Crown?
No, I don't.
Do you remember a guy by the name of David Parker?
Yes.
Yeah, he was the Attorney General, wasn't he? And he would have been the caretaker Attorney General at the time that the appeal was filed? You don't know? Do you know anything about the responsibilities of a caretaker government in terms of doing, while they're being
decisions in general.
Yeah, so they can't take big decisions.
Right.
Yep. And they pretty much have to do whatever the incoming government's going to be their policies. That fair?
Fair.
Yep. So the appeal that was filed in the Supreme Court 8 days before the coalition agreement was signed reflected the coalition's agreement that they were going to amend Section 58. Isn't that right?
I
don't
can't.
know.
Yeah.
Okay.
Those are discussions I'm not party to.
Okay.
I wasn't party to.
Do you agree that the coalition agreement details would have been well known by the government-elect at the time of the filing of the appeal, 8 days prior to it being signed?
I don't have knowledge of that.
Okay. Are you able to confirm that the Crown is not now saying, it's going to get confusing, the decision to appeal Edwards was unrelated to the content of the coalition agreement? So is the Crown now saying that the decision to appeal Edwards was because of what was agreed in the coalition agreement, or it was completely separate?
I can't confirm that.
Okay. That's another question about the Edwards appeal, and I'm pretty sure you're not going to know the answer to that either. I think
Probably
those
not.
are my... Got anything else? Those are my questions. Thank you, sir.
Well, sir, Mr. Kahukiwa is online and he will be rejoining the Whangarei High Court MACA proceeding tomorrow, so he has 5 minutes today and we'll bump him up the order to make sure that happens with your leave.
Thank you. Mr. Kahukiwa.
Oh, and I'm grateful. Tēnā koe Ona, tēnā koe te tēpū, Kahukiwa for Waste 3380 claimant, Mr. Preti Mahanga for Te Wairiki, Ngāti Korora, Ngāti Takapari. Tēnā koe Ngāti Pro.
Me ngā puhi.
Me ngā puhi, aye. Tēnā koe, Ms. Marsh. As I said, I represent Mr. Mahanga for Te Wairiki, Ngāti Korora, Ngāti Takapari, Hapua Whangarei, Harbour and Coast. We're currently in the middle of the Stage 1B, well not middle, but we've just started the Stage 1B hearings. Now you've mentioned quite rightly that the MACA Act was enacted 13 years ago, and also that the two main events that have bearing on its interpretation
the Court of Appeals decision in Edwards, and secondly, the coalition agreement. That's the fair summary so far?
Sorry, you'll need to repeat that.
Okay, so 2011 is the MACA Act. So 13 years on, there's two events that have come up time and time again in the questioning of you that bear upon the interpretation of that Act. Firstly, the Court of Appeals decision in Edwards, October of last year, and secondly, the coalition agreement of November of last year. That be a fair summary so far?
I think so.
And but isn't there another one in that in 2014, the Waitangi Tribunal in its 1040 Stage 1 report found that the rangatira did not cede their sovereignty by te treaty. Were you aware of that finding?
I'm from the north, so yes.
So yes, and so you'd agree then, wouldn't you, that in considering te treaty, that finding is relevant to that topic of considering te treaty, isn't it?
The finding?
Yes.
The tribunal's finding.
Aye.
So, sorry, what is your question? Aroha mai.
So now, in today's terms, when we're thinking about te treaty, just in general terms, the tribunal's 1040 Stage 1 finding that the rangatira did not, by te treaty, cede their sovereignty, that's a relevant finding, isn't it, in that consideration?
I think the Crown, I can't recall the Crown. The Crown has a position on that.
I'm asking you as a policy developer.
I'm here as the Crown witness. I've been reminded.
Okay. So, and because you're from the north, you'd agree with me that he whakaputanga and te tiriti, they're significant documents to the hapu in the north in particular, aren't they?
I would.
Yeah. And so when you're in Te Arawhiti, when you're addressing hapu of the north in relation to the MACA Act, considering changes to Section 58, was there any account taken of that 1040 Stage 1 finding in the policy development and advice to ministers?
Not that I'm aware of.
No. Were you aware of any time that the minister sought advice from Te Arawhiti on the Y1040 Stage 1 finding in re-looking at the treaty clause under the MACA Act?
Not in relation to the Takutai Moana Act. Obviously, my other portfolio, treaty settlements, that is relevant to that.
But not under the MACA Act?
He has not sought under the Takutai Moana Act.
Okay. Oh, tēnā koe, Ms. Marsh, thank you for answering my questions. And I thank everyone for being bumped up the list. Kia ora. Thank you, Your Honour.
Thank you, Mr. Kahukiwa. Mr. Lau.
I understand it's Tamaki Legal. I think Mr. Naden is online in this.
Yes, I am, Your Honour, and I hope that I'm coming through loud and clear.
Yes, we can hear you, Mr. Naden.
Thank you, sir. We filed an amended cross-examination bundle and index this morning. Hopefully their documents are with the tribunal, the Crown, the witness, and other parties. Those were filed both electronically and hard copy 7 times. Sir, I've listened to the cross-examination of my learned friends, Mr. Lau and Ms. Cole. We do go into some of the areas that they have examined, but we think so in different ways. And we think we take some topics a little further here and there, but we'll see, sir, if we are looking to be repetitive. I'm sure you'll let us know, but our intention is not to be so. There are some of the questions that we had planned to ask that we will not proceed with because they've been asked. Your Honour, I understand I have 40 minutes of cross-examination time, and it might be that it's not that long. And so, tēnā koe, Ms. Marsh.
Tēnā koe.
It's good to meet with you again, and thank you for your evidence.
Hoki.
So, I was wanting to take you to some of the documents that were filed in the Stage 2 tribunal. And they relate to Crown policy development in 2009, 2010, in relation to, in particular, compensation. And hopefully you do have our amended bundle, and I'm sure that you do. So, in 2009...
We're just trying to find the document for the witness, sir.
I see, Mr. Stevens.
Can you repeat the page?
Where am I looking?
Sorry, just ask him to repeat the document that he's
Oh, can you please repeat the document you're asking for?
Oh, no, not yet.
Oh.
I have mentioned that we have an amended bundle and index. Ms. Marsh, and I'm hoping that you have that with you. I take it that's that document. So it might be that, well, there will be some documents put to you. That is certainly the case. But in 2009, Crown officials noted to Minister Finlayson that a cabinet paper at the time contained a Crown bottom line of no compensation for the loss of customary rights in the Taku Taimoana as a result of the incoming Taku Taimoana Act. Do you recall that no compensation bottom line?
Sorry, I don't.
Would you accept that there was a no compensation bottom line?
I would accept your statement that there wasn't.
We can go to documents to establish that, Ms. Marsh, but I take it you accept that there was a no compensation bottom line. Thank you.
If that's what you are confirming, yes.
Thank you.
I think it would be helpful for the witness to be taken to the document that's being referred to, rather than...
Of course, Mr. Stevens.
Yeah, thank you.
So, this is an excerpt from the Lucy Moreland brief of evidence. She filed evidence for the Crown, it's dated 25 November 2019. And it's at page 194 of the amended bundle. Do you have it there, Ms. Marsh?
I do.
And so I'd like you to take you through the relevant section of this on this page. It's at paragraph 5. It states, as it is drafted, the cabinet paper includes a bottom line of no compensation. The reason that this bottom line is included in the paper is that the Prime Minister has made statements along these lines in response to questions from the media. The Prime Minister has said publicly that it is unlikely that compensation will form any part of that review process. And as I've said, this is from a cabinet paper attached to Ms. Moulin's brief of evidence for the Crown, filed for the purpose of the Stage 2 hearing. You'd accept, wouldn't you, that the Crown had a no compensation bottom line policy for the loss or infringement of Māori customary rights in the Taku Time Moana as a result of the Taku Time Moana Act at that time, Ms. Marsh. You'd accept that?
I'd accept that that's what's stated in this paper.
So, on the 5th of October 2009, Crown officials advised Mr. Finlayson that property rights awards would be significantly diminished if the remnant bottom lines were applied, and that a common law compensation would be required. Do you accept that the Crown considered the provision of compensation for the loss and infringement of rights in the Taku Time Moana as a result of the enactment of the Taku Time Moana Act? Do you accept that there was that consideration of compensation, Ms. Marsh?
Sorry, can you refer me again to the relevant?
Yes, of course, Ms. So, if again the amended bundle at page 195, at paragraphs 39 and 40, and I'll take you and the tribunal through those paragraphs. At paragraph 39, overall, we think a property rights award is significantly diminished by accommodating public access, rights of navigation, and fishing, and existing rights. The property rights award referred to there is the C&T award, Ms. Marsh. At paragraph 40, at common law, the approach would likely be to require compensation for any diminished rights. That's the key statement that I'm asking you to take note of. That is that Crown officials were considering at this time the provision of compensation for the diminished rights of Māori in the Taku Time Moana as a result of the MACA Act. Do you accept that there was that consideration of compensation by Crown officials at this time?
I accept that that's what's included in this paper.
So the Crown came to accept that compensation was owed for the breaches of customary rights. In recompense, however, for the, and this is the Crown's term, significantly diminished property rights, the Crown would institute regulatory rights that could be attained under the new legislative regime. You're aware, aren't you, that the provision of regulatory rights is a form of Crown compensation?
I can't answer that. I don't know. I
So
can't
the
confirm or
regulatory-
not. Yeah, but yeah, sorry, just I need to take a bit out of my league, that one. Sorry.
You'll be familiar with the regulatory rights, Ms. Marsh, having worked in the
In the current
MACA
Act?
sphere.
Yeah.
Yes, they are, for instance, the RMA permission right.
Yes, I am.
Otherwise known as Section 66 to 70 of the Act. You're familiar with the conservation permission right. In
I
Section
am.
71. The right to create a planning document.
I am.
The right to participate in conservation processes. At Section 47 of the Act, Ms. Marsh, you're familiar with?
Yes.
So I'd like to take you to pages 195 and 196 of the Tamaki Legal Bundle before you. And it's paragraphs 42 and 43 that I'd like to take you through. And so this is Crown officials' advice at the time. We think a more appropriate approach than monetary compensation is to augment the diminished bundle of property rights with regulatory rights. We think that in some circumstances, regulatory rights could be considered on a par with or more valuable than some incidents of fee simple. Two examples of powerful regulatory rights are the right to veto the granting of resource consents and to be exempted from normal permitting or consent requirements. Then in paragraph 43, we also think that incorporating regulatory rights accords with the holistic approach of customary interests holders. Also, by providing regulatory rights, the award is explicitly integrated into the legislative regimes that apply in the foreshore and seabed, which ensures its functionality. And I'll leave paragraph 44 there. So, Ms. Marsh, would you accept that at paragraphs 42 and 43, what officials are talking about is the provision of regulatory rights as a form of compensation for lost customary rights in the takutai moana, and not monetary compensation? Would you accept that that is what is being said there?
Sorry, this advice is new to me and I'm trying to process it. So again, I'm going to answer that, what I have in front of me. I accept that.
Thank you, Ms. Marsh. You're aware of who Benicia Smith was in relation to the development of the Takutai Marana Act?
I understand she was involved, and I do know her. But I was not around at that time, so do not have any in-depth knowledge of the process.
I understand that to be the case, Ms. Marsh, that you were not present at this time. She was the director of the Foreshore and Seabed Unit from 2007 to 2010. And in her evidence that she gave to the Waitangi Tribunal during stage 2, she stated she was heavily involved in the Takutai Moana Act development. During tribunal questioning at the stage 2 hearing, Ms. Smith admitted that the regulatory rights were provided in lieu of financial compensation. Would you prefer that I put Ms. Smith's evidence to you, or would you accept that Ms. Smith made that compensation concession at the stage 2 hearing?
Sir, I think it would be helpful for a reference to be given to the evidence that Mr. Naden is talking about, because it's not something that Ms. Marsh is personally familiar with. If Mr. Naden wants to explore this, of course, but references would be helpful.
Of course. Sorry, in the interest of time, sir, I've seen what I might be able to get through a little more quickly with, but Ms. Marsh at page 205 of the Tamaki Legal bundle. That's a hearing transcript from the Waitangi Tribunal, where Ms. Smith is being questioned by Mr. Crosby. And I'm asking you to look at at lines 4 to 24. Mr. Crosby asked of Ms. Smith the following: you've used the term and you had quite a discussion, I think, particularly, probably, with Mr. Naden in terms of the awards concept. And as I understand it, and I just want to have it quite right in my mind, that the regulatory award aspect that you were taking into account as a counterbalance to the possibility of compensation was a mix of, and tell me if I'm missing something, the conservation rights, permission rights, the permission right, resource consent permission right, and the RMA plan, the management plan approach. And Ms. Smith, in reply, added non-nationalised minerals, taonga tūturu, and I think I'd need to go look at the papers, but I think there was about 6 or 7. So in effect, Ms. Smith agreed with the thrust of Mr. Crosby's question. And then from Mr. Crosby, okay, Ms. Smith, but maybe I've got their number wrong, but yes, those types of things as you've discussed. Mr. Crosby, and as I understand what you're saying is that because a number of those, and particularly the plan process, involved concepts that were not available to a private landholder, you say that that meant the issue of compensation was covered in that way. Well, says Ms. Smith, or offset costs, Mr. Crosby asked, and Ms. Smith answers, offset, yes. And Ms. Marsh, what's transpiring there is confirmation, if I may, by Mr. Crosby of what this regulatory rights compensation package consists of. And he goes through the types of regulatory rights that they are. And there appears to be, or there is confirmation from Ms. Smith that those regulatory rights offset the loss of customary rights. So it's established, isn't it, Ms. Marsh, that the regulatory rights are supposed to be a form of compensation for the applicant groups? You'd accept that?
I'd accept that this is a transcript of Ms. Smith's discussion there and the opinion or the kōrero of a Crown official at that time.
Saying that the purpose of the regulatory rights is compensation based. That's what she's saying, isn't it?
I'd accept that's what she was saying, if it's a
So-
transcript.
Thank you, Ms. Marsh. And turning to the present now. There's evidence, isn't there, that Minister Goldsmith is of the view that the customary rights and interests of Māori in the Takutai Moana will be heavily reduced as a result of the proposed amendments. There's information on the record in that regard, isn't there?
Can you pose that question again, please?
Yes, of course. So there's evidence on this record that Minister Goldsmith is of the view that the customary rights and interests of Māori in the Takutai Moana will be heavily reduced as a result of the proposed amendments. You'd accept that?
I don't recall those specific words being used.
So can I take you to a Te Arawhiti file note? And I understand that we can get you to tab 13 of the Crown Bundle at page 106. Paragraph 19.
Oh, well.
And there, paragraph 19, it states, the Minister for Treaty of Waitangi negotiations said that changing the Section 58 test should reduce the 100% of coastline subject to DMT to 5%. That statement represents a significant reduction in Māori rights and interests in the Takutai Moana, doesn't it, Ms. Marsh?
That statement is an accurate reflection of what the Minister said at that meeting.
Thank you. Since the new Section 58, as I call it, for when it's enacted, will result in much reduced CNT awards, there will be little to no opportunity for the applicants to exercise any regulatory rights. That's correct, isn't it?
Sorry, where are you reading from?
Oh, this is a question, Ms. Marsh. I'm not reading at the moment. So I'll put it again to you. Since the new section coming in will, and in accordance with Minister Goldsmith, substantially reduce the rights of Māori in the taku tai moana, there will be little to no opportunity for Māori applicants to exercise any of the compensatory regulatory rights. That's correct, isn't it?
The proposed amendments,
The proposed amendment will have the effect, Ms. Marsh, of reducing rights and interests, according to the Minister. And so that means the compensation that exists in the form of the regulatory rights will not be realised.
my response to
You
that
accept
is
that?
that the proposed amendments mean that all the, not using the right technical jargon, all the requirements of the Act, the two limbs of the Act are met.
Yes, and let's say that, however, there's a high threshold and small areas awarded, which is a phrase used by the Minister, then regulatory rights that would have been granted had there been a significant grant of CMT are not going to be available where there's a small award. Well, they'll be available, but not in a sufficient measure to offset the loss of customary rights in the taku tai moana as a result of the legislation.
So I think in our documents, we do state that it's it's in the opposite more. It's a case-by-case basis. If it depends, and it is a case-by-case basis based on applicants meeting both limbs of the test. More in line, as the proposal is, in line with the literal wording.
I'll leave that question there, Ms. Marsh, and move on. But on a related bent, that since the regulatory regime becomes obsolete if there are little to minimal awards of CMT, and since the customary rights remain lost or infringed as a result of the new Section 58, won't the Crown have to find some other way to compensate the claimants for their losses?
I don't quite understand your
So
point at all.
the regulatory rights were offered as compensation by the Crown. I thought we had established that, you may recall.
Yeah, the rights, to my understanding, the rights that will be afforded under for those who gain CMT have not changed.
But if the gains in CMT are to small areas or not at all, this compensation mechanism doesn't take effect at all. You understand that, Ms. Marsh?
Again, CMT under the proposal to gain CMT, the applicant will need to meet the requirements of both limbs in line with the literal wording.
So there's nothing in the unredacted discovery to show that Te Arawhiti has advised the Minister about the compensation situation that we're talking about here, is there? There's none of that kind of information.
It's not a discussion that we've had.
Your Honour, sir, I'm not clear whether it's a 5 o'clock finish. There are questions to carry on with, or we could call it there, sir, if you're of a mind.
I am here, Mr. Naden. How much longer do you estimate you have to go with your questions? If you don't have much longer, I think we should proceed and complete your questioning tonight, and then I have some questions for Mr. Lyle about tomorrow. But are you...
Yes, Your Honour. So it's about 20 minutes, I'd say.
Okay. By my calculation, you have 15 minutes left. Are you able to complete it within that time frame?
I'll do my best. And yes, sir. As a Te Arawhiti official working in the realm of the Takataima Wāna Act for some years now, you're aware, aren't you, that customary rights in the Takataima Wāna can be extinguished?
I'm aware that rights can be extinguished.
Do you know how they can be extinguished?
Not the actual process, sorry.
So it's usually by way of legislation, Ms. Marsh, and can you advise on the kind of language, if my guidance there that it's legislation, the kind of language that may be used in any extinguishing legislation? Certain words, are you aware of those words?
I am not.
So clear and plain language should be used, Ms. Marsh. And I'm going to ask anyway, are you familiar with the process known as side wind extinguishment?
I am not.
So the proposed amendment to Section 58, it will not include clear and plain language. And yet the effect of it will be to extinguish customary rights, Ms. Marsh. Can you accept that?
That's your opinion?
If there is side wind extinguishment, no, the Crown and yourselves have not talked compensation at all, have you?
It has not been, I've not been part of any conversations.
Thank you. Moving to a different topic now. And this is around the parliamentary intent, original intent. The resource consent veto right awarded to CMT holders is a concern for the Minister. That's a fair statement, isn't it?
Sorry, can you repeat that?
The resource consent veto right that CMT grantees or CMT holders can get. That right of CMT holders to veto resource consents is a concern for the Minister, isn't it?
That's a question for the Minister. He may have made statements. I don't know.
But there are statements to this effect in the discovery documents that have been provided, where, well, for instance, at the Crown Bundle, tab 13, page 106, paragraph 12. This is recording an exchange between Minister Jones and Minister Goldsmith and seafood representatives, where Mr. Jones said that he did not know about the resource consent veto and asked Minister Goldsmith to change it. And by change it, Mr. Jones means to get rid of it, doesn't he?
I don't know what Mr. Jones means.
That he'd have to change this. doesn't mean get rid of it. So at paragraph 13, just below where we've been, Minister Goldsmith said, the veto right made sense if only 1% of the coastline was going to be subject to CMT, unquote. And so this Minister Goldsmith is expressing an interest in having that veto right reduced, isn't he?
He is making a statement from the notes.
Yes, and the meaning of the statement is he is interested in reducing the effect of the resource consent veto right, isn't it?
Again, you'll have to ask Minister Goldsmith, and I accept if that's your take on it. That's your take.
So, in paragraph 10, Minister Goldsmith says, economies grow through investment. Taku Taimwana creates too much legal uncertainty. I think there he's referring to the Taku Taimwana Act. He says that, doesn't he?
He does.
And so again, the uncertainty is around aspects such as the resource consent veto. You'd accept that?
What I accept is that this is an accurate record of the meeting that was held.
So many industry stakeholders seeking resource consents in the Taku Taimwana don't want to deal with customary marine title holders in the consenting process. They don't want to have to seek their consent through applicant groups who have been successful, do they?
You would have to ask them that.
So you're working in this area of the proposed amendments, and you've been researching and reading through materials in relation to the interests and perspectives of the various parties and stakeholders involved in the process of amending the legislation. And you have not yet come across any information that would inform you that resource consent applicants are not keen on the resource consent veto that CMT grantees will get.
What I am aware of is the letter from the seafood industry, which was the purpose for, they requested the meeting with Minister Goldsmith, in that they raise and have raised with Te Arawhiti their concerns about the public consultation process and the difference between the Crown engagement pathway process and the High Court, and the cost to them of that.
So isn't a big part of the changes afoot to reduce the possible number of CMT awards to a small amount? That's right, isn't it?
Sorry, I missed the first part of your statement or question.
A big part of the changes with the proposed amendments is to reduce the possible number of CMT awards. That's right, isn't it? Or at least Minister Goldsmith has stated that that's his objective. That's right, isn't it?
What Minister Goldsmith thinks in terms of rationale for the changes is contained in the Cabinet paper.
So you are accepting that that is his view. We're talking the possible number of CMT awards being kept small, the prospect of vetoed resource consents being kept to a minimum, is what the Minister is interested in. That's right, isn't it?
As I said, the Minister's views on the rationale for change to the amendments are contained in the Cabinet paper. They are his views and his voice.
They're not your views and your voice. Is that what you're saying, Ms. Marsh?
Well, not me personally. What we have talked about today, there have been places where we have provided different, advice that was different from the minister's views. Again, that was received, considered, and ultimately not accepted.
So what you're also saying is that you maintain a different view from the minister. You maintain to this day that the TMT test was to result in small awards. That is not your view to this day.
Our
That's
view,
right,
I think, stated is that it was a less restrictive intent than is the minister's view.
And looking to reduce the size of CMT awards and expressing concern with the resource consent veto, the minister's seen here to be favouring economic and industry interests over customary interests. That's right, isn't it?
Again, the minister's views are in the cabinet paper. It's not something we've discussed.
But you'd be aware that this is where the minister's at with his thinking around economic and industry interests. You're aware of that, aren't you?
I'm aware that I confirm that the record of the meeting is an accurate record of what was said at the meeting.
And so the minister's favouring of economic and industry interests, is that, do you favour economic and industry interests over customary interests in the takutai moana, Ms. Marsh?
Do I personally? Or as the Crown?
As a Te Arawhiti official, actually.
As a Te Arawhiti official, we're interested in Māori rights and interests. And Māori have commercial, from my knowledge, have commercial, recreational, all types of interests.
So the economic and industry interests that are the concern of the minister are Māori, but they would mostly be non-Māori. And so what you're saying there, that there can be the minister favouring Māori interests, doesn't account for all of the interests of an economic and industrial nature being supported by the minister. That's right, isn't it?
No, what I'm making the point of is that Māori have multiple interests, including commercial.
Yes, no, that is not.
And not
contested.
just customary.
But the thrust of the reduction in CMT awards and their area is so that there can be a facilitation of commercial interest in the takutai moana, whether they're Māori or not.
Again, I can only take you back to the cabinet paper where the minister sets out his views on the rationale for the amendments.
Mr. Naden, I see we have reached the time limit for your cross-examination. Do you have a concluding point that you want, that you wish to make, or does that complete the questions that you had?
Just working through, sir. There's Ms. Marsh, you're aware the national government did not campaign in the previous election on amending Section 58. You're aware of that?
I am not.
So let's say that there was that campaign that did not include the proposed amendments. The people who voted in support of National cannot have voted in support of the proposed amendments. It sounds about right, doesn't
The
it?
amendment, the coalition agreement is a political compact. I don't have any other comment on it.
I'm talking a step beforehand. National did not reach out and ask its support or endorsement in relation to amending the proposed amendments. That's right, isn't it?
Oh, I can't speak on behalf of National either.
Asking if you're aware that that was not a campaign promise.
And I said I am not.
So if there is the case that National is in Parliament without having garnered the support of its voters to amend Section 58, Parliament as it stands at the moment is not representative of the will of most of the population of New Zealand, is it?
They're the duly elected government.
But National and even the coalition government cannot be saying that the people who voted for them support the amendments to Section 58. That's not available to the coalition government, is it?
Mr. Naden, Ms. Marsh has already responded that she's not aware of the campaign policies that National
Yes, sir,
used.
she did.
I'm not sure if she can answer this question either.
Thank you, sir. So I'll leave it there. Thank you, Your Honour. Thank you, Ms. Marsh.
Tēnā koe.
Thank you, Mr. Naden. And Ms. Marsh, I just want to acknowledge your mammoth effort today. Unfortunately for you, it's not over. You will need to return tomorrow. But Mr. Lyle, now I am not aware of where things are at the moment. Are we still on track compared in relation to your calculations?
We are not, sir. My suggestions would be perhaps if the tribunal was minded to start 15 minutes early, we would be able to make up some time there.
Okay.
Claimant counsel have been emailing me saying that they'll be looking overnight to make sure that there's no repetition, so we may gain some time there.
Well, I'll just raise this because you assured me after the afternoon break that counsel were conferring internally and that you weren't going to take longer than the total time projected. I'm not clear if that's still the case. Can I ask you to confer and to provide an updated cross-examination timetable in the morning so that I can see and monitor where we are at, because tomorrow is the final day and there is no further time.
Yes, I have sent an updated guesstimation through to the registrar and to my learned friend for the Crown, which shows around 100 minutes of cross-examination remaining for claimant counsel. So it's really working within that. That would only leave on, should everything else stay the same, 45 minutes for questioning from the tribunal and for re-examination. So that won't work, and we'll need to.
Okay. Well, if you can look at that overnight and provide an update in the morning, that will be helpful. Mr. Stevens, I also have a question for you, not related to the timetable, but I'm wondering if you are able, well, you may be able to provide an answer now, whether we have a more definitive date on the proposed introduction of the bill. I know so far we have been told mid-September. I'm not clear whether that means the 15th of September or whether that could be anywhere between the 12th to the 18th of September. To the extent that we can get greater clarity on that, we would certainly welcome it, because as you know, we need to try and produce a report before then, and so we would certainly invite the Crown to provide further clarification on when the bill may be introduced so that we can ensure that our report is issued before then. So can I leave that with you overnight as well?
You can. I don't know the answer to that question, but I'll take instructions and come back to you in the morning, sir.
Okay. And Mr. Lyle, so you're suggesting an 8:45 start tomorrow?
might get ourselves on the right foot for the day, sir. So yes, with apologies to everyone. Your Honour.
Okay. Well, thank you again, Ms Marsh, for the evidence you have given, and also Counsel for the questions you have put so far. We will adjourn for the day and we'll reconvene at 8:45 in the morning. And I'm just handing things over to our tohunga to close for the day.
Unuhia rā te pūtake o ngā kōrero o te wānanga, unuhia rā te hautapu o ngā riki. Whakairia e rongo ki ngā pātu o te rangi kia tiki nā tuanu e mātou i te rā āpōpō. Ko pai hua tui e rea ka whakamau kia tīnā, tīnā hui e, tā iki e.